Hi. All right. Good morning. It's
Just the,
he's nowhere on the rules on the gel card again. That's what I have met him.
okay, so you know you might need some guideline,
Oh,
guardrails.
oh, I know. I didn't know that.
Yeah,
Oh,
just be
okay.
prepared.
Good morning. It's now actually 9:03, so we're a little late. Welcome. This is the House Judiciary Committee, and we're about to begin. First, I would like to ask Representative Andrus if she would lead us in Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Representative Andrus. All right, so the first bill that we have up for hearing is House Bill 320, and I will recognize the sponsor, Representative Schmidt.
Thank you very much, Mr. Chairman. It's a pleasure to be before Judiciary. It's a rare occurrence, but always a privilege. So I will say next to nothing about the bill because I'm pleased to sponsor it on behalf of my former colleague and good friend, Representative the Honorable Neil Kirk, who has suggested it to me, and he is very knowledgeable on this subject, so I will stand in his shadow and take no questions, but I am pleased to support the bill. Thank you very much.
All right. Do we have the list? I assume Representative Kirk will be will testifying, but do we have the list of the pink cards?
It's been a while.
No, that's all right.
Good to see you, Neil.
I think it's
Yes, he's always done a voice for
Oh,
privacy.
oh, fine. Thank you so much. Very good. Oh. No, that's okay.
Good morning, Mr. Chairman, members of the committee. For the record, my name is Neil Kirk. I live in Ware. I'm a former state representative, but voluntarily retired. Mr. Chairman, with your permission, I'd like to distribute some material to committee members.
Yes, certainly. Why don't you just split it up, maybe, and give them
I have
half around each side? We'll self-distribute. Yeah.
No, sorry. This one. Mr. Chairman, members of the committee, this House Bill 320 is an important bill. It deals with free speech in the United States and in the state of New Hampshire. As we all know from recent news articles, there are allegations, and in some cases, most folks have concluded, demonstrated situations in which social media companies have censored various messages that individuals are trying to communicate on these, and, for example, on vaccines. And there's also evidence that the federal government itself, including organizations such as the FBI, involve themselves in influencing the content that, say, Twitter and other media were allowed or by themselves censored to put forward. We've all read about the Hunter Biden laptop issue and the 2020 election. This is not a partisan issue. It's true, at the moment, it seems the Republicans are accusing the Democrats of doing these things. But you and I both know that what's sauce for the goose is sauce for the gander. And so when the Republicans are in control, as they are of the House and Congress now, they will start using or thinking about using these same kinds of tactics to achieve their political ends. And it's, for me, and I hope for you, unacceptable that the private sector or the government would choose to use their mediums of communication available to all and censor them. That, to me, it attacks the basis of a democracy. If we cannot have free communication between us as individuals through Twitter or Facebook or whatever medium we're using, including the newspapers, but they're not part of this, then we all suffer, because the basis of a democracy is debate and conclusion. And there can be no debate, there can be no discussion if someone has his fingers on the scale. That's the situation now, where government is attempting to censor, and these mediums of communication are themselves attempting to censor the kind of communication that goes on between individuals. Who gets hurt from this? The people of New Hampshire get hurt, because we can't have the kind of debate we need to make reasonable decisions. Congress, as you know, is not acting. Congress is doing nothing about this. They're talking, they're investigating, but they're doing nothing to solve this on a national basis. And so, what can we do in New Hampshire, if anything? The answer is House Bill 320. Let me explain a little bit as to how this came about. A number of months ago in October, I was reading the Wall Street Journal, and there was an article in there by a Columbia law professor, Philip Hamburger, that raised this issue and proposed a solution, something I had never thought about. And that is, he suggested that if these organizations, Twitter, Facebook, and so forth, were considered common carriers, you know, like railroads are common carriers and utilities are common carriers, they could be regulated in a way that was compatible with democracy and not overly invasive, but would guarantee that viewpoint discrimination did not exist. Viewpoint is where somebody says, I'm pro-vaccine, and somebody says, I'm anti-vaccine. If you discriminate and say, no, the pro-vaccine people cannot, or the anti-vaccine people, cannot have a voice on this platform, we're going to censor their communications, that's viewpoint discrimination. So, inspired by this, by the op-ed, I wrote to Professor Hamburger and said, do you have any legislative solution for this? And he said, yes, I do, state by state regulation of these organizations as common carriers. If the federal government won't act, New Hampshire can act, Vermont can act, Maine can act. And that's what this bill is. He sent me I guess you'd call it a piece of model legislation. It was overly complex and legal, so I tried to pare it down to something at least I could understand, and hopefully all of us can understand. And that's what you have before you. Please understand that viewpoint discrimination is banned by this bill, but not content discrimination. The platform can say, we're not going to entertain any religious or any political, you name it, material on our website. But if they allow religious or political or whatever on their website, then they cannot discriminate as between those people who take one position on a religious issue and those people who take another position. That's what this bill does. It is constitutional. There are no free speech violations because, of course, the entities, Facebook or whatever it is, can voice whatever opinions they want themselves, as long as they don't do it in a way that, in effect, bans those people with a different point of view from having their perspective heard on Facebook or whatever the platform is. As you know, there's a long history of common carrier regulation in the United States, starting with, I think, the railroads. I remember when I was in high school, or maybe it was college, we were discussing this, and it seemed that the railroads had this great idea that where there were two competing lines, they would charge the farmers who wanted to get their goods to market one price that was lower than what they would charge the farmer who was only served by a single railroad line. So they were discriminating based on location. The farmers, obviously, a vast majority of people in the 1880s, were upset by this, and Congress passed legislation that, in effect, prohibited this kind of activity, this discrimination based on location for railroads. As I said, there's no First Amendment issue here. This legislation has no impact on the ability of the common carrier, in this case, let's say Facebook, from advocating its own positions on its own network. So, to whom does this apply? It applies to social media companies such as Twitter and Facebook that have at least 50 million users in any calendar month. So this only applies to very large platforms where people are using, many people are using them. It allows the companies to regulate the content, whatever they want to carry. If they want videos or no videos, whatever they want, that's up to them. It forbids discrimination on a viewpoint on any topic. And, as I said, the company can voice its own opinions. This bill also allows the companies to ban unlawful content. For example, pornography, doxing, violence, support for terrorism. Those can be banned. They can discriminate on the basis of content if the subject is unlawful. Finally, there is no conflict with Federal Section 230, which provides protection for these social media platforms against content discrimination. They cannot be sued for the content that's put up on their websites. Let's say it's vaccines or whatever it might be. They cannot be sued for anything that anybody says about that. But Section 230 has nothing to do with viewpoint discrimination, and that's where the state of New Hampshire can regulate. So, I would ask the committee to pass this bill to protect the ability of everyone in New Hampshire to express his or her opinion on social media and not be subject to censorship, and to prevent the government from influencing our ability to hear other views or to voice our own. As I said, this is very important legislation that promotes free speech, and I hope the committee will vote it out as ought to pass with whatever amendments are necessary to clarify things. Thank you, Mr. Chairman. I'd be willing to answer any questions if there are any.
Questions from members of the committee? Yes, Representative Wallace.
Thank you for taking my question. Have any other states enacted this legislation at this point?
No, as usual, New Hampshire is going to be first.
Thank you.
Other questions? Yes, Representative Greason. Yeah.
Thank you, Mr. Chair, and thank you, sir, for bringing this bill. A couple of questions. You said that this would only apply to social media platforms of 50 million users in a calendar month.
Correct.
What is to prevent them? Because that seems like an arbitrary number, although I'm sure they well exceed that. But we know that Twitter, for example, and other social media have used bots to inflate what appears to be the number of users when they are in fact phony accounts. So what is to prevent them from suppressing the user numbers in order to be able to fly under the radar of this and avoid any accountability to this?
I suppose the direct answer is nothing, but from a company point of view, that would be very undesirable in terms of advertising and other revenue. I doubt very much if the company would care so much about this that they would be willing to sacrifice millions or tens of millions of dollars in revenue to avoid this kind of regulation.
Follow up, sir?
Yes.
Thank you.
Please.
And secondly, you said that this would not prevent them from censoring such as child pornography and terrorism and stuff like that. And while that sounds good, and we certainly would want that, the problem comes into who defines what is terrorism when a parent standing up at a school board meeting is now called a domestic terrorist.
Point well taken, sir. My understanding is the law with respect to support for terrorism is a federal law. And I'm not an expert on that, and it may be that that federal law is flawed, but to the extent it's flawed, we all suffer from that generally and in this legislation. This legislation does not try to correct that issue to the extent that it exists.
Other questions for this witness? Yes, Representative Manos. Manos, I'm sorry.
Good morning. I wanted to ask you, paragraph Roman numeral 3 says some interactive computer services, and then it goes on. And is the definition of some related to the size? Is that how you're defining some?
Yes.
Thank you.
Representative Horgan, did you have a question?
Well, yes, you talking about, we're asking for about support for terrorism, but where should these services draw the line when it's, not just a parent at a school board meeting, but, perhaps a public official or another individual who actually has, power to encourage others to break the law and is using the platform to do so. So, like, would that be appropriate? Would that be appropriate to, would it still be appropriate for them to, block such an individual if they believe they're engaging in illegal activity? And I'm not naming any individual in particular, because the one I'm thinking of is someone we're not supposed to talk about. But anyway, yes. So this would not prevent him from blocking the use of their platform to encourage illegal activity, though.
No, I don't believe it would. I don't think this bill in any way changes or deals with that problem, and it is a problem. But I don't think this bill deals with it. If the problem exists, it continues to exist with this bill, and it will continue to exist if this bill is not passed. This bill does not address that issue. And it suffers, as does all legislation, from the fact that that issue is not resolved.
Other questions? Representative Smith.
Thank you, Mr. Chairman and Mr. Chairman Emeritus. In looking at this bill, I understand that we would be breaking new grounds, and we usually have no problem with that. I'm just curious about the enforcement mechanism. Are we expecting that to fall completely on the courts when a user brings a complaint, or is there another way that the user could demonstrate a complaint, and then what happens?
The provision of this bill is enforced by, the provisions of this bill are enforced by the individual who suffered an injury as a result of this. And yes, you're right, the individual under this bill would go to court and sue the social media platform for the violation. As you can see from the fiscal note, there is an indeterminate number of additional court cases as a result of this. Therefore, the fiscal note does not specify a particular number. But yes, there would be an additional burden on the courts.
Representative Andrus, did you have a question?
Thank you, Mr. Chair, and thank you for taking my question. Why is this bill limited to users of 50 million a month or more? Why aren't smaller users included?
That's a good question. When I originally drafted a version of this, I dropped the 50 million down to 1 million. And as you'll see from Professor Hamburger's letter, which each of you has a copy of, as well as the original opinion piece that I mentioned, it has to do with the nature of what a common carrier is. There are 3 points that he makes about common carriers, and one of them has to do with size and the number of people that are affected by the activity. And When I suggested 1 million, he immediately said that number is too low. That would give opponents a really good case to say that that these platforms are not common carriers. They don't affect enough people. And so it was his number that I restored in the New Hampshire version, because I want to make sure that these activities, these social media platforms, are in fact considered common carriers. And they have to serve a large number of people to be a common carrier.
Other questions? Yes, Representative Tur.
Yeah, thanks for answering questions. I guess my concern really is around the concept of common carrier at a state level. I don't know, maybe this is a multi-part question. Are there other examples of common carriers that are established at the state level and sort of within New Hampshire? Do we have any statutes that discuss what a common carrier is? And my understanding is most of them at the federal level are assigned under an oversight board or something that they are responsible to. So could you say a little bit more about what a common carrier at the state level is and how it would operate?
I think I'm on solid ground on this, but I would stand corrected if I'm not. I believe our Public Utility Commission regulates common carriers, that is to say, telephone companies, water companies, and other utilities, which basically serve a large number of people, have some sort of monopoly type power or significant market influence, and that the state of New Hampshire has determined by statute that these companies are common carriers and need to be regulated. Now, in the case of these kinds of utilities, there's a very stringent regulatory framework with a regulatory agency. In the case of this bill, the idea is to tread very lightly and not regulate them except for one thing: viewpoint discrimination.
Just a quick follow-up. So are you suggesting that this would fall under the PUC? Or
No, not at all.
You're saying it wouldn't?
It would, unless you change the bill to say that these organizations would be regulated. I'm not suggesting that. I don't think it's necessary. I think the enforcement regulation, the enforcement mechanism of an individual who's adversely affected is the right way to go. We don't need a bureaucracy to take care of this relatively small but very significant issue.
Other questions for this witness? Yes, Representative Tripp.
Thank you, Mr. Chair. Thank you for taking my question. The issue I have with this is you're treating social media as a product rather than a service. And, you know, the people that use the social media are just that. They're not customers, they're users. So it being a free service, how can they be injured?
That's a very basic question and a very important question. First, as I understand it, while it may be a free service, you have to register. You have to sign up for Facebook, for example. And once you do that, there's no product involved except what you create, the message or the pictures or whatever it is. It's a service. And the service allows you to communicate. This bill simply says that communication has to be yours only, and cannot be censored. I don't know if that's responsive, but maybe you could clarify.
That's a good answer. I'll accept it. Thank you.
Do we have other questions? Yes, Representative Oregon.
Oh, thank you. I mean, I could defer to any of the members who have already asked one. So these Facebook services like Facebook and Twitter, they're for-profit companies. Their business model is basically that they mix in, well, primarily is that they mix in some ads in with the feed of messages from other people, and the way they also want you to log on as often as possible and spend as much time reading it. So that means, first of all, they have to have obviously the advertisers don't necessarily want to be associated with, extraordinarily objectionable content, but more to the point, if you're a user, you might like to see some things you disagree with, but nobody wants to see anything that's repellent. You don't want to see too much of repellent. Like I don't want to log on to Facebook and Twitter and see only like a million
Yeah,
posts by Nazis, for
it-
example. So how do you
Representative
balance
Hori-
out
oh,
their
I'm
business
sorry, go
model
ahead.
with the interests of free speech, and of course also freedom of the press? That is also includes the authority not to use your press to print things you don't want to print. So is there like a does this you think this infringes on? Do you think this still respects their business model so they can make a profit while also maybe engaging in different practices than they have been?
Thank you for the question, Representative Horrigan. This does not affect their business model. All they need to do is continue business as usual and just make sure that they don't prevent your particular message from being heard and my particular message from being heard. They can continue to advertise and put these ads in as you've suggested. This has no impact on that whatsoever.
Other questions? Yes, Representative Kutab.
How can this be enforced where we live in the state of New Hampshire, but these other platforms are probably out of other states? I know Facebook, for example, I believe is out of California. And so I guess two-part question, how can this be enforced? And then secondly, is there any bit of apprehension that perhaps these companies will just say as part of their signing up that, hey, if you're from the state of New Hampshire, you're ineligible because we'd be the only state to be implementing something like this, so perhaps they just wouldn't want to deal with it?
I can see the headlines. Thank you for the question. I can see the headlines. Twitter bans New Hampshire. If you're trying to make money and you have a business model, that's not the headline you want to see. So while I appreciate the fact that they could do that, I doubt very much that they would. Among other things, as soon as that happens, should it happen, other states would immediately say, oh boy, we've got to join New Hampshire. This is absolutely unacceptable. And that, in fact, if they did something like that, Congress might even act. So I'm not concerned. I don't think that's an issue. I'm sorry, I forgot the rest of your question. I got so passionate about that answer.
Just how it could be enforced, only for the state of New Hampshire where these companies are doing their business out of other companies and it's not a platform that we're paying for. So how could it be enforced where they're in another state than us?
When there are customers in New Hampshire, and there are for all of these platforms, the companies are in effect doing business in New Hampshire. They have customers here. They may not have a physical presence here, as you point out, their servers may be elsewhere. And our courts will take jurisdiction of that to protect New Hampshire customers from this kind of illegal discrimination should the bill pass.
Yes, sure.
I understand that for the business people, the people that are actually paying for it, but for the people that are using it as a free platform, are they technically a customer even though they're not paying anything?
I don't know if the right word is customer, but they're certainly a user, and they have a physical presence in New Hampshire and some sort of a legal relationship with the company, because normally when you signed up, you have to agree for this huge list of things that nobody reads, but we all say, yes, we agree to your terms of service.
Other questions? Yes, Representative Perez.
Thank you for taking my question. I've been in Facebook jail many times. And if you don't know what that is, they block you for 30 days. So
That's a wonderful term. I hadn't heard it before, but I like it.
I borrowed that from someone else, so it's not original. This has been going on for a long, long time, since the beginning of this. I just wondered if there was something in particular that prompted this bill for now.
The thing that prompted me for now is the article that appeared in the Wall Street Journal. That's the immediate impetus. But for me personally, over the years, I've read about all of these kinds of activities, censoring activities that the companies are doing, or allegations. And I'm saying to myself, this is not right. We need to have a robust debate about these issues. And so I sat and stewed. Then I saw this opinion piece with a possible solution. I jumped on it, and I'm bringing it forward to the legislature. I think there's a real problem. I think this is a viable solution, and I think this is so in New Hampshire tradition that I would hope the legislature would take it up and pass it.
Other questions?
thank you
Representative
for that.
Wallace.
Yes, thank you, Mr. Chair. Thanks for taking my question. Couldn't the harvesting of personal information by the social media platforms be considered a payment as the data is quite valuable?
Yes.
Thank you.
Other questions? Representative Tur.
Yeah, I just wanted to ask about the section, and perhaps I'm not understanding it, the 359U3, where it says waiver prohibited, and it basically sounds like even if you waive your rights through, I agree, kind of click, because that's how I'm interpreting it. I wasn't sure what that does in terms of giving up sort of the contractual relationship between an organization and a user, and sort of down below, and I don't know if this section just applies to the waiver or applies to the entire law, where it says this chapter applies to a user who currently resides in the state, does business in the state, or shares or receives expression in the state. The way I would read that would be essentially everyone in the United States or maybe beyond, could fall into one of those three categories. And so if it applied to those, if it applied broadly and not just the waiver, would it be the case that someone from California, because they sent me a Facebook message once, would be someone who expressed in the state, and we could essentially become the grounds for everyone who has a grievance against Facebook?
Very good questions. Thank you for them. The waiver the language is put in for a very simple reason. As I said before, the terms of service are something nobody reads, and everybody has to sign. And we don't read it because we don't have the time to read it. And if we read it, we couldn't understand it anyway. I've tried to read those. I'm reasonably literate. I find it extremely difficult to understand them. One of the ways that companies would circumvent this law is to put a condition in the terms of service that says the user waives his right to bring a lawsuit under House Bill 320. Obviously, that would be very easy for them to do and would totally undermine this legislation. And so there's a provision that says you can't do that. And it's a pretty obvious response that a company might have, and therefore a pretty obvious response that the legislature ought to have. As far as the lawsuit is concerned, I think you have to have some nexus, some connection with New Hampshire to bring a suit in our courts. I don't see the California person having that right, but I do see the New Hampshire person having that right, somebody who is either physically here or is expressing his views in this state. You could make the argument that the California person is expressing his views in this state. If that's a concern, it can be addressed in an amendment. But I wanted to make sure that free speech was protected as widely as possible, hence that language.
Other questions for this witness? Thank you very much, Mr. Kirk, Representative Kirk. Appreciate your being here.
Thank you, Mr. Chairman, and thank you, members of the committee.
I know we have a number of other people that wish to testify in this, and I'm concerned that we have a very full docket today. So I'm going to ask if you would please, as you come to testify, to do your very best to limit your testimony to 3 minutes. I'm not going to cut somebody off in the middle of an answer or something like that, but just be sensitive to the issue of time. So next I'm going to call on Chris Marchese. Mr. Marchese, if you come up, please.
Thank you, Mr. Chairman.
Yes, and I would say if you've got printed testimony, anybody that may have printed testimony, obviously we're happy to accept that. I would again suggest that we all have the ability to read, and we will read it, so you don't need to go into detail about what you've said in your written testimony.
Thank you, Mr. Chairman, and thank you, members of the committee. My name is Chris Marchese, and I'm here today on behalf of NetChoice, a trade association based in Washington, D.C. Our members include the usual suspects like Google, Meta, etc., as well as some of the platforms that we use every day but don't necessarily think of as social media, like Pinterest, eBay, and Etsy. So I'm here today to testify against Bill 320, and the reason why is because it is unconstitutional. In fact, the state of Texas tried this exact same bill, and it is currently on appeal to the U.S. Supreme Court. In fact, tomorrow, the court is expected to rule on our cert petition. Both the state of Texas and us as the plaintiffs have agreed that the Supreme Court needs to weigh in sooner than later and clarify some of these legal issues. And my testimony, the written testimony, goes into detail about why this is an unconstitutional bill. But here I'm just going to focus on the highest level concern, which is that if you want to protect the First Amendment, you do so by preventing violations of the First Amendment, not by actually violating it yourself. And that is exactly what this bill would do, because it forces private companies. Remember, they are private. Even if they are large, they are still private companies. And the idea of forcing them to carry somebody else's speech, it should be insidious to all of us. The First Amendment doesn't just protect the right to speak, it also protects the right to remain silent. And it certainly protects the right not to have to carry somebody else's message. Even in the marketplace of ideas, we can't have the government coming in and saying, you know what, we think that all viewpoints should be heard, or else no viewpoints will be heard. And that is exactly what we heard from the sponsors of this bill. You can ban content categories, but you can't ban viewpoints. That's going to leave us with an internet with basically no content. Because at the end of the day, there is a vile viewpoint on just about everything imaginable. Somewhere in this country, there is someone with a very nasty view that wants to share it on the internet. And to be honest with you, as our lawsuits have discovered, there is very scary, vile content on the internet. It is astounding what people can come up with. And yet, this bill would say, if you want to talk about the Holocaust, then you also have to allow Holocaust denial. If you want to have an educational seminar about, Hitler, you must also allow pro-Hitler content. So this is a very practical concern. It's either we're going to have no content and therefore be safe from vile content that parents don't want their kids to see, and quite frankly, I don't think anyone in this room wants to see, or we're going to allow all viewpoints, including the viewpoints from people who perhaps are not actually on the internet, to engage in meaningful discussion. So that's point one. The second point is that this bill will have unintended consequences even if somehow it were rendered constitutional. Earlier it was mentioned that data is very important to tech companies. That is true. But this bill would actually require the collection of even more data. Think about it. In order to comply with this law, tech companies, every single website covered by it, would need to know where content is coming from. Is this user in the state of New Hampshire, or are they in California? Are they in California trying to reach people in New Hampshire? That is going to require even more data collection. And that would be sanctioned under law. It would be required by law. And then the third thing to say here is, NetChoice, we are a right-of-center trade association, and we fully agree that it is inappropriate, if not outright unconstitutional, for the federal government to be weighing in on content decisions. It is one thing for the federal government to work with platforms to remove child pornography and content harmful to children. It is quite a different thing for the federal government to be weighing in on vaccine information or misinformation, whatever you want to call it, that is inappropriate. And that is why we support a federal bill currently pending in Congress that is due for a vote, I think either next week or the week after, that would prohibit every federal bureaucrat from weighing in on content decisions. It is sponsored by Representative Jim Jordan, Kevin Comer, and Kathy McMorris Rogers. And that bill would prohibit exactly what we heard earlier about the Twitter files and, President Biden's disinformation board. So it is simply not true that this bill hasn't been tried. It's been tried in Texas, and it is currently pending before the Supreme Court. A similar version was also tried in Florida, and the 11th Circuit unanimously struck it down as unconstitutional. So to support free speech, that also means that we need to accept the fact that some private businesses will do things with their free speech that we don't like. It doesn't mean that we don't have recourse. It just means that our recourse is in the court of public opinion rather than in the courtroom. Thank you, Mr.
Thank
Chairman.
you. Questions for this witness?
Excuse me 1 second, somewhere along here, the witness's statement was presented at the top of the table and the rest of us haven't gotten it.
I am the last one, but I know.
Oh, are there more on the, there are more coming around? Oh, there are more coming around, probably.
I'm sorry, Mr. Chairman.
No problem.
Apologies, I'm not very good at counting.
Uh, Do we, I wonder if maybe we don't have enough copies?
I have a copy that I'll provide
Oh,
everybody.
oh.
I do have a copy for the record.
Okay, great.
Thank
Thank you.
you.
So, all right, we'll get that. All right, other questions for this witness? All right, I just have one question. The Fifth Circuit, that you said the case is up to the Supreme Court, did the Fifth Circuit rule in your client's favor or against you?
Against us, 2-1.
So it's, so the status of the law, so to speak, to the extent it's been decided, is you won one in the 11th Circuit and you lost one in the Fifth, and you're hoping the Supreme Court is going to go your way on the Fifth Circuit case.
Well, Mr. Chairman, out of every federal court to review our cases, every single one has been in agreement that these laws are unconstitutional, except for the Fifth Circuit. And in that instance, it was a 2-1 decision. So 2 judges thought that the Texas law was constitutional, although one said perhaps it's too soon to tell and we need more hearing or more litigation about it. And, I think given the weight of the precedents, given what has already been said in the 11th Circuit, we are confident that the Supreme Court will agree with us. And it's also worth noting that when the Fifth Circuit ruled against us, we went to the Supreme Court asking for an emergency injunction, and the court granted us that injunction. So that is kind of a preview that at least a majority of the Supreme Court thinks that this law is unconstitutional.
Other questions for this? Yes, Representative Manis.
Good morning. Do your members agree that you are common carriers?
No, we are adamant that we are not common carriers.
Representative Horrigan?
I guess, is it accurate what I said earlier, that the business model of Facebook and Twitter and these other things is basically provide people with content which they actually want to see, which may include some content that they don't agree with, but people don't want to see anything that's like totally repugnant. They don't want to see a feed full of things that they totally hate and don't want to look at and are totally repugnant to them. And also advertisers are probably want to be somewhat selective about what sort of content is appearing alongside their ads too. Is that an accurate summary of your business model of your clients?
It absolutely is. And just to give one very brief example, when HB 20 was in effect in Texas, interestingly enough, there sounds even the same, HB 20, when it was in effect in Texas, we had the massacre in Buffalo occur. And as you may recall, the murderer posted a vile manifesto on the internet explaining why he did what he did. And technically, under HB 20, our members were not legally allowed to remove that content. So even though it is a vile, violent, disgusting viewpoint, it is constitutionally protected speech. And the only reason why our members were able to remove it is because we were able to have the law enjoined, meaning not enforced. But otherwise, the manifesto, as well as the video of innocent Americans being gunned down, would have been left up on the internet, at least in the state of Texas.
Other questions?
And one specific practice I'm curious, which Twitter in particular is often being accused of shadow banning conservatives. And I've noticed even with things that I tweet, that sometimes I tweet them and only a few people see them. Is anything sinister going on, or is that because their algorithm thinks that there aren't that many people who want to listen to what I'm saying? So,
well, I'm assuming the algorithm has it wrong if you're not getting a lot of views, but I will say that I am not too familiar with how Twitter does content promotion and how it decides in what order tweets will be shown. But I know that Elon Musk would not be able to do what he's doing at Twitter today if this were law. And that's because Elon Musk has been, operating in real time to experiment with new things at Twitter. It's actually kind of interesting to see, the CEO of a social media company engaging with the public in real time on, hey, what do you guys want to see with this platform that you're using? And he goes back and forth with users. Under this bill, some of those changes would not be allowed.
Thank you very much. Any other questions? All right. Thank you very much, sir.
Thank you.
Next, we have Christopher Galleria. Am I pronouncing that correct?
Thank you, Chairman Lynn, members of the committee. I am delighted to be here for my first New Hampshire testimony of the year. I will be very brief, as I know we are running up on time. I did submit written testimony electronically. I do not have copies for the members here, but I hope that you will get it. So my name is Chris Gilrain. I represent TechNet in the Northeast. We are a trade association comprised of over 100 companies in the innovation space, including platforms that would be covered under this legislation. I'm here in opposition to HB 320 because it would completely undermine content moderation practices that keep your constituents safe online. Social media companies review millions and millions of pieces of data daily to filter and remove content that violates community standards, things that are legal and constitutional, but represent things that we don't want to see: bullying, harassment, hate speech, scams, spam, and other objectionable content. HB 320 would create a perverse incentive for companies to stop removing objectionable content in order to avoid the risk of lawsuits created by this legislation. The bill exclusively allows companies to remove content that violates federal law. As we've heard, there is a massive universe of things that we find repugnant that are nonetheless legal under federal law and would be required to be hosted on these platforms. It would present a harmful online experience and create real-world dangers for granted staters. As I read it, the bill would also circumvent parental controls, as the bill prohibits content from being received by all users. It puts New Hampshire in the position of dictating to how a private enterprise can run its business and enforces it with the blunt force of a private right of action. It would create, as Representative Smith identified, a burden on New Hampshire's courts if it were not, in fact, enjoined by a previous lawsuit, but the courts would be flooded with these kinds of lawsuits. And it does not serve to protect the free exchange of ideas, but instead would fill these pages with so much filth as to render the platforms functionally useless. I am here in the real physical public square to address my elected officials and ask them not to advance this legislation.
All right. Thank you very much. Questions for this witness? Seeing none, thank you very much, sir.
Thank you, Mr. Chair.
Next, Elaine, I know I'm going to torture this word, this name, Elaine Oyong Combs.
Alon Sean Combs. It's
Alon-
Alon, like a lawnmower.
Okay, Alon. All right.
I don't think I brought enough copies.
Good morning, Chair and other members of the committee. Thank you for having me here. My name is Alon Sean Combs. I'm a Director of State and Local Government Public Policy for Chamber of Progress, which is another technology trade association. We're a center-left leaning tech trade association. We represent like the other two Chris's, the Googles, the Facebooks of the world. And I'm here to urge your committee to oppose this bill. The other two Chris's have made a lot of the points that I would like to make, and I want to be conscious of time, so I'll keep things very short. But I'd like to make at least two quick points. First, consumers and constituents, I don't think actually want this type of bill out there. We've done a set of polling, my organization, a national poll, and we found that 67% of voters said that social media companies and online platforms should be able to block violent and offensive content. In fact, a majority of social media companies, a majority of voters want social media companies to actually do more content moderation. And this includes pluralities of Democrats, Republicans, and independents. So across the entire political spectrum, kind of the majority of constituents and voters think that there needs to be more content moderation, not less. The second point I want to make is a point that the other two Chris's have already made, in that this will result in more obscene and unsavory content on the internet. And I think it will also make spam a major problem on the internet and tie companies' hands against toxic and incendiary content. Third and finally, this law will almost certainly face and perhaps lose a court challenge under the First Amendment. And no one wants the internet to become, a cesspool of offensive content. And consumers have consistently told us through the polling that we've done that they want more content moderation, not less. So we urge you to listen to the concerns raised by voters, fellow lawmakers, and the Constitution, and reject this bill. Thank you very much.
Questions for this witness? Seeing none, thank you very much, sir.
Thank you, sir.
Next, Representative Dan Hines.
Thank you, Mr. Chair. And I will submit some written comments and documentation, so I'll make this even briefer. This is not unconstitutional. The Fifth Circuit has held so and essentially issued a stay pending appeal. The First Amendment and free speech is known as the marketplace of ideas. This applies specifically to common carriers having 50 million people. I did some recent research. Looked like Facebook has 240 million people in the U.S., representing about 70% of the population. The Texas law similarly had 50 million people. In regards to the common carrier question, the Texas bill specifically defined common carrier as a social media platform with the largest number of users or common carriers by virtue of their market dominance. I would suggest that 70% is effectively a market dominance. Commercial speech is a type of speech. It's a type of speech that is giving one of the lowest protections amongst various types of speeches. On the other hand, political speech is given typically the most protection of any speech. In regards to political speech, this is viewpoint discrimination. Courts have pretty much, possibly unanimously, or if not near unanimously, prohibited viewpoint discrimination. There's been a lot of comments talking about violent, offensive speech. Similar, this bill specifically allows Facebook and every social media organization to still prohibit all that content. If you look at page 3 of the bill, it's lines 27 through 30. This specifically allows them to block unlawful expression that harasses people, incites violence, obscene, lewd, lascivious, filthy, excessively violent, and harassing, and other behavior. So things that people don't want, and that poll that they mentioned would still be prohibited under this bill. I'll add that I have also been in Facebook jail for numerous times. Facebook shadow bans me, and what that means is they essentially limit my content to certain people. Essentially, I don't think Facebook should be the one fact-checking things. Facebook is, and others, are blocking opinions. I believe Zuckerberg at some point in front of the in front of Congress or someone told them essentially to fact check certain opinion by Facebook, and they don't want them to be legally binding. I suggest that because of their market dominance, this is a limited bill. It does not violate the Constitution and is a good thing because Facebook should not be the one deciding what is true speech and what is not.
Thank you. Questions for this witness? Seeing none, I guess in light of your last thing, I just have one question. I noted the language that you read on page 3 in subsection 2C says, and I'm quoting, any expression including obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable. So if I'm Pfizer and I think that people who have a view that different than mine about the efficacy of the vaccine? Can I say under that section, this is objectionable, and therefore Facebook or Google or whatever take it down?
I guess the court would decide who on that one. If I guess different language were proposed, I guess I don't think, because it's a difficult question. I think a judge might in Facebook at the end of the day be the one deciding that.
Other questions for this witness? Thank you very much, sir.
Thank you.
All right. Do we have any other witnesses on HB 320? All right, seeing none, I'm going to close the hearing on HB 320, and I'm going to open the hearing on HB 171. Give me just 1 second while I turn to that. And I will recognize Representative Bill Boyd, the sponsor of the bill.
Thank you, Mr. Chairman. I appreciate it, and good morning to everyone. Again, through you, Your Honor, to my esteemed colleagues of the Judiciary Committee. My name is Bill Boyd. I represent Hillsborough District 12 in the town of Merrimack, and I am presenting to you House Bill 171, which was presented to me by request by my constituent, Robert Bevel, who's sitting right behind me. The goal of 171 is to clarify language in the existing statute 507B, seeking to do two things. One, as it relates to New Hampshire case Everett versus General Electric, it's going to codify language that was used in that decision. You'll see that reflected on lines 9 through 11 of your bill. And then it seeks to redact language that was in the City of Dover decision, which you're going to see on lines 16 through 20. The purpose of these particular changes is to add clarity to the statute to better provide intent of what the statute is meaning to do as it relates to its authority. On Tuesday, a stakeholders meeting occurred, trying to gain clarity and consensus on the language in this bill. Reluctantly, neither of that occurred. Not for the want of trying. The process was certainly collegial. So we're here today with the bill as is for your review. I'll do my best to answer any questions. My knowledge is limited. I would defer to my constituent, but I'll leave it at that, Mr. Chairman. Thank you.
All right. Questions for this witness? I guess I do have one question, Mr. Boyd. It does seem like, at least from the elimination of the language that is currently in 507B2, that this would, and that language generally limits the circumstances in which liability can be predicated against a municipality to vehicle and property. This would eliminate that, which it would seem to me, at least initially, would sort of pretty significantly expand the basis of municipal liability.
That would be correct.
All right. Okay. And I take it you have no concern with doing that, or you think that's a good idea?
I don't have an opinion.
Oh, okay.
As I said at the onset, I'm presenting the bill on behalf of my constituent.
Okay.
Who's here to explain more about the reason why he chose to add and redact as it relates to the statute.
Right. Thank you.
Okay.
Any other questions for this witness? Thank you very much, Representative Ford.
Your Honor, thank you. And thank you to my colleagues.
And I'm sorry, in light of Mr. Bevel, you're the person. Okay, why don't you come up next, please? We'll hear from you next. Thank you.
Good morning, Your Honor. Judge Lynn and Chairman and the rest of the committee, thank you for hearing me again.
got a haircut since yesterday, if you don't recognize me. It's a lot lighter. Thank you. So I'll start off. My name is Bob Bevel. I live at 12 Blair Road, Merrimack, New Hampshire. I'm coming for myself, but I also work with a network of parents of special needs children. I'm not legal counsel for any of them, but they have addressed some concerns. Let me answer your question first, Judge, in that yes, that would open up the floodgates if we move the portion regarding vehicles and premises. But in my opinion, this particular spot in the statutes, in all of the statute, this is the improper place for this because it's trying to accomplish two things. One is that the statute is supposed to be protecting you, our our representatives. When you make decisions, it is in what's called a discretionary function. You're making a decision on whether the highway is built on the left side of the property or on the right side of the property. And in such, you should be protected for full immunity for making those decisions because you're making decisions in the interests of the people. However, there are state and local employees who do not make discretionary decisions. They are doing ministerial tasks, sweeping floors, filing papers, that kind of stuff, that do not fall under what the intention of this bill was. A lot of this is because was in response to a case back in the 70s where that the Supreme Court was looking at eliminating the state created and the judiciary created position of municipal liability or municipal immunity. And there are so many flavors out there. I won't get into that. I can more answer your questions, but the purpose of Merrill versus Manchester was to chop that down and to go more to what's already codified. In response to that, the legislature created 507B2, and then later on the court in the city of Dover found that to be unconstitutional and struck it down. And then again, the legislature tried to put something back in to cover things having to do with arising out of ownership, occupation, maintenance, or operation of all motor vehicles and all premises. So I will be submitting written testimony later because I just didn't have time. You can't see this here, but there are many parents that are concerned with special needs kids that are coming through. I guess I kind of dropped the ball when I was talking to the stakeholders on Tuesday in that I started off talking about it having to do with the bullying statute. That was more of as an example. Many parents have gotten very involved in their legislature and are advocating for their kids. Last year, one of the new things was to add to the bullying statute 193F a section which allows for a private right of action. If the parents see that something's not going forward, they can file a private right of action. But because under the way 507B is already written, just because you have a right to that, summary judgment is still going to go against you because in some cases the judges put together the indemnity in the first part of 507B2 with the part of 5 and say practically unless you run somebody down with a truck or something falls on them at a premise, no one has the ability to pierce municipal liability, and that's why I'm here, is to deal with that. So I looked at the definition of the methodology that was written by the committee support staff, and it's a very good definition. It's basically pointing out that this opens up the door for the ability for lawsuits against ministerial employees. That's already the case. What we're doing with this legislation is codifying what are the exact court decisions that support that. So there are several cases that are out there. For example, Everett versus General Electric, Tilton versus Doherty, Schaff versus City of Somersworth, and Hacking versus Town of Belmont. One of the best examples of this I'd like to read from Hacking versus Town of Belmont. Elevating the decisions of a referee and coaches in the course of an elementary school basketball game to the level of government planning or policy formation would indeed undermine the rule of Merrill, establishing immunity as the exception. Accordingly, we hold that the trial court did not err in denying the motion to dismiss on the grounds that the decisions of the referees and coach were not entitled to discretionary function immunity. Several times the Supreme Court has already signaled the legislature, please fix this law. It's hard to understand. We're having trouble. I presented this with Bill Boyd's help last year under House Bill 1034. Some of you may have remembered that. I see there's new members on the committee. What we're trying to do is not take away the rights of the people who are already entitled by law. What we're trying to do is eliminate the confusion for who is entitled to it. So the difference being discretionary versus immunity. The language being added, as Bill Boyd aptly said, in lines 9 through 11, come from the decision in Everett versus General Electric, and the portion from 16 versus 20 comes from the Dover decision. Thank you for your time.
Questions for this witness? Yes, Representative Alexander.
Thank you, Mr. Chair, and thank you for taking my question. My concern is on line 10, the end that says is not made in wanton or reckless manner. Wanton or reckless manner is a violation of a right of another person.
Correct.
So my question is, if a planning or zoning board makes a decision, perhaps an uneducated decision because they don't know the proper like RSA or like direction from the legislature, would that qualify as wanton or reckless manner, and then compel the person whose rights were violated to sue the town for that? Thank you.
I'll do my best. I try not to overburden people. So under Prosser, the decision under Section 132 for that is that the usual meaning of willful, wanton, or reckless is that the actor has intentionally done an act of an unreasonable character in disregard of a known or obvious risk that was so great as to make it highly probable that harm would follow. In your situation, no, that would not follow that.
Yes.
So, would you be opposed to adding intentional somewhere in here, or do you think the language is explainable itself?
I'm amenable to whatever the committee thinks. Again, what I was trying to do was that the court has signaled several times to the legislature that this needs to be fixed. And again, I'm not opposed to the language of liability protection for things on premises or vehicles. But having it included in 507B adds to the confusion, because when you read from the top down, you can naturally put them together, and that is not the purpose of this. One is about exemption from being sued by an individual for whatever job they're doing is, versus something that would be ipsa loquitur. You know, something falls off the building, or somebody slips because the floor waxes a little too much. Those are things you don't expect to happen. What's driving me for this is the parents. Parents are having their children in seclusion. They're having restraint used against them. They're being bullied. When things don't go the way of the school district in some decisions for the school, they call DCYF on parents, and they don't have any reaction. There's no teeth to protect parents when actions are happening against their kids. For the example that I found recently was that a school principal and a special ed teacher didn't like a response from a special ed kid, and they dragged the child on his back the length of 2 football fields through the halls of the school. It was captured on video. The principal tried to delete the evidence. She admitted to doing the charges, and then she was suspended. It took the school district 2 years to fire her. And in the meantime, the little boy's parents missed out on a lawsuit because of the governmental immunity that exists in Tennessee. This is a problem in many, many states, is that the liability that is meant for you as our elected officials who are doing the discretionary functions of setting policy and making decisions are being benefited by those who it's not its purpose is. So I'm also going to anticipate the question is, wasn't this going to open up the floodgate of lots of lawsuits and lots of costs? School districts already play into a primary pool with Primex. They have insurance for it. So if we're not going to be able to sue them based upon the law, why are we paying insurance anyway? And the second piece is, if it's open there, then you start to have a financial incentive like, whoa, now we've opened the floodgates. Our insurance is going to go up because now we're getting the lawsuits. Maybe we need to change our method. That accomplishes the same thing. Thank you, Your Honor.
Other questions for this witness? Seeing none, thank you very much.
Thank you very much.
Marissa Chase, from New Hampshire, I believe it's New Hampshire Association for Justice. Marissa Chase. Oh, all right, we'll pass over her and come back to her then. Mark Beaudoin. Bodwin, I'm sorry.
Thank you, Mr. Chairman, and members of the committee for allowing me to speak today. I'll try to keep this very brief, as I know you're probably already behind schedule. I represent the New Hampshire Police Association and the New Hampshire Troopers Association today as a former detective sergeant with the New Hampshire State Police. Our concern that we have with this bill is obviously that it might be overreaching, and what I mean by that is as the constituent said, opening the floodgates. I think there's potential for a lot of unintended consequences as a result of this. The other concern I also have as a taxpayer and as a property owner here in New Hampshire, if your municipal insurance rate goes up, who pays for that? That's going to be coming under my property taxes. And I don't know about the rest of you, but my property taxes are pretty high as they are right now. So that's another concern that we have. I think this could more easily be addressed if under another statute such as 193, if that's the bullying issue that he's concerned about, or issues with liability within the school system, and not having it overreaching over all public employees. So those are just some of the concerns that our associations have, and I just wanted to bring that to your attention. With that, I'm willing to take any questions you might have.
Questions for this witness? Seeing none, thank you. You know, I guess I do have, I'm sorry, Representative Smith, do you have?
I am very conscious of the time, but you said something that interested me, in that you talked about the fact that your taxes are high and you don't want them to be any higher. Are there specific expenses that you think it's appropriate that you have to pay taxes for? If not, one, to provide insurance coverage for certain categories of public employees?
No, absolutely. I think, you know, you pay taxes in order to have a government and the government to run and for services and within your town. The town that I live in, we do have great services. We have great schools. However, you know, there's that saying, you know, death by 1,000 cuts. You know, if you raise something over here and then you raise something over here, and yet in and of itself, it's not a big deal. I believe it is
understand that then. Thank you
it
very
is
much.
appropriate to have insurance, but you know, we should try to do the best that we can at mitigating the expenses.
Representative Perez.
Thank you. You said you thought it was overreaching. Can you give me an example of what you mean by why you think it might be overreaching?
Well, I think it's overreaching because this affects if the constituent is truly looking at just a school issue and school employees, I don't think it needs to apply to all employees. Also concerned with the language that's being struck, which would open up some liability when it comes to the areas that you can file a lawsuit under. You know, when you take away that particular language.
Other questions? I do have one question. I'd be interested in your, I mean, one thing that I'm not so clear that the prior witness who said that the Supreme Court, at least in recent decisions, has been saying you ought to change the law in this area. I'm not quite sure, unless they've said something very recently that I'm not aware of. But beyond that, the one thing that I think is very true, and I'm wondering what your view on this would be, the law is different, at least to some extent, of the circumstances under which the state or its employees can be held, are subject to immunity versus municipalities and municipal employees. And I'm wondering if you think it would make sense to change the law to eliminate that. So in other words, the immunity statute would apply equally to both the state and its actors, state police officers, you know, for example, the Department of Environmental Services, and to municipalities and their actors, selectmen, planning board members, local police officers.
All I can say in reference to that is the concern, specifically in law enforcement, that we have at this issue is the attack on official immunity. Right now, you have a recruitment and retention issue within law enforcement. We're having a hard time bringing in new police officers, and we're having a hard time retaining the ones that we have. I can tell you if there was something that were going to negatively affect official immunity in that respect, that would get even harder. You know, as a police officer, I was willing to put my life on the line to protect others. I'm not willing to put my family's life and their livelihood on the line for that. And so that's one of the main concerns we have as law enforcement. I don't know if that answers your question, but I think that, you know, you'd have to obviously study this and look at this in a sense that if you're going to combine the two, you don't want to have any unintended consequences that come out as a result of that. So I guess I'm not opposed to it, but I'd be very careful in how I do it.
Sure. No, I understand. Other questions for this witness? Thank you very much, sir.
Thank you. Thank you, members.
Marissa Chase from the New Hampshire Association for Justice. If you'd come up, please.
Good morning, Mr. Chair, members of the committee. I apologize. It's a Thursday at the beginning of session, so bopping around a little bit. For the record, my name is Marissa Chase. I'm the Executive Director for the New Hampshire Association for Justice, which is a euphemism for the trial lawyers. We have about 400 members statewide who practice across the board. With a small collegial bar like New Hampshire, you can imagine most law offices encompass many different practice areas. That includes personal injury, medical malpractice, family law, workers' compensation. This is kind of all to say that our members would love to be a resource. I myself am not a lawyer, so if you have a question for me that I cannot answer, I can absolutely find someone who can. So we worked on this bill a little bit last session with Mr. Attorney Bevel and Representative Boyd, and I believe our intent was aligned, but the language last session, and I apologize for not having the House bill off the top of my head, did not accomplish it. And that's all because this area of case law and the statutory framework that has been interpreted by case law is extremely confusing and complicated. We are in support of this bill today, and I passed out testimony that Attorney Megan Douglas had emailed you that kind of lays out how we got here and why. I want to note, I won't go through her testimony, as Representative Lynn said earlier. I know you all can read and can follow up with any questions you may have. The one thing I would note is that immunities are pretty much why our organization exists, to oppose them. Our belief is that the only immunity you need is to act responsibly. Lawyers, especially in this state, do not file lawsuits frivolously or without careful thought. It's a business decision for them. Lawyers take personal injury cases on contingency fee, which means they front the cost of litigation before filing a suit. I'd also note that about 99% of cases in New Hampshire settle pre-suit before a lawsuit is even filed. As I said, it's an economic decision. So unless there are damages that exist that are going to make it worth all the time and cost of litigation, a lawsuit's not going to occur. It's kind of a self-correcting problem to negate that fear that some floodgate of litigation would open. I just don't see that happening. So that's all I have to say for now. Again, if you have any questions, I will do my best to answer it. And if I don't have the answer now, I will follow up.
Questions for this witness? Thank you very much.
Thank you.
Next, I would call on Natch. I keep either your handwriting has to get better, or my ability to read has to. Natch Grays.
I'm certain it's my handwriting, Mr. Chair.
Well, I don't know. It may be my eyesight too.
It's Nate like nature, Grays like the color. I know we're a little behind, so I just want to say that I agree with everything that the Detective Sergeant set up here. We at the Municipal Association do oppose this bill. I just note that 507B has coexisted for decades with other immunities granted by the court, and the case that is supposedly being put into the statutes here is about 15 years old. And our reading of it is that essentially what this bill would do is not just add that language from that case into the statute, but it broadens the scope of municipal liability, and that could open up the gates to additional lawsuits, particularly in property and vehicle related incidents, because we're dealing with ministerial immunity here. I believe, Mr. Chair, you asked whether we thought you asked the detective sergeant whether it was true that the state and municipal immunities don't quite line up. I would agree with that. It's a very complicated issue, as we've heard from other witnesses today. We want to make sure that there's no unintentional consequences from any sort of changes, because this is a complex area of law, both because of the statutory language and because of the cases. To the extent you may have suggested that the Supreme Court, whether they've been asking that the law should be changed statutorily or not, I would say they have not been. I think the law as is appropriate. And the example we heard for the impetus for this change really comes from an example from Tennessee, if I understood correctly, about a principal and another teacher dragging a student down the hallway by their foot. To me, that certainly seems like a crime and should be referred to the criminal justice system. It would not fall in the realm of the civil justice system, which is what we're talking about here with immunities. So I'll keep my testimony short. I'm happy to answer any questions that anyone might have.
Questions for this witness?
Thank you.
All right, thank you very much. Is there anyone else here who desires to testify on HB 171? Seeing none, I will close the hearing on HB 171. And I will turn to HB 314. And I think I saw Representative Erf come in. I thought I did. I saw him come in. There he is. Representative Erf. No problem.
Am I waiting for you, or am
No,
I,
no, we're all, you're all set.
Well, my apologies. I was standing outside.
No problem.
So thank you, Mr. Chair and members of the committee. I am Representative Keith Erf, Hillsborough District 28, representing the town of Ware. I'm here presenting as sponsor of HB 314, which is the privacy bill.
And I should just note, to interrupt you for a minute, Mr. F, just
problem.
because I'm a co-sponsor on that bill, I'm going to turn the chairing the meeting for purposes of this bill over to Vice Chair Wallace.
I can still refer to him as Mr. Chair, though, correct? Okay, thank you. So I'm sure we're all familiar with the constitutional amendment the state passed in 2018 with a substantial majority that states an individual's right to live free from governmental intrusion in private or personal information is natural, essential, and inherent. This, like the Constitution, this amendment is aspirational. And I believe that I don't believe, there are two ways that we can put flesh, if you will, on this. There's the judicial approach where a court case comes up, and if it impinges on the constitutional amendment or statutory law, they'll rule in some way. The other approach, which I think is a better one, is the legislative approach, where we try to define what this aspirational statement means. So with that as some background, I'll go to the bill and try to go through it with you at a fairly high level. And before I get to the goals of the bill, I want to touch on the definitions, since they're very important to both simplifying and clarifying the underlying language of the bill. So the first definition is personal information. And this is things like your name, your address, your social security number. But more than that, it's things like what a phone company keeps in terms of records that relate to your phone calls. So they keep records for billing purposes that include who you called, how long the call lasted, and that sort of thing. So that's an example of one of the things that comes under the notion of personal information. The next definition is third-party providers of information and services. So this is basically those phone companies and others that build up databases of information that's related to their business, but that's related to their business. The third definition, and this is one we added in conjunction with the last hearing this bill had, or similar bill had last year, the notion of government entity. Previously, the bill included lists in various places related to government entities. And that was confusing to folks as, do we have the total list here? Is it there? And that sort of thing. So the government entity is basically any state or county or municipal entity and their employees. And then we'll use that term through the document. And the AG's office helped me I worked with the AG's office to help me develop that definition and usage. So the goals of the bill are twofold. The first one, and I'm going to read it, it's line 24. Except as otherwise provided in law, an individual shall have a reasonable expectation of privacy in personal information, including content and usage, given or available to third-party providers of information and services, and not available to the public. So right there you can see the use of some of those definitions so that the language of the statement is fairly simple and straightforward once you understand the definitions. And the intent of this is going back to that phone company example. Under current law and court rulings, the phone company can provide that information to law enforcement or pretty much anybody. This statement, in conjunction with the constitutional amendment, we believe, precludes that. Now, there, of course, will be exceptions to that, and I'll come to that, because obviously law enforcement, that's probably one of your questions. We'll come back to that one. But otherwise, it's a fairly straightforward statement regarding who that personal information belongs to, and it's basically the person who made the phone call or what other information is being held in databases. The second goal of the bill is to preclude governments at all levels, government entities, from maintaining databases of personal information that are not relevant to their statutory or constitutional responsibilities. So just to read that one as well, on line 24, no government entity shall acquire, collect, retain, or use any personal information of any individual residing in New Hampshire from any third-party provider. Okay. Now, obviously that would preclude the governments doing a lot of their jobs. So there need to be exceptions to, in the case of both of these goals, exceptions to them so the government can perform their jobs. And I won't go through each of the exceptions, but they continue from the rest of page 1 on down to line 20 on page 2. And these were worked out in conjunction with the state agencies and other agencies of government over the last 4 years. Most recently, so I worked with the Department of Health and Human Services, I worked with the Banking Commissioner, I worked with Fish and Game and other agencies of state government. And most recently, I worked with the Attorney General's office, who I mentioned earlier, that helped me define a government entity. And they also indicated that the inquiries by grand jury, the exception on line 20, was important as well. So we added that one in there. Another confusion that came up with the bill, as previously presented, was what are you guilty of and what are the penalties for being guilty of that? So, and again, here's where the Attorney General's office is very helpful to me in, first of all, separating those two issues and then clarifying how they're expressed. So line 21 talks about what are you guilty of? What's the infraction? And essentially, if you're a person, like me or you, it's a violation. If you're any other type of entity, it's a misdemeanor. So not particularly serious crimes, but to put some teeth into the bill itself. So there's some consequence for violating the terms of the bill. Now we get to the penalty, and this is on line 23. I'm just going to read it because it only applies to government entities. A person who suffers injury as a result of a violation of this chapter shall be entitled to damages from the government entity responsible for the violation of not less than $1,000 for each violation, and so on. So it's only penalizing government entities who know, oh, I should have added in, I was not careful to point out in line 21, any person who knowingly violates the provisions. And that's something else that the Attorney General's office pointed out needed to be in there. So if you're accidentally violating it, you're not guilty of anything. On line 26, and this goes to the business community. Previously, the bill listed out some things here, and folks said, well, I don't know what kind of, you didn't list my business. So as before, I defined government entity, the AG's office said, well, just use the term non-government entity. So that will refer to everything else, whether you're a for-profit, not-for-profit, subchapter S, subchapter C, sole proprietorship, whatever. And it states, this chapter shall not be construed to create a cause of action against a non-government entity for providing information to a government entity. So this is not intended to impact the business community other than the goal number one, which is the information about your phone calls and that sort of thing is private to you. And lastly, I'll touch on the regulation of biometric information just to tell you why that's there. When OLS reviewed this bill a few years ago, they recognized there's a relationship between this and RSA 359 N:2 Roman numeral IC. So they added that in to account for that relationship. So that's my overview of the bill. I will just point out that I did upload a more detailed, in-depth description of the underpinnings of the bill to your online web portal. Thank you, Mr. Chair.
Any questions? Representative Greason.
Thank you, Mr. Chair, and thank you, sir, for answering our questions. Just for clarity, can you define in lines 21 and 22 of page 2, any person who knowingly violates the provisions of this section shall be guilty of a violation if a natural person, or guilty of a misdemeanor if any other person? Is this a crime against Aretha Franklin, who feels like a natural woman, or what are we talking about here?
So this is a play on words. Is that kind of your question?
Yeah.
So I'm not an attorney.
Okay.
I'm a lowly software developer. But this is the legal language that I was instructed was appropriate to use. And my understanding, just my understanding, that if some attorneys speak later, perhaps they can confirm this or not. A natural person is a you or me, an actual, what I would call a person. And any other person, it would be a corporation, for instance.
Someone more important than us.
There you go, if that's how you want to refer to it.
Representative Horgan.
Well, my question is probably more appropriately directed to the chair than the clerk's office, but you did mention the online portal, and I've used it to submit stuff, but how do we retrieve that stuff? Do you have any idea how we go about actually seeing this information that you submitted through this online portal?
You're killing me. So unfortunately, I'm on the finance committee, and we don't even work through the people that I think are responsible for that.
Yeah.
I just assumed you can get access to it. If you can't, I would be happy to send it to the committee separately. You have it.
If I could just, the chair
Thank you.
can't do anything on this bill. So if I could just point out to Representative Hargan and to everybody else, new systems have glitches, both old and new. And there is an information technology office, and Representative Hargan is very familiar with that office. And if you are having problems reaching any of these sites that supposedly exist to help us, but that doesn't necessarily work that way, they should deal with information technology to help get them to where they have to be. Could I just, since I have the microphone,
Follow up.
I am, my mind is going, I have to admit that. I read this bill and I keep on thinking of situations we had before this committee last year where entities came in and wanted to use information that had been collected for a particular purpose, but use that information for another purpose. Is that covered in this, or am I being too general for you to be able to answer? Last year, there was a question having to do really with specific property boundaries. And you need them for 9/11 issues, but not for others that could violate privacy.
So I'm not familiar with the particular issue you're talking about. First of all, you're talking about government or non-government?
It was government information that other government agencies wanted to use, even though the information was available to Agency 1 for a very particular purpose.
Well, I guess my answer would be, and if it needs to be clarified, I'd leave that in your hands. But I guess my answer would be, if the other government agency needs it for a statutory or constitutional purpose, then that comes under the exceptions that are included here. That would be my contention. I'm not a lawyer.
Thank you. It was a very unfair question. I didn't mean to do it that way.
That's
Thank
okay.
you.
Representative Turer.
Yeah, thanks. Just looking at it looks like sort of the active parts of this are 507H2 1 and 2. The first one says that you should have an expectation of privacy and information held by third-party providers. The sort of active part of it says no government entity shall acquire, collect, retain. So I'm just wondering, where's the onus of this? Is it on the companies that hold the third-party information not to just turn it over to government entities, or is it on the government entities not to ask, or on the government entities to keep track of why each piece of information that they happen to have came to them and what it's there for? If that makes sense.
It makes total sense. So it's on the government entity, and if you go to page 2, line 26, this chapter shall not be construed to create a cause of action against a non-government entity for providing information to a government entity. If that answers your question about the business side of things being impacted.
Yeah, I think it does. And so the government entity then needs to maintain some sort of justification about why they, so then are they prohibited from asking for the information, or are they prohibited from, maybe related to what Representative Smith was asking, using it for some other purpose, or not knowing why they have it?
Is who prohibited from asking? The government entity?
Yes.
Yes. Yes, I mean, they need to know, and in consultation with government entities, Department of Health and Human Services, AG's office, the banking commissioner, they know what they need, what kind of data they need to fulfill their constitutional or statutory responsibilities. So they should not be asking, and they have not expressed a problem with not asking for information they don't need.
Any other questions for Representative Irf? Seeing none, thank you.
Thank you, Mr. Chair.
We now call John Williams, Esquire.
Chairman Wallace and members of the House Judiciary Committee, my name is John Williams. I am the Legislative Director for the New Hampshire Department of Health and Human Services, and it's a pleasure to come before this committee today to speak on the bill. HB 314 is a work product that Representative Irf and others have committed some time and energy. Former Representative Neil Kirk, actually, you may recall, brought similar legislation before this committee. You could look at this bill that in terms of a purpose statement, the adoption of the state of the importance of the protection of privacy and private information of individuals is extremely important, not only to our agency, but to the state. And it has been codified, or rather put into the state's constitution as it relates to personal Bill of Rights. So in an effort to creating good legislation, it is when a legislator does their homework. And I will say in this case, Representative Irf and former Representative Neil Kirk invited various state agencies into the process to work with them to ensure that it honors the commitment to protecting personal information, but at the same time allowing New Hampshire's state agencies to deliver both at a regulatory level but also an administrative level the services that benefit our state citizens. And I would say that Representative Irf has done that and accomplished it, at least to our state agency's perspective, on page 1, starting on lines 26 through 29, which sets forth the first exemption within the legislation under paragraph A. It's very clear that there's two connections here. It applies to state agencies in their regulatory and administrative functions, but then in terms of the collection, retention, and use of that, it has to be for a purpose that that state agency will undertake. And it has to be specifically for its functions, either regulatory, investigative, adjudicatory, or administrative functions. There's also a recognition here on federal preemption, which we think is also very important, and I would perhaps think that a conversation with the Department of Justice probably was had with Representative Kirk, and I'm kind of looking back for a knowing nod on why that was included. So what I would say to other entities that are out there who would like to collaborate with the bill sponsors, that they have done a really great job in making themselves very open and available to at least the various state agencies in terms of participating to ensure the balance of protection of privacy and the ability to do our job meaningfully here in the state. So I'd invite anybody who probably might be coming after me who might have different perspective than I'm articulating before this committee, that I would encourage them strongly to work with the bill sponsor. They've been open to this process throughout for the last several years, most recently in the prior bill that this committee passed out on an 18-3 vote back in 2021. It was a retained bill, eventually made its way through 2022. That was House Bill 597. We think that work product that was worked there has been carried over to this bill, and we want to thank the sponsors for bringing this important bill before you. Again, we're not taking a specific position on this bill, but as it relates to our agency, we're fine with legislation.
Any questions for this witness? Seeing none, thank you.
Thank you.
We now call Ross Connolly.
Thank you, Mr. Chairman, members of the committee, for holding this hearing today. Just for the record, my name is Ross Connolly. I'm the Deputy State Director for Americans for Prosperity here in New Hampshire. Here to voice our support for HB 314. As was mentioned by the previous speaker, this has been a bill that has been fine-tuned over a couple sessions now, and really give a lot of credit to Representative Irf and Honorable Neil Kirk for really finding a way that this bill works to protect the granted staters' right to privacy, but also that balance with how state agencies work. So in the respective time, I'll try to be brief and not repeat, but as Representative Irf mentioned, in 2018, granted staters overwhelmingly supported an amendment to our Constitution to protect privacy, specifically from government. And there's not much right now in statute backing that right up. So this bill seeks to achieve that goal of really trying to protect granted staters' right to privacy. As was mentioned, this bill does not ban the collection of data by government agencies or private entities. It simply puts in guardrails in place to ensure that those technologies are not being abused, since as we've seen over the years, especially the past few years across the world, that use of data and collection of data can be abused in enormous ways and violate individual rights. To Representative Irf's earlier point that this can be achieved through the courts or through legislation, I'll just reference that we think that legislation really needs, in this space especially, needs to be forward-thinking and responsive to constitutional changes and changes in technology. And we think this bill achieves that. We want to make sure that government can do its important job, but also respecting those individual rights. And as former or as current U.S. Supreme Court Associate Justice Alito stated in Riley versus United States in 2018. He said, in these developments, it would be very unfortunate if privacy protection in the 21st century were left primarily to the federal courts using the blunt instrument of the Fourth Amendment. Legislators elected by the people are in a better position to assess and respond to changes that have already occurred and that almost certainly will take place in the future. So for these reasons, we think that this bill and bills like it are really the best avenue to back up this right to privacy for granted staters. And we encourage the committee to move this bill out to pass. And I'd be happy to take any questions if there are any.
Any questions for the witness? Seeing none, we thank you.
Thank you very much.
We now call Christopher Gilrine.
Thank you again, members of the committee, Mr. Chair. I was informed that I may not have been close enough to the mic last time, so we'll endeavor to do better. Again, I apologize. I did rely on the online portal to submit my written testimony, but I can make sure to get that to the rest of the committee members. Again, my name is Christopher Gilrain. I represent TechNet in the Northeast. We are a trade association of companies throughout the innovation ecosystem. Privacy is of major importance to my members. We support clear statutes that allow our customers to understand their rights and our companies to establish compliance structures that make sure that they are within the bounds of the law. To that end, I appreciate the concept of putting some more statutory meat on the bone to back up the constitutional amendment to provide more information and more definition. I am here simply to express my members' concern that in their opinion, the bill's requirements are still not exclusively limited to government actors or data provided to government by third parties. Specifically, H2 Roman numeral 1, the expectation of privacy. It's a broad and subjective standard that's usually applied to the right of individuals to be protected against unreasonable search and seizure by government. It's unclear if this does in fact apply to the broader private sector, how that can be interpreted and created into a compliance structure that anticipates every individual's expectation of how their data is being used. Again, this is with the understanding that, despite the additional changes that have been made and the sponsors' clarity on this, that we do believe that Roman numeral 1 still does apply to the broader private sector. And we are concerned about how a company would come into compliance with that expectation. If that is the case, then the private right of action enforcement mechanism becomes really, really difficult. When you've got a statute that is vague and difficult to comply with, enforced via class action lawsuit, you see massive liability for New Hampshire companies. You see companies pulling back on the kinds of services that they will offer in the state in order to try and avoid those lawsuits. And ultimately, it's a payday for class action firms and very little benefit to the residents of New Hampshire. And this is not speculation. We've seen this in Illinois with the biometrics privacy statute. Small businesses facing class action lawsuits for unwitting or unknowing violations of a vaguely defined statute. Companies pulling back. In Illinois' case, it's smart home features, things that are available to the rest of the country but not Illinois, for fear of running into this statute. In New Hampshire, under this statute, I would imagine, since there is not a exemption for fraud prevention and security that we see in most omnibus privacy statutes, that you'd start to see those kinds of services being curtailed. New Hampshire has a well-earned and well-deserved reputation as a business-friendly state. There's few things that are more toxic to business than a vague statute enforced via class action lawsuit. Again, this is all predicated on our concern, again, that it is not exclusively limited to government actors and data provided to government. So we're happy to work with the sponsor and with the committee to get some more clarity on that. We want to be a resource in that regard. Thank you.
Representative Kutab.
So it sounds like in general, would it be a fair statement to say that your opposition is because you feel that there's too much third-party ambiguity, and if that were fixed in an amendment, that you wouldn't be opposing the bill?
Yeah, I think our key concern is that Roman numeral 1, the expectation of privacy, applies broadly to everybody who like all entities that handle data. So we've been involved in omnibus privacy statutes in other states, and what we seek is some clear definitions. What are the consumer's rights? What are the responsibilities of the entity that holds the data? And that way you can create a compliance structure that keeps you in compliance with the law and protects consumers. In the case of a expectation of privacy, it hinges on an individual's what they believe should be done with their data or not done, and it's hard to create a compliance structure that anticipates that.
Thank you.
Representative Alexander.
Thank you, Mr. Chair. So the words expectation of privacy literally are now in our Constitution.
Right.
So I'm confused because I'm looking on page 2, line 26, 27, action against non-government entity. It's saying, it's very clear, right, that you cannot be sued if you provide information to a government entity. So I'm really just trying to understand where is the vagueness in this bill? Yeah,
so that exemption, the way that I and people smarter than me read it, was that it applies exclusively, that exemption applies exclusively to government or to data provided by a non-government entity to a government entity. And then that is exempt from the class action, but the overall expectation of privacy is not exempt. So if a company fails to live up to an individual's expectation of how their data will be handled by a private corporation, it is our understanding that that is not exempt, at least as written right now.
Any other questions for this witness? Seeing none, we thank you.
Thank you, Mr. Chair.
We now call Rick Fabrizio.
Mr. Chairman, members of the House Judiciary Committee, I am Rick Fabrizio, Director of Communications and Public Policy for the Business Industry Association of New Hampshire. We're New Hampshire's statewide chamber of commerce and leading nonpartisan business advocate. BIA strongly opposes House Bill 314, which is essentially, if not virtually, identical to HB 597 that the Senate sent to interim study last year. The belief is that HB 314 is built on the same vague and overly broad definition of personal information and features the same troubling language regarding constitutional and statutory expectations of privacy. The ambiguous term content and usage of personal information is one of the most troubling aspects, especially as the legislation would grant a private right of action. Remaining a problem is the inclusion of third-party providers and contractors, as it appears to extend coverage to non-government entities despite the bill's intent. H.B. 314 creates a new right to an expectation of privacy for certain conduct and types of information for which there is no definition. It doesn't clearly state what constitutes a violation, nor does it provide a reasonable right to cure a violation before a cause of action is instituted. HB 314, much like last year's version, lacks expected exemptions for entities and types of information already subject to federal law and regulations. The belief is, like last year's version, this bill is too flawed to advance, and we ask that you do not move this bill forward. I'm happy to take any questions at this time.
Are there any questions for this witness? Seeing none, we thank you.
Thank you.
We now call Nate Grays.
Thank you, Mr. Chair. Nate Grace for the Municipal Association. Apologize for you having to see me so many times today. We do oppose this bill as written. We're concerned with unintended consequences that may arise from the language as it exists now, particularly within the realm of law enforcement. Obviously, businesses and law enforcement share information, and we want to make sure that any legislation that gets passed does get it right, so that we don't end up in a situation where we cannot get justice for victims. And I do want to thank Representative Irf. He has reached out. We have been talking with him. We are hopeful that we can come to an agreement on how to resolve some of the issues that we have identified. So I really do want to thank him for that. We are hopeful that we will end up coming to some sort of compromise. But as written, we do oppose this legislation. I'm happy to take any questions that you may have.
Any questions for this witness? Representative Smith.
Thank you. Representative Irf and Representative Lynn have submitted this bill to the Judiciary Committee. So it is now in our control. Would you be willing to share with us the changes that you would like this committee to make in order to get your support? Since in fact, neither, although Representative Lynn will have a vote and will be able to participate in the executive session, he cannot participate today, and Representative Irf will not have a vote.
Sure. So we were concerned. One of the concerns we had was there wasn't a definition for what is publicly available. So one of the questions that came up was there are situations where something might be behind a paywall, and therefore, if I'm a member of the public, I can go pay $14 for the information. Is the government allowed to do that? So we'd like it to be clear that that would not be a barrier to the government getting that information. And I understand that the concerns that Representative Irf would have, I don't want to speak for him, but I understand obviously his concerns are he doesn't want a company that has gathered information for a specific purpose, providing a service to an individual, to provide that to the government, because that's what he's trying to protect. So I don't have exact language available for you about how we would work that out at this moment in time, but I'd be more than happy to share that if we can work something out. Thank you.
Any other questions? Seeing none, thank you.
Thank you.
Major Joe Ebert, New Hampshire State Police.
Good morning, members of the committee, both chairmen. My name is Joseph Ebert. It's E-B-E-R-T. I'm a major with the State Police. I oversee the Investigative Services Bureau, which is your state police detectives. So I come in to testify today in agreement with the principles that this bill was submitted on. We truly do uphold the right to personal privacy. However, I would, as the prior speaker pointed out, I would call some caution to the effect that this may have on law enforcement. And as a member of law enforcement and somebody who oversees the investigation of numerous numerous horrific crimes and crimes against persons, I never want to take something away from one of the investigators that may bring justice to one of the victims. And although I don't think that's the intention of this bill, what I would say is we would be certainly agreeable to working with Representative Irf and the Honorable Neil Kirk to amend this bill. Representative Smith, you had asked specifically what would cause the prior speaker to be in support of it. I believe that we could achieve that support if there was a definition given to that line 23 on page 1 and not available to the public. We share some of the same concerns as the prior speaker. Also within line 27 of page 1, where it talks about a state regulatory or administrative agency, and we would ask your consideration of putting in a state investigatory agency. Those would be the two items that would cause us to come to a level of support for this bill, and I'm happy to answer any questions at this time that you may have.
Are there any questions? Seeing none, thank you.
Thank you very much.
And we now call the Honorable Neil Kirk.
Thank you, Mr. Chairman. Good afternoon to you and to members of the committee. For the record, I'm Neil Kirk. I live in Ware, and I was a former state legislator. As has been indicated in prior testimony, this bill has been before the legislature a number of times, and it's passed the House in various forms, and hasn't made it out of the Senate yet. The reason why it's brought back is because it's extremely important. The bill protects an individual informational privacy from government and other intrusion. It does this through this concept of expectation of privacy, which is something the court system, federal and state, has developed. And it only applies to situations where an individual is dealing with a third-party provider of goods and of information and services, not goods. So this wouldn't apply to Amazon. This wouldn't apply to Walmart, but it would apply to a streaming service or a telephone company, social media providers. The concept is, and this is the situation we're all faced with, in order to take advantage of many of these services, we give information about ourselves, and that's defined in the bill. The personal information, your name, your address, your telephone number, maybe your social security number. In some cases, it may be biometric information. And we give it to them so that they can provide us the service, the telephone service or the internet connection service, whatever it might be. And we expect them to use that information for that purpose. But it seems that they are using this information for other purposes. And government is able to access this information at the discretion of the provider, either on a simple request or even by a subpoena, which of course doesn't require the same element of proof as a warrant. A warrant requires a proof of probable cause, which is a pretty much higher standard to meet. The question, I think, because some of you are new and perhaps have not seen this bill before, the bill addresses an issue that's come before the courts, and the courts, both federal and state, are really in a state of confusion over this. In the United States, the Supreme Court has said, based on the Fourth Amendment search and seizure, that there is no expectation of privacy with respect to personal information in third-party providers of information and services. So that means that the police, if they want to go and get your telephone records, can go to the company, Verizon, and say, please give us Neil Kirk's telephone records, billing records, and whatever else they might have. Not the content of the calls, to the extent that they may have recorded them, but only the information, where the call was made, when it was made, what number it was called to, and everyone I called. That's the situation now under federal law. And the reason is that if there's no expectation of privacy, then the provisions of the Fourth Amendment against search and seizure don't apply. So the police can, or any government agency can go to these organizations and get whatever they want from them, whatever the organization is willing to give. In the case of a subpoena, the organization is required to give it. So, the Supreme Court of the United States in 2018 in the Carpenter case slightly changed its concept of expectation of privacy when it found that there was a reasonable expectation of privacy in cell tower location information. Okay, so general rule, no expectation of privacy in information you give to a third-party provider, except when it comes to cell phone or cell tower location information. So what that means is that third-party providers can do what they want with your information, sell it to information brokers, give it to a government official, etc. What about New Hampshire? Again, there's little statutory guidance. This legislature has not established a policy as to what to do with this information. And so what has the courts done? Well, the Supreme Court in State versus Goss in 2003 said, along with a minority of other states, that there was an expectation of privacy in black plastic bags containing garbage left within 3 feet of the street for collection, so that the police could not open the bag, look for its contents, and use that contents to get a warrant to search the individual's home. Okay? Pretty good if you're interested in protecting privacy. Your garbage is private. You put it out on the street, your expectation is that it goes to the dump and nobody's going to search it and use it. We all know that, of course, kids and others will sometimes go through it, but from a legal point of view, the expectation was you were disposing of this in a secure manner. Then, in 2005, in the State versus Gibitosi, the court, in an interesting decision, held that a subpoena to Verizon for telephone billing records did not create an expectation of privacy, and therefore the state could get those records without having to prove that there was probable cause for them to need them. A no warrant was necessary. Again, this is only the record of the call, not the content. That was a 2-1-1 decision. 2 judges says, yes, there's no expectation of privacy. A third judge said, yeah, I agree with them, but. And then 2 other judges said, no, there is an expectation of privacy in telephone records. The majority, in its opinion, said, quote, nothing in today's decision prevents the legislature from closely regulating subpoenas for phone records. And the concurring justice, Chief Justice Broderick at that time, said, quote, I would encourage the legislature to examine whether telephone billing records should be protected from the reach of a prosecutor's subpoena, not a warrant, a subpoena. The court has yet to consider the implications of the recent privacy constitutional amendment, Part 1, Article 2B, an individual's right to live free from government intrusion in private or personal information is natural, essential, and inherent. In effect, the court, in the absence of legislative guidance, is all over the place, both at the federal and the state level. And so, with all due respect to those who might oppose this bill, some guidance from this legislature is truly essential for the courts and for private citizens. So what does this bill do? It clarifies the constitutional amendment with a legislative determination that the third-party doctrine will not operate as an escape hatch for third parties, providers of information and services to access personal information for purposes other than providing the service promised the individual. Number 2, it provides that the police need the consent of the individual whose data is sought or a search warrant supported by probable cause in order to get that personal information. the legislature would be protecting the privacy of that information. There are exceptions in this bill. State agencies, if the information is necessary for them to fulfill their statutory responsibilities, obviously a warrant if there's probable cause, 911 calls, emergencies where there is physical danger of death or severe physical injury. If there's some other statute that happens to deal with this, or where the individual consents, but only for the purpose for which he consents, and for grand juries. And there's a provision in the bill that a violation of the bill may bring a civil action. We can always improve this legislation, and I'm sure that if it were to pass, there would be changes that would come in the future. But this represents a very solid starting point for the state of New Hampshire to protect the privacy, the informational privacy of its citizens. There is one technical correction to the bill, Mr. Chairman, that I'd like to bring to the committee's attention. Page 1, line 18, where it talks about government entity means. On line 18, after the third word, or, the word its, I-T-S, no apostrophe, should be placed, so that employee, elected official, and contractor mean employee, elected official, or contractor as part of a government entity, and not private sector. That completes my testimony, Mr. Chairman. I'd be very pleased to answer questions from committee members if there are any.
Representative Lynn.
My understanding is I'm allowed to either testify or ask questions. Since I didn't testify, I think I'm allowed to ask a question. So,
Mr. Chairman, the tradition has been that a member of the House who is a sponsor of the bill does not participate in any way in the public hearing on the bill, but may participate in every way in the committee's executive session, voting, providing amendments, and making statements.
Then I stand corrected. I thought that I had read somewhere you could do one or the other, but not both.
Any work session that
Okay. All right.
takes place,
No,
just
that-
not the public hearing.
It is so nice to hear a
stand corrected.
former Chief Justice say, "I stand corrected." You have made my day.
Are there any other questions for Representative Kirk? Seeing none, we thank you for doing what you've done over the last decade for privacy in New Hampshire.
Thank you, sir.
And with that, we'll conclude the hearing on this bill.
Okay. All right. So now we're up to, yes, so we'll open the hearing then on HB 149. Find that. All right. Sorry. No. That's that's what I kind of thought, but that's all right. Yeah.
Good morning, Mr. Chairman and my distinguished colleagues on Judiciary. It is wonderful to see you from this view. I can see everybody. It's terrific. And I am here to introduce House Bill 149 FN relative to the handling of requests made under the Right to Know law. I believe that this is the first Right to Know bill to come before this 2023 session of the Judiciary Committee. Let me assure you that there will be many more to follow. The state has tried over many years to develop a right to know system that in fact is accessible to the public, understandable to the public, that is transparent and accountable. And because it is a very difficult task, as difficult as protecting privacy, as we heard before, there are constantly needs that arise to refine and clarify the law for right to know in the state of New Hampshire. This bill comes forward not because of any idle desire to just have another right to know bill, but because over the years we see patterns and practices that might not completely reflect the underlying purpose of right to know. And one reality is, for whatever reason, legitimate or not, and there are legitimate reasons, it is not always true that a public agency responds in a timely, accurate, and thorough way to requests for information under right to know. It is a complicated business. If it weren't, we could have settled this in no time at all. Therefore, this year's contribution, at least from me, is one that says agencies experience problems in getting all the information out in a timely way. We can understand that. There are reasons, legitimate or not, but there are reasons for a delay. All that this bill does is say that if the agency has not been able to respond in a timely way, it must explain why and do that in a written report so that there is a record of why the agency had not been able to answer the request under right to know. And it also says that a 30-day limit seems to make some sense, but if you're not going to honor that 30-day limit, then you have to, the agency has to let the concerned individual know. So it's just, again, a question of fine-tuning a very complicated issue that in the end will never be able to be fine-tuned completely and thoroughly. But each time that we see a problem, we try to narrow the effects of that problem. And I therefore present House Bill 149 to you and ask that you add it to the long record of the House Judiciary Committee on trying to make sure that the citizens of this state can in fact feel comfortable knowing that right to know is alive and well in New Hampshire. Thank you very much.
Thank you, Representative Smith. Questions? Yes, Representative Greason.
Thank you, Mr. Chair, and thank you, Representative Smith, for this bill. I do have one question here at the end. You have, if statement of time exceeds 30 days, then they can request another 30 days. Would you be open to some amendment that would say, that would prevent the stonewalling of just continually asking for 30 more days? Say you've got 90 days max, you've got, no matter what, you better get your act together within 90 days or whatever, but something that just prevents the perpetual stonewalling of, we need 30 more days.
I am completely sympathetic to what you say. I understand the reality of what you say. But my purpose here is not to say my way or the highway. My purpose here is to try to move us, however slowly, towards a more perfect union. And so I would not, although I'd only have 1 out of 20 votes and when this committee considers this bill, I'm not interested in setting up boundaries that do not allow for a particular circumstance where it might in fact be legitimate for there to be a delay.
Questions? Representative Tripp.
Thank you, Mr. Chair. Thank you. Thank you for taking my question. I noticed on the towards the tail end of the change that the public body, whenever it's the 30-day time limit is exceeded, that are they required or to submit another rationale as to why they can't provide the information?
Thank you. The language on line 18 says shall provide. It does not say may provide. So they are expected to provide. And because it's written, if what they tried to, if someone in not acting in good faith just had a whole stack of forms that said, sorry, we can't comply with your request, come back to us in 30 days, it would be a very short period of time where that approach would be challenged.
Follow up, please.
Yes, please. Go ahead.
So there's no requirement on the person that asked the initial request to make another request for the 30 days.
Oh, no, I believe that the burden at this point is on the agency, not on the individual making the request.
Thank you.
Representative Perez.
Thank you. Right now, there's a 5-day business day, correct? That they have 5 days, business days to respond. My only concern about the possibility of stretching it out 30 days is, do you foresee any problem with things that really need to be obtained in a timely manner? Because if you have something that you need to receive in a timely manner for perhaps a meeting or a hearing, this really could eliminate that. So do you see any problem with that? I mean, some 91As are submitted because you find out that you need that for a particular thing that is going on, and to wait 30 or 60 days, just you've lost the ability to obtain the information you need.
Representative Perez, yes, in all of right to know requests, I see danger. I mean, if I were, a children's book author, I would have dangers of denials of or delays of right to know requests just filling the bedroom. But we're adults and we're trying to do the right thing, and we're trying to understand that sometimes there is a legitimate reason. And we hope that agencies will understand that right to know isn't going away. And we hope that individuals will understand that sometimes there is a legitimate reason for a delay, but in fact, the agency would have to write in writing why there is a delay. And in the fullness of time, this all might work.
Follow up, please.
Yes, please.
Reasonably necessary. Is there any way to tighten that up? Do you foresee any way reasonably necessary?
Well,
what would
Representative Perez, I would suggest that you go home and tonight, instead of dreaming about right to know, dream about reasonably necessary and prepare an amendment that, and we can talk for freshmen, we can explain how to get an amendment done, because that I don't think has happened yet, and we want you to understand how to do that, and bring it into the committee and say, this is my improvement on the bill, and you'd be earning your $200 that way.
Thank you. Thank you very much.
Other questions for this witness? Yeah, yes, Representative Alexander.
Thank you. This is, thank you for taking my question. So I've served with you for 4 years now on this committee, and I'm not going to speak for what the committee is going to do, but I do know in the past with right to know issues, we've kind of erred on the side of not specifying too much and not making everything so like written into the law in the effort to allow litigation to occur, so we can build up a case, maybe a case file on right to know, or allow an ombudsman to make a decision about a right to know issue. So my question to you is, do you think that this would ever or could ever be hurting kind of the efforts we've made in the past to make sure that it's broad as possible to allow for litigation if necessary?
Representative Alexander, thank you for the question. I think it's a good question. as it's likely to be good coming from you. I think of the work that our colleague Representative DiLorenzo has done on getting an ombudsman in place in issues relating to right to know. And I would be very interested in hearing either from the ombudsman or from others about whether this would, rather than try to do what we hope it will do, which is to encourage movement, that it might interfere in some way. And if so, we ought to address that.
Other questions? Seeing none? Thank you very much.
Thank you, Mr. Chair.
I'm going to next call on Giles Bissonette. And, I should note, and I'll ask Representative, just in regard to the last hearing, Representative Kutab checked the House rules, and apparently Rule 106 does say that a member that's a sponsor or a co-sponsor may either testify or ask questions, but can't do both.
Which is
So which is
We
what.
amended it in this House rules in this session. It was one of the amendments that had come up.
That was my understanding.
I mean, so no problem.
So shall we reopen the committee?
No. I'm absolutely not asking that the committee hearing be reopened. No, absolutely not. Absolutely not.
Voting on the prevail side.
No problem whatsoever. We all make mistakes, that's for sure. And I make more than my share, I'm sure. Mr. Bissonette, welcome. Thank you. Oh, microphone.
Right. Is it on now? Oh, it is. Great. It's nice to be here. Again, Gilles Bissonette, Legal Director at the ACLU of New Hampshire. I couldn't help but chuckle at that moment because, like any lawyer and judge knows, you go back to the rule book whenever questions are raised, which certainly happened in this
When
instance.
all else fails, read the law.
Read the rule. Read the
That's what we
rule.
always used to say, yeah.
I'm going to keep my testimony very brief. We support this legislation. We want to indicate our support. I do want to note that it is not uncommon for there to be delays, sometimes even significant delays, with respect to when a requester obtains a substantive response. So, a month or two can lapse, even then only to obtain a blanket denial citing an exemption. And so there can be delays in this process. But I do want to note that, frankly, in my practice, there is a tendency as a litigant that's kind of a repeat player in this space that I do tend to get periodic updates, not always, but I do. And I think why I think this bill is a good bill and why I support it is that it makes sure that everyone gets that benefit, not just lawyers like me, who routinely go to court in public records litigation. And I think it's a really important service for government agencies to provide, just to timely communicate what they're thinking, what issues may be coming up when they're responding to a request, if there are going to be delays, why they're going to be delays, how long. I think that really is a good thing, because I think the more communication that happens between government agencies and requesters, in fact, the less likely there is to be a fight or dispute down the line. The more communication that happens, the greater there is a chance that disputes can be resolved amicably without litigation. So I think this is a good bill that really fosters that level of communication and transparency. It makes sure that it's not just my office that gets that every member of the public gets that, whether they have a lawyer or not. So for those reasons, we support this bill. I do want to note, with respect to the 5-day issue that was raised, this actually doesn't change the 5-day response requirements. I just wanted to flag that. A municipality or government agency would still have to respond within 5 days. But what this bill does is just make sure thereafter, in the event that the documents aren't produced at the 5-day mark, that there are just, again, regularly check-ins with the requester about the status of the request. So with that, I'll conclude my testimony. And it's great to see familiar faces and some new ones as well in the committee. Thank you.
Thank you, Mr. Bissonette. Questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Mr. Grays.
Thank you, Mr. Chair. I do have a handout. Thank you, Mr. Chair. Nate Grace for the Municipal Association. So I do have a handout today with a proposed amendment. So I think that the sponsor raises a great question here. So under our current system, what happens if you make a right to know law request? The agency has 5 days to respond, and they either give you the information, they deny the request, or they provide a written statement saying how long they need to figure out what they're going to do. And the sponsor raises a great question of, okay, well, what happens if they provide you that written statement and it turns out that their estimate of how long they need to figure out what they're going to do is wrong? And so I really think resolving this issue makes a lot of sense. And we would propose a slightly different solution than the sponsor has put in front of you. So under the existing statute and under the bill as proposed, as I understand it, is essentially the government would respond and say, hey, we need however long it is. So for example, you make a request that you want all the emails from your town administrator for the last 6 months. Your town comes back to you and says, hey, we think that's going to take 90 days. 90 days is coming up. They realize they need a little bit more time. And we think that the appropriate response is really that the municipality should, and the people responsible for responding to that request should look at how long it's realistically going to take and give you that update along with an update of, well, what have we done so far? So you know that they're not just sitting on it. You know that they're working towards responding to your request. And that would be different than the 30-day update. And there are two reasons that I'm proposing this. The first is that the purpose of the right to know law is to get information into the hands of people who need that information as soon as possible. And I think making the government look at the request and make a realistic judgment of how long it's going to take makes sense. And the second is, I'm very afraid, having answered many, many legal questions about how the law works, that somebody is going to look at the 30-day thing and say, hey, I missed the first deadline. I said I needed 90 days. I get an extra 30 days when it doesn't actually take them an extra 30 days. So I think by realistically leaving the onus on the government to make that estimate and make that estimate accurately with the update makes sense. And so that's what my proposed amendment would do. And I'm certainly happy to take any questions that anyone has.
Questions for this witness? I guess I do have one question, Mr. Grace. The thing one significant difference between your proposal and the way it's written now is, if I'm understanding, your proposal constitutes that there's if you can't provide the information in the time estimated in the initial written statement, then there's only one, the municipality only has an obligation to provide one report saying it's going to take us longer. There's no obligation to continue providing updates. Is there under yours?
If I miswrote that, there should be a continual obligation, and that's what we advise.
Okay, so you don't have, in other words, you don't have a problem if your proposed language was tweaked a little to say that you gotta if you don't meet what you've said you're gonna do, you have to provide more response.
Right. So when the ACLU makes that request and they get some information and they get the update of here's how long it's going to take, if they miss a second estimated deadline, that's totally fine. Understandably, the ACLU or whoever else should get an update of here's where we are. And so they know that we, the government, are working towards accomplishing the request.
Other questions for this witness? Yes, Representative Tripp.
Thank you, Mr. Chair. Thanks for taking my question. I'm a little slow sometimes, so please bear with me. I believe that when a right to know request is made, there's 3 suitable responses by the government agency. They can make the record available, they can deny the request, or give you a statement saying how long they think it'll take for them to fulfill it. I believe that the bill makes the assumption that if there's the third option is the one selected, that eventually the requester will get the information. Would it be possible, should that the government agency, in the time used to, prepare the response determines that the information should be denied? Is that something that could be written in the response?
So I think that's inherent in the law. So let me give you a realistic example. So if you make a request for the last 6 months from your town administrator's emails, while the IT department can probably run and capture all of those emails fairly quickly, someone in the government's going to have to go through those and determine, if it's a governmental record, which is the first question. So if your town administrator wrote, me an email and said, "Hey, Nate, it's your birthday, happy birthday," that's not a governmental record because it has nothing to do with the business of government. So those aren't going to be included. They can exclude those. There might be information about pending litigation. So they might have sent their town attorney an email and said, "Hey, the ACLU is suing us and we want to talk about settlement. Here's kind of some numbers." And obviously that's not going to be released because that puts them at a disadvantage when talking about those settlement settlement negotiations. So that might be denied. But as they go through it, if that's a later email, as they're going through, like, periodically, day by day, someone is reading through each of these emails, they might not know that email exists until day 89 of 90, in which case they're going to say, we're going to redact that email because there's an exemption that applies, but they won't necessarily know about that at the 75-day mark when they thought that they were going to have all that information ready. Does that make sense? I hope that explanation made sense.
It'll do. Thank you.
Other questions? I thought I saw another question over on the side, but anybody?
Chair, I'm a
Yeah.
co-sponsor, but I may ask a question, correct?
You didn't testify, so yes, you may.
Okay. Thank you. Thank you for taking my question. So the example that you gave about, going through the emails and finding, information between the lawyer and one of the parties at the public agency, would that be covered by attorney-client privilege as well?
Yes.
Okay.
I'll leave it at that. I just thought that would be an easy example to use. So,
Other questions for this witness? Thank you very much, sir.
thank you.
I'm going to call on Representative Peter Schmidt.
Thank you, Mr. Chairman and members of the committee, for your attention. For the record, I'm Peter Schmidt. I represent Ward 1 in Dover, and I am a co-sponsor on the bill because I have been looking at this situation for quite some time. I've been in the House now for 20 years, and I was on the Dover City Council for a couple of years before then, so have a fair amount of experience with governmental issues. And my concern is that in most cases, these requests can be acknowledged very quickly. They can be complied with very quickly. But sometimes the request is constructed in such an open-ended fashion that it can require the efforts of the legal department of the city of Dover in some cases, and I've conferred with our city attorney and some other people who do this kind of thing for the state, And the bottom line can be, it was alluded to a moment ago by Mr. Graves, that sometimes it's a request for a review of correspondence over a long period of time. That just can't be done in a couple of days. You can start it, perhaps you can give some kind of a partial thing, but if you want a review of 5 years of correspondence between the city attorney, hypothetically, or any city official, and a group of other people, this can turn into a doctoral dissertation in terms of the amount of work that's required. And that's one of the concerns that I really want to bring to the committee, the idea that this is not free. The people who are doing this in many cases are the legal department, and they can be literally spending virtually all their time. Now, they've got competing requirements of their position for whatever the town may need. And so they're torn between this inexorable machine of the right to know request that says you got to do this within a certain number of days, or respond to it with a denial and so forth. It can be a very, very difficult request or aspect to respond to legitimately. As I say, in most cases, the thing can be acknowledged and responded to quite simply and quite quickly. And the bill does say every reasonable request and to make a reasonable effort. One of you brought up the question of what does reasonable mean? And I serve on the Joint Legislative Committee on Administrative Rules together with your chairman. And I've been on the JELCAR, as it's called, for 16 years, I think. So the word reasonable appears in the statutes more than once, and it's, as Judge Lynn knows, that's the devil in the details. What does reasonably mean? And trying to make the word more and more precise can be really devilish. So without wanting to prolong my testimony too much longer, but the thing is that I urge the committee to look seriously at this conundrum of the not simple request, especially something for a long period of time, some kind of a review. It can't be done in a short period of time any more than you can pop a seed in the ground and pour 800,000 gallons of water on it and expect you're going to have the plant next day. It can't be done. So please do do your reasonable best to look at this language and see if it does not improve the situation in those instances in which the request is not a simple one, and therefore can't be responded to immediately, possibly partially, but you can't get a full review of something that requires months of work. And it's extremely expensive. One other aspect I do want to address here, and that is that not every requester is an ordinary citizen who wants to have some bit of information acknowledged or referenced in a short period of time, and it can be. You do have, in some cases, malicious actors who do want to hamstring the municipality by requests, which can be extremely expensive, and they tie up people who need to be doing, in some cases, more important things. So the malicious actor is one that is causing a lot of problems. So I'll answer any questions you might have if you have any.
Questions for this witness? Yes, Representative Staples.
Thank you, Mr. Chair. Thank you for taking my question. These exceptional circumstances that consume a lot of time and are very costly to the municipality, is there any way to assess some type of fee recovery for those sort of things, either to discourage or enable the delivery without such a heavy impact upon the municipality?
Well, that is an excellent question, Representative Stapleton. And the reality is that that's one of the problems. Is kind of a kick me sign in some requests, in some situations, that because there's essentially minimal cost involved to make the request, that it tempts the malicious actor or even the unfamiliar citizen who doesn't realize that his request is so open-ended that it's going to be very expensive, but he ain't going to pay it. So it encourages, abuses, in my opinion. Thank you.
Yes, follow-up?
Sure.
So basically, the answer is we have no recourse against those malicious actors or the unknowing request that's too extensive to be handled expeditiously.
I think that's one of the problems, that the committee has to be aware of this, and perhaps some testimony from a city attorney, or there are people who at the state level who also deal with these requests, this type of requests, and hearing from them might be beneficial for the committees. I don't know whether it's going to go to a subcommittee, but or whether it's an early bill, but that is an aspect as well. Very significant question. Thank you.
Thank you.
Other questions for this witness? Thank you very much, Representative Smith.
You're
Schmidt.
more than welcome, Mr. Chairman. Thank you, members.
Next, Carla Garicki. Am I pronouncing this?
Should she go first?
Sure.
She represents Right to Know, so.
Oh, sure. Yes, if you come up and just tell us, are you Miss Keiko?
Catherine Coco.
Coco, I'm sorry. Please.
So I can still say good morning, honorable members of the Judiciary Committee, and Your Honor. My name is Catherine Coco. I am the acting president of Right to Know New Hampshire. We are a citizen-based organization that provides advocacy, education, and assistance to those seeking access to public information and increased transparency in government operations. Our priorities are threefold: to keep government records access free and open to the public in compliance with the New Hampshire Constitution in Part 1, Article 8, which stresses and uses the term accountability twice, to improve the enforcement of New Hampshire's Right to Know law, and to improve government transparency. You'll be hearing from me today on a number of proposed bills, so I won't repeat my introduction. Right to Know New Hampshire views HB 149 as an incredibly important piece of legislation this year. This is one of two pieces of legislation that our members chose to really focus on because it addresses a critical issue that is raised in many of the inquiries that we receive from the public. This bill provides clarifying language that makes it clear that a public body has ongoing accountability for every right to know request until such time as a decision is made and the records, when available, are provided. Currently, the only response required under the law is that within 5 days, the public body must do one of the three things that were mentioned before: provide a denial, provide the record itself, or provide a written statement of the time reasonably necessary to determine if the request should be granted or denied and that reason. Note that there is actually no requirement to ultimately provide a final determination and the records themselves when the public body selects item 3. Unfortunately, we see immediate responses or denials from public bodies far less frequently than we see a standard legalistic response outlining an anticipated wait time for records when someone makes a request. As a predictable result, the most common inquiry that Right to Know New Hampshire receives from the general public regarding these inquiries is regarding extended timeframes in which the requesters have been waiting for information without receiving updates on the status or the completion of their request. Based on the current language of the statute, the only advice that Right to Know New Hampshire can provide to those individuals is that the public body is only required to provide them with an anticipated timeframe for response. It does not actually provide for any further update on the status of the request, the efforts being made to respond, or actual completion of the request. This loophole does not serve the public interest and weighs the balance of power in favor of the public body, who may have reasons of its own to wish to delay or withhold information. Various court decisions have made it clear that what constitutes an acceptable time frame for consideration or fulfillment of requests can depend on the size and the scope of that request. And I think that speaks to some of what Representative Stapleton's question was. I can speak to that a little bit later as well. This revision doesn't change that fact. And the language that is written here is not designed to be punitive, despite the fact that public bodies do not really have a motivating disincentive to delaying their response. Instead, HB 149 could provide the future right-to-know ombudsman, which we are very excited about, and the courts with relevant information about the public body's good faith efforts to honor the request and adhere to the intent of 91A. And I think in response to Representative Alexander's question, we anticipate that the information provided in these updates will allow for a more objective evaluation of the public body's efforts when those are in question at the court or through the ombudsman. We would also argue that once a request is made, the burden of justifying a lack of response should fall on the public body. It is asking for an exception, and the public body should be accountable for actions it has or has not taken. And this language achieves that without creating a punitive disincentive. We also think the 30-day window is a reasonable period of time, would not place an undue burden on the public body, and it aligns the expectations of both parties involved in the request process and hopefully alleviates some of the current demands on the public body that exist because there's already a lack of guidance regarding follow-up. So individuals will be following up. The community or public body doesn't know what their requirement is to respond. There's a lot of back and forth. If you have an established process for this, it should help clear some of that up. Our hope is that adding these simple reporting requirements will assist citizens, public bodies, and the courts in establishing whether or not reasonable efforts have been made to address those requests. And I'd like to add a couple of things to my prepared testimony, and I will send a copy of this to your staff person. I did not come with copies, but I know how to submit them electronically. To answer a few questions that have come up, I have had a couple of situations where I personally have put in a request, and that request has been, I've been given the time frame for response. And at the end of that time frame from response, I have been told that certain elements of my request were being denied at that point. So yes, that does happen. I think that we need further clarification on the amendment. I didn't quite follow, quite honestly, the significance of the change that NHMA was requesting. It seems to me that what we're asking for in this particular bill is already what NHMA is saying that they want, except that there wouldn't be any additional follow-up after the second update. And I think that leaves a pretty wide loophole, but I need to make sure that I'm reading that correctly. So I'll weigh in on that in writing as well. And finally, I would add for Representative Stapleton's question, that language that was mentioned by Representative Smith, is that correct? I'm sorry, not Smith, Schmidt, right, okay. The courts have determined that there is what the boundaries of reasonable are. That case law, some of that information is already out there. And so there is some leeway for a public body to determine whether or not a request is reasonable or unreasonable, if not in the statute, but based on the case law. And so that provides the basis for responding to the kinds of overburdensome concerns that you've raised. And with that, I will
Questions for this
welcome your
witness?
questions.
Seeing none, thank you very much.
Oh.
Oh, I'm sorry. Representative DiLorenzo.
Thank you, Mr. Chair, and thank you for taking my question, Ms. Coco. So, just to follow up on what you had just said, that there's sort of a judicial remedy for, abusers of, right to know requests.
Yep.
How does it get to the point of a judge? How does it get there?
So at this point, because the ombudsman does not take office until January 27th, an individual would have to file something with the court in order to have an action come forward. Does that answer your question, or?
I need to think about it a little more.
It would need to be, so I believe if the public body feels that it's being overburdened, it would be their responsibility to file something, or through usually, I would say town council or their own council, but unfortunately, until the ombudsman is up and running, that is the reality where we are.
Just to follow up, I
Yep.
think that public officials kind of back away from, I feel that they should back away from, getting into contentious, fights with the public. So I think that's sort of like a walking on eggs, because public agencies are there to serve the public. Thank you.
Understood.
All right. Any other questions? Thank you very much. Carla Jiraki, is that correct? Jurek, I'm sorry.
Hello, committee. My name is Carla Garrick. I'm from Manchester, New Hampshire. I'm here representing both myself because I do file a lot of right to know requests, and I also serve on the board of Right to Know New Hampshire. Right to Know New Hampshire is a statewide, nonpartisan group of concerned citizens. We're just people who really care about the issue of, as it's stated in the New Hampshire Constitution, open, transparent, accessible, and accountable government. I think I'm here in support of this bill, and it's kind of nice to be on the same side with people I'm sometimes on the other side of. So that probably tells all of us this is a good bill, good for the people. So, I think the important takeaways here to remember is the way the bill, Right to Know, is currently written. The public agency would have to respond within those 5 days. This is really just providing a broader exception in those cases where they don't respond within those 5 days. In my experience, it's actually really good if the public body just, gives the information. But there are situations where there's a big request, and we understand that people do need a little more time. I wanted to make a point to Representative Greason's point. I think it might be valuable to add in to the end of this, that 90-day period, so that we're looking at, the law says you got 5 days or you have to deny it. Now we're saying, well, sometimes it seems reasonable that you might need some extra time. Here's 30 extra days, but you have to tell us when you think you're going to get to this and, what you're struggling with. But then let's not make it this sort of open-ended thing. I can give you a very concrete example. Recently in Manchester, there was a move to rip out a community garden and put in a Boys and Girls Club. It was done in a backroom deal. There was a sale of a public park without any input from anyone in the neighborhood. I filed several right to know requests. I think everyone knows me by now. So I got a lot of the requests back very quickly. But then with regard to the emails, I got they said, hey, it's going to take us about 30 days to get those emails back. And then since then, I never heard anything back on those emails. So this would be a concrete way to really help concerned citizens to be able to hold our government accountable. To the point about costs, I don't think that's relevant to this bill at all. There are other bills that will be coming in front of this committee, and that is something we should talk about. But also, just as a last point, a lot of people who are filing these right to know requests, there isn't a malicious intent. What there is an intent of concerned citizens to hold our government accountable. The only way we can hold government accountable is if we know what is being done in our names. And so that is the goal, and I ask the committee to please consider this bill favorably. I'm happy to take any questions.
Questions for this witness? Seeing none, thank you very much.
Thank you.
Is there anyone else who wishes to testify on HB 149 FN? Seeing none, I'm going to close the hearing on this bill. I will note that we are probably about an hour behind schedule. What I would propose, and I'm open to, if committee members have a different view, I'm open to consider it. I would propose that we hold the hearing now on 254, try to get through that, and then I would propose that I open, maybe before 254, that I open the hearing on 289, but recess it until 1 o'clock. Does that seem reasonable to everybody? Seem reasonable? All right. So what I will do is I will open the hearing on HB 289 and then recess it until 1 o'clock so that people that are here for that, and, you know, if you want to go get lunch, you can go do that. But then I will proceed to the hearing on HB 254. And
I don't see a pink card for Representative Simpson.
oh,
Sorry.
ah,
Oh, that's 254, that's Nate.
oh, okay, that's 254 also. Okay, all right. 54. All right, yes. Well, not quite morning, but that's close enough. Go ahead, please.
Good afternoon. Good to see all of you. Mr. Chair and members of the Judiciary Committee, thank you for allowing me to introduce HB 254, which would allow local public bodies to meet the needs of their constituencies more effectively by allowing more of their members to access meetings remotely. Many local public bodies began employing remote meeting technology during the pandemic, and community members and elected officials found that it was effective and efficient technology that could address issues they face in terms of everyday participation in running the government. Town leaders from across the state have asked that we add language to 91A to make it easier for them to do their work when members face child care or elder care emergencies, illness, or disability issues. Many local municipal boards and committees are struggling to achieve a quorum in person that they would easily be able to achieve with an adjustment to 91A. These select board members, zoning board members, etc., have time-sensitive decisions to make, and if they don't make a quorum, there are real consequences when they're unable to take a vote at a meeting. In this bill, a physical location for meetings is required, but if a quorum is not achieved at the physical location, having 1/3 of the local public body present at the physical location would suffice. The quorum could then be met by members participating remotely. This bill focuses specifically on local public bodies as specified in 3A. So things like school boards and towns, municipalities, counties. In every case for these rules to be applied, the governing body of each local public body can choose to allow this option. Access to remote state and local meetings during the pandemic was necessary for Granite Staters to stay safe, but it continues to be necessary for those who experience barriers to accessing in-person meetings under regular non-pandemic conditions. Those who have disabilities or illness, those who have young children, who are taking care of elders, those who have all shared with me how important remote access is to them, excuse me, as members of public bodies. This bill gives each local public body the ability to be flexible for its needs while still adhering to the right to know laws. So before I take your questions, I need to ask you to consider an amendment. So it has come to my attention, and I apologize that at such a late date, but I've been speaking with disability rights advocates, and by making 254 a repeal and replace bill, we've inadvertently taken away options for committees who were already meeting under paragraph 3, RSA 91A2 paragraph 3, to operate as they are now operating. So committees perhaps of the Department of Education or something like that. So there are already rules for those in place. So what I'd like to ask you to do is consider this amendment that leaves paragraph 3 untouched, but would add this as a new paragraph under that, 3A, A through H, I believe.
So
Oh, can I, one
No,
more
I'm sorry,
sentence?
please,
I'm
go ahead.
almost, thank you. So it would add this new paragraph that would only apply to local public bodies, and it would define it for that case. And then it's also come to our attention that we, in the drafting of the amendment, we need to add an exception for town meeting because we think that would be really impractical. So that will hopefully, I have spoken to a member of your committee who may change this amendment and bring it to you as well. But I'll answer your questions to the best of my ability. But also there are others here who will be speaking who may be able to answer them too. Let me pass this around if that's okay.
Of course. Yeah.
I think I have a couple extra copies.
All right. So do we have questions for this witness? Yes, Representative Andrews.
Thank you, Mr. Chair, and thank you for taking my question. I only have one question.
Sure.
Is this bill constitutional?
Is this bill constitutional? We believe that it is. Yes. We have no reason to believe that it's not. We believe that it's in line with what is already in RSA 91A. Yes.
Other questions? Witness. And you know what? I guess I just have a question.
Yes,
so you are going to provide, or maybe you already have. This is the amendment. This is the cure that for
yes.
the problems you identified. Okay.
Yes, that's it.
That takes care of my question.
So the only thing I'm going to do to that is add an exception for town meetings. Right after local public body in the first paragraph, it will say except town meeting. Okay. Other than that, it solves the oversight.
I'm just making a note here, except town meeting.
Thank you.
Right. All right. Other questions for, yes, Representative Perez.
Might I have you add and school meetings too, because we have a separate town meetings and separate school meetings when you're voting on people and budget. So perhaps that should be an exception too.
Let's definitely talk about that. I haven't thought about that or talked to anybody who does that at this point. But we can definitely talk about that.
May I?
Yes, of course.
When you're talking about town meeting, are you talking about, I live in Londonderry. We have a town meeting. Well, it's not really a town meeting. It would be inappropriate to have people in by Zoom or whatever.
So we were thinking of the town meetings where folks don't vote in the voting booth, where they vote in a room. So I've not thought about deliberative session. Oh. Yeah, no, my town also has a deliberative session. I've not thought about deliberative session. I'd have to talk to, especially to the municipal association who's representing the towns and municipalities, to see what kinds of conversations the folks who run those and who participate in those have had already. The other piece of this is that there's already in statute, there's already provisions for meetings that allow for remote access of the public body. And so the amendment wouldn't change that. It would just change the quorum. So right now, you still have to have a quorum. Like for a deliberative session, you have to have a quorum in the physical location, right? And so this amendment, without an exception for deliberative session, would say that you could have a third present as opposed to 50% plus one present in the physical location. Yeah.
Thank you.
Yeah.
Question, Representative Tripp.
Actually, I have a question of the chair. Since we're holding a hearing, obviously we've accepted the bill. Will the prime sponsor be able to submit a amendment at this point?
I think we've got it, right? I mean,
At some point before the executive session, someone on the committee would have to bring the amendment in. but I believe Representative Simpson understands that.
Yeah. Yes,
All right.
I do. And have talked to Representative Page has offered to work with me to turn it into an amendment that you all could have at your executive session if that's all
Sure.
all right with you.
That makes perfect sense.
Great.
Other questions for this witness? Yes, Representative Kuto.
So as this was originally written, it had allowed for a public body may, but is not required to.
Yes.
And this is changing it to a local public body, and then it's also excluding the fact that it can't apply to the general court. Was that intentional?
That's a great question. The general court makes its own rules, so we have only been focused on the local public bodies for this piece of legislation. So if you look in the definitions for RSA 91A, number 5 is for public body, and then it has a list of different kinds of public bodies, and Part D is the would include like towns, municipal corporations, school districts, school administrative units. And so that is where the idea for let's just call it local public bodies so that we can just deal with the towns, the municipalities, the folks who are really strongly encouraging and urging us to do this legislation. Yeah. So the general court is not involved in this at all. The drafter told me it was not necessary to have that line in there, that it excludes the general court already because of the definition of local public body.
Yes, sir.
So it wasn't your intention then to actually exclude the general court. My concern is that right now, the way that the law stands, if the speaker wanted to, due to an emergency or something like that, he could allow, because 91A is allowing it.
Yes.
But if you're removing that from this paragraph and there was an emergency for some reason, then he wouldn't have the power to allow that unless we had amended the House rules. And so that's my concern.
So he would have the power to do that under what already exists in Roman numeral 3. It would just have.
You're removing that.
No. So that's what the amendment does not remove it. The amendment adds an extra section. That's so it was a repeal and replace, and now it's just an addition. So it leaves in what's already in statute and it makes an addition.
See what I'm saying? It's a new section.
Good. Okay, great. No, thank you. I appreciate you saying that. So that stays the same. Yeah.
Other questions for this witness? Yes, Representative Andrews.
Thank you, Mr. Chair, and thank you for taking my question. My question is line 14, the two words reasonably practical. What is the definition of those two words in here? And should it be listed what is reasonably practical?
So my first answer is it's really for the governing body to decide and the local public body to decide what's reasonably practical. My second is that this is language that a former member of the Judiciary Committee and other stakeholders worked at for quite some time to come up with, and felt that that was a good way to state it so that you left the towns with enough local control, but not complete free reign.
Okay,
Does that
thank
make
you.
sense?
Yeah,
And
thank
I
you.
think I'll also ask that if Nate Grays from the Municipal Association would also address that, I think he'd have some insight into that as well. Thank you.
Other questions for this witness? Thank you very much.
Yes, thank you.
Representative Josh Yerkella?
Thank you, Mr. Chairman and members of the committee. For the record, my name is Representative Josh Okella from Rockingham 32, Fremont, Danville, and Brentwood. I am testifying in support of the HB 254, as I am a co-sponsor on the bill. And I have looked at the amendment, and I was part of that working group that actually drafted the original language. And so one of the things that is being changed is that it is allowing more control at the local level for restricting if a governing body is not handling their remote access properly, then this law would now be able to allow for some restriction of that, whereas in current law, it's just they're able to do remote access by right. And so there is the local public body is allowed to vote to disallow remote options. That is one change. Also, regarding the town meeting language being added to this amendment, town meeting is also includes deliberative session and the SB2 voting day. That is all considered town meeting. It's just different ways of describing town meeting. And so we will verify that school town meetings are covered under the exception and not allowed to have remote access, because that was not the intention of, like, how would you check someone's ID and stuff like that all remotely and make sure you're eligible to vote. It doesn't make any sense. So we're going to make sure that gets cleaned up before your executive session. So this also, I do believe that the reasonably practical language as far as remote attendance is already current law, as far as like people being able to understand whether or not they're allowed to be doing remote attendance to their meeting. And this is also, and it is decided by the board so if I'm on the ZBA, I actually did attend a ZBA meeting remotely, and the board actually, the people in attendance decided whether it was reasonably practical for me to have attended in person. And so that is how the current law is. And so also I wanted to clarify that the quorum, the intention of this bill was not to mandate that just because the members of the board have remote access, that it's also forcing the municipality to force remote attendance by non-members of the board. So this is just focused on the remote attendance of the board itself, and leaving the option open as far as remote attendance and whether or not they are hearing testimony remotely, based on if they have the capacity to do so. Because there are technologies that, depending on how many people are in attendance, it costs more money. And so if you have like a smaller Zoom plan or something like that, you might only be able to have the actual members be able to attend, and wouldn't be able to control like the entire population being able to attend remotely. And I think that is all that I had to clarify. If you had any more questions or detailed questions about the language.
Questions for Representative Ukella? I'm sorry, Representative Di Lorenzo.
Thank you. Thank you, Representative. Thank you for taking my question.
Absolutely.
So, towards the end of your presentation, you mentioned that sometimes it's costly on Zoom to, have larger audiences or larger participations. Is the cost really enough that it would limit municipalities or public bodies from having meetings?
Thank you for the question. I think that the purpose of the bill was not to mandate that the local municipalities have that technology or that higher level plan. It's just trying to address the board process and whether or not you're allowed to, and how many members are allowed to vote, be in attendance remotely, and the remote participation by members of the public was kind of outside the scope of this bill. It was the intention. So, absolutely.
Other questions for this witness? Representative Tripp.
Thank you, Mr. Chair. Thank you for taking my question. The amendment would allow meetings to be held remotely, which would, in my mind, since the meetings have to be, the discussion has to be, people have to be able to listen to it and everything. So does this actually mandate that if the meeting's being held remotely, that people would have the same technology as is being used by the the body to hold the meeting?
Thank you for the question. I'm not entirely sure that I understand it, but I'm going to try and answer both kind of possibilities of your question. I think I am unclear on whether you're saying that whether the bill requires that the other members of the board be able to discuss things and see each other and have the same technology. And that is addressed on line 17 of the amendment to line 22 of the amendment, where where each member, or specifically starting on 18, each member participating electronically or otherwise shall be able to contemporaneously and throughout the meeting see and hear and be seen and heard by the other members of the public body in the meeting. So yes, they would be required that all the members of the board would be able to see and talk to each other and have that full communication. And then if you meant that the attendees be able to see, then that is addressed on line 23 to line 25, which says that all members shall be audible and or visible to the public in attendance at the meeting's physical location. So it's not mandating that everyone that attends the meeting actually have a Zoom, but that they be able to hear or see the people that are attending in Zoom. Let's say, for example, having a TV set up in front of the, that is just pointed at the audience so that everyone would be able to see that is in the audience, but not necessarily attend remotely, right? Thank you.
Other questions for this witness? The only question that I have, then, Representative Ukela, is will you and representatives, we probably will, we haven't agreed on this yet, but I'm thinking we probably will exec this bill in about 2 weeks. And will you be able to have the amendment with the town meeting, this sort of stuff, to Representative Page in sufficient time for us to do that?
Thank you for the question. Yes, I'm in frequent contact with the representative and the municipal association, and so I could have done it much sooner than 2 weeks. So I have strong confidence that it will be ready for you.
Great, thank you very much.
Thank you.
All right, thank you. Next, I'm sorry, not representative, but Karen Hill. And
Good afternoon.
I know we have a number of other witnesses on this, and the clock is ticking here. So I guess what I would say is this: I don't want to inhibit anyone from testifying, but you've all heard sort of what other people have said, and so I would hope that you will tell us new things that we haven't heard, rather than just kind of repeating what other people have said. Thank you.
Thank you very much, Mr. Chairman and members of the committee. My name is Karen Leo Hill. I am a city councilor in Lebanon, And I'm here to voice strong support for this bill on behalf of the city and also to request a one-word amendment if someone would be willing to bring that forward. The city of Lebanon, I have served as the city councilor and also the former mayor over the last 18 years. And so I have seen varying levels of participation. I have seen almost all of the potential ways that people can participate or be prevented from participating. And what I have seen over the last 3 years during the pandemic is that the ability for people to participate remotely has been good both for the city council. Just last night, we had a city councilor, actually 2 city councilors were in COVID quarantine, and they were able to participate in the meeting remotely. And so we were able to benefit from their contributions. When there's only 9 of you, each voice is really important to the deliberative process. And in some communities, there can be as few as 3 people who are responsible for making decisions. And so the City of Lebanon strongly believes that this bill is beneficial for good government to be able to continue despite weather, despite illness, despite any of those things that can come up. This bill is consistent with local control. It is enabling. It does not mandate that communities must do this. It merely provides the option so that if a local community feels that it is appropriate for them, they can go ahead and adopt it. And it does have safeguards in place by having the requirement that a physical meeting does take place with at least a third of the board. That ensures that public meetings, as they should, while meeting the need or meeting the desire to have people be able to participate remotely. Lastly, I'll just address the amendment. You may have heard about the Community Power Coalition of New Hampshire. This is an effort of cities and towns, local governments, including counties, to pool efforts to get lower prices for energy. It is an instrumentality of local government. And there are more than 20 communities that are involved so far, stretching all the way from each corner of the state. And so I'm here. Some of you may have served with Clifton Below, who is currently our assistant mayor, and he's also chairing the Community Power Coalition of New Hampshire. And he has asked, saying that it would provide it would be very helpful in order to meet quorum issues and to allow the functioning of this entity if the word instrumentalities of local government could be added so that it would address the Community Power Coalition. It would be a very narrow addition that we're requesting. And I bring that to you today at the request of Cliff Below and the City of Lebanon.
Question, yes, Representative Tripp.
Thank you, Mr. Chair. Thank you for taking my question. Is instrumentality defined someplace?
Yes, I believe it is, and I'm happy to have Cliff Below provide some additional language. He is very well versed on these matters, so if Representative Page is open to considering that in the other amendments, or I can provide it to the chair.
That's great. Thank you.
Other questions for this witness? Great, thank you very much. Next, Catherine Coco.
Thank you, Mr. Chair. Hello again. I'll jump right into it. Right to Know New Hampshire is opposed to Bill HB 254, which is designed to alter the requirements for remote participation by public officials. We recognize the advantages that remote access has provided to engage citizens and public officials everywhere. But there are challenges that are posed by the use of technology, and many of those still remain to be resolved. To explain those, I have actually attached an additional backgrounder to my testimony that I am happy to share electronically and answer any questions about our position on that. It provides some insight into Right to Know New Hampshire's concerns and considerations about remote meetings in general, and many members of our group have testified in Concord on this issue for several years in a row now. Our membership did do, specific to this bill, a full comparison of the existing and proposed language, and I believe that even with the amendment, these comments still stand. The first issue is that by saying that and I think now the language has changed from governing body of a political subdivision to local governments, may be authorized to participate in remote meetings. This bill effectively creates a distinction between how local and state level public bodies are able to make use of remote meeting technology. Political subdivisions are, well, that I don't think applies anymore under the amendment, the political subdivision piece, but it still raises a question of what's the authorization authority at the state level. And the language as it stands implies that state bodies may not allow remote participation. Second, there is contradictory language in here that requires the members of the public body be audible and visible to each other under item C, but not to members of the public to whom they must be audible or visible, which is under item D. This creates an imbalance of the information that's available to members of the public body versus those that are in the public. It also raises questions about the technology that's to be used. Does this language now require video conferencing? Is that video able to be used only between public officials but not be seen by the general public? Third, this bill removes critical requirements that the location of the meeting must be given in the meeting notice, and that all votes taken during a remote meeting must be taken by roll call vote. I think some of the changes from the original statute to the draft you have in front of you were not necessarily intentional, but when you do a line-by-line comparison, there are changes like that that are substantive. Finally, item C provides an alternative to the quorum requirement for meetings to be able to move forward. Instead of a quorum, it requires that only a third of the public body, if that number is less than the quorum, would need to have a physical presence. The language in item C is very confusing, and I'm going to get in the weeds a little bit about this. The main question is, why would we provide an alternative definition of a quorum? A quorum can often be defined by the public body itself or by the governing body that is over it. So if they wanted to have less than the current quorum number, there's usually a mechanism for making that change. Item C is further contradicted by a later statement that says, a member participating in a meeting by the means described in this paragraph is deemed to be present for all purposes, including for determination of a quorum. If the physical participation is being used to determine the quorum, then those who are remote are not being counted in the quorum, despite what that sentence says. The term all purposes is also exceptionally broad. The power of a public body typically lies in its voting power, which requires a presence of some kind. Using the phrase all purposes raises a question about what other purposes is the public body being put to beyond voting. The reference to the quorum requirement is also confused by the fact that item G below provides an exemption for emergencies, but much later in the reading of the bill. Within the right to know law itself, the language consistently used to note exemptions to a requirement prefaces that requirement by saying, except in an emergency, comma, and later it goes on to define that emergency shall mean, and explains that. This standard language would be much clearer. There are elements of this bill that Right to Know New Hampshire does support. Giving the governing body the authority to determine whether or not a public body can allow remote participation helps to clarify a consistent process for its use, while the bill still allows for more stringent conditions if the local entity wants to consider those. Right to Know New Hampshire and its experienced leadership, many of whom have testified here long before me, would be happy to discuss concerns about remote meetings with any legislator. We've testified previously on that issue. Unfortunately, the language of this proposed bill does not appear to be ready to legislate. Today, we urge you to oppose this bill as inexpedient to legislate. Tomorrow, we encourage the creation of an ongoing conversation and an analysis of the challenges we face when we're balancing the use of technology with the public's right to know. Thank you.
Questions for this witness? Thank you very much. Carla Garrett.
It's Gericke, but no one can say that. Thank you, Chairman and the committee. Carla Garrick for the record, again, testifying as myself and as a board member of Right to Know New Hampshire. I know everyone wants to go to lunch, so I will make this very quick. I concur with the previous statement. I'm very torn. I'm a techie person. I love technology, so I definitely understand that this is a direction we want to move in, but I don't think this bill is the right way to do it. So I would encourage you to ITL this and then to start a conversation. I think it's important to note that the conversation and the testimony in favor of this bill only talked about how it would be easy for the people who serve. And of course, we appreciate everyone who serves, but you serve on behalf of the public. And so these bills need to accommodate the public and not make it easier for the people who are serving the public, but indeed for the public. I would also say that as we explore this area, an important thing I noticed that is missing from this is I would encourage us to put in language that talks about these kinds of remote meetings then, of course, being recorded and also being subject to the right to know bills, so that we just make sure as we move into this direction, we are actually creating a greater public body and public work for the public, because that is actually why we are all here. I haven't looked at the line items on the amendment yet, but I would encourage this committee, if you do proceed for whatever reason, I do think there needs to be a very close reading of the language to the bill, and there has been testimony submitted electronically via email from some other right to know members that would help you with that. So I encourage you to go look at those emails. So I would say, due to the shortcomings of this bill, I would like you to oppose it now. But again, we are open to, and we understand that there is a need for this, but let's do it right from the start so that we don't make a mess and then we spend 20 years trying to fix it. Thank you.
Any questions for this witness? Thank you very much. Mr. Graves.
Thank you, Mr. Chair. Nate Graves for the Municipal Association. We support the bill. We support the amendment. I know there were a couple specific questions committee members had asked. So Representative Perez had asked about school meetings. I don't know off the top of my head whether those were included as part of the exemption from people meetings where remote participation could occur. That was not meant to be included, so we'll make sure to get that language correct. The term town meeting does cover, as Representative Yokela indicated, the whole event, no matter what structure your town is. So if you have a deliberative session, if you have a traditional town meeting, whatever your structure is, that's the term as defined in the statutes elsewhere. I believe Representative Andrus had a question about what reasonably practical means. That's already in the statute. That has existed there for a long time. And it really captures the idea of, why can't you show up? And it has to be a good reason. It can't be, I didn't want to get off the couch and not drive to town hall. It has to be some legitimate reason, like I'm in quarantine or, something that actually matters. Representative Tripp asked a clarifying question about kind of the process. So I just want to reiterate that this does not authorize totally remote meetings. There still has to be a physical location that at least 1/3 of the public body has to be present at. And there are additional requirements for anyone who is participating remotely so that information from them can be shared with other members of the board and the public. So it's not an entirely remote meeting. There's still a physical location for people to go to, as already is required. Other than that, I just want to say, since you've seen at least you've seen one municipal official, we've also heard from quite a few municipal officials about their desire for something to go into effect to allow them greater flexibility with meetings, because they recognize that with the advance of technology, it is important that the government can respond in a similar manner to, as private business, to events that occur and allow the participation of people who've traditionally been excluded, such as the elderly who may not be able to drive, such as the disabled, such as people who rely on others for transportation. And we have seen an uptick in that type of participation over the last few years. And we want to continue to provide greater access for participation as members of the government, because we are a government of the people. And we want to continue to promote that for all the people. Thank you. Happy to answer any questions.
Questions for this witness? Thank you very much, sir. Oh, whoops, I'm sorry. I'm sorry.
Thank you,
Di
sir.
Lorenzo.
In your opinion, do you think that the remote meetings as a whole have made improvements to public access for people?
Absolutely. So when I've talked with municipalities, they've said as they've done things like streaming their meetings, as they've done things like opening it up to more remote participation, they've seen a pretty marked increase in the public generally, and especially people who wouldn't ordinarily be able to come down to town hall and sit through those. So people who have young kids, you know, they're not going to get a babysitter for the night. People who, you know, for whatever reason can't drive there or too far away, or there's bad weather or whatever the case may be, and they can continue doing the business of government. So I think it's been a great improvement on how government functions.
Thank you.
Thank you.
Other questions for this witness? Seeing none, thank you very much, sir.
Thank you.
You may step down. And Karen Rosenberg, please, from the Disabilities Rights Center.
Good afternoon.
Welcome.
Thank you. I'm Karen Rosenberg, the Policy Director at the Disability Rights Center. I know you're all starving, so I'll be quick. In general, we support the concept of this bill because we want to encourage civic engagement in this state, but we also don't want to thwart our public body's ability to get their work done. Civic engagement can include people with disabilities, people who have experienced illness. Now we've learned about COVID and need to quarantine. So expanding the ability of public bodies to function despite some of these bumps in the road for participants that would encourage participants is a good thing from our perspective. But only if the bill is amended to create a new section that would not obliterate the current protections in our current law that apply to other types of bodies that wouldn't be covered by this law. So current 91A2 Roman 3, which I'm sure I'm going to butcher your name, Representative Kutap, astutely pointed out, is really necessary so that when there's an emergency or reasons that other public bodies can't meet or in person, or not all their members can, that they can continue to function if they meet the in-person quorum requirement. So as a member of the State Advisory Committee for Children and Youth with Disabilities, this has been an issue, allowing parents of children with disabilities and parents with disabilities to participate by allowing them to access our meetings remotely if necessary. So one other thing I wanted to encourage you to think about is how, if there is going to be a remote option for public body members, that the public also be able to, at the very least, view those meetings contemporaneously. Again, it's about civic engagement, encouraging engagement from people all over the state, regardless of whether they have a disability or not, or a communicable illness like COVID that we've seen recently. It's about making our government open and accessible to more folks. So thank you.
Great. Questions for this witness? So can I just ask one question? Are you comfortable with, at least that's the first point you raised, are you comfortable with the proposed amendment, which would basically say we're not repealing the existing Section 3, we're just making this what is referred to as Section 3 in the bill, Section 3A?
Yes,
Okay.
my heart skipped a beat when I saw the repeal, so yes.
All right. Any other questions for this witness? Thank you very much.
Thank you.
Is there anyone else who wishes to testify on House Bill 254? Seeing none, I'm going to close the hearing on that bill. And now, at long last, it will be time for lunch. I know that I said that we would resume the hearing on 289 at 1 o'clock. It's obviously, you're not going to have enough time for lunch if we do that. I will be back here at 1 o'clock to recess that until, but can I say at 1:30, does that give everybody enough time to come back by 1:30? All right, so if you would all be back by 1:30, I'll be here at 1 to recess.
You actually had said 2 p.m., so there might be people not coming back until, and I don't know if you want to.
Did I say 2? Oh, I got you. Did I say, I thought I said.
Let me go
Oh,
back
maybe,
on YouTube.
I thought I
It's
said 1. I thought I said 1.
Let me go check on YouTube.
Okay.
I've got it
I feel like I
noted that
said
we just
2.
moved it.
Now, it's actually a couple of minutes after 1, and I said we were recessing the hearing on HB 289 till 1 p.m. So for the record, it's a little after 1. We're going to continue. We're going to recess that further till 1:30. So at 1:30, we will begin with HB 289, and then we'll go through the rest of the bills, as quickly as possible after that. Right? Thanks. bill we have for hearing is House Bill 289, originally scheduled for 11:30, but we recessed the hearing first to 1 and then to 1:30. Yeah, Representative Corcoran, let me, not here. All right. I guess maybe, well, let's see, what, 30, yeah. All right. I guess maybe I'll recess the hearing on that, for now and move on to House Bill 307. And
We're only a half an hour behind.
right. Unless this is Representative Corcoran. No, it's not. All right. All right. We're gonna move on to 307. And I'm gonna recognize Representative McGuire.
Thank you very much, Mr. Chairman and members of the committee. For the record, my name is Dan McGuire. I represent the town of Epsom. This bill makes a small change to the right to know law, 91A, related specifically to attorney's fees that may or may not get paid after the conclusion of a trial. So we're in a situation where somebody asked for a certain kind of information, they were denied by the public body, and then they filed a lawsuit, took it to court, and won. And then the question is, should the public body cover their attorney's fees or not? And so currently, in current law, it says that only if the court has to make a judgment. They have to say, should they have known that they should have given this information? And if so, then they would cover the attorney's fees. We're changing it simply to, in this case, you're denied, you go to court, you win, then your attorney's fees will be covered. Right? And it's basically pretty simple. You know, we want public information to be available to people. And we don't want the process to be the punishment. You know, so somebody needs information, they go through all of this, they get it finally at the end of the day. It shouldn't, on top of that, cost them fees. So it's that simple. Thank you, Mr. Chairman.
Questions for this witness? I'm sorry, Representative Wallace, did you have a question? I guess I do have one question, Representative McGuire. The language you propose says the court renders a final judgment in favor of the requester. So, I mean, this might be a somewhat unusual situation, but if a final judgment in favor of the requester would not necessarily mean that the requester got some information. And I guess what I'm thinking of is this. Suppose there was a lawsuit under the right to know law that said something like, you town, eventually you gave me the information I wanted, but you took too long. And so I'm bringing a lawsuit saying, I want a ruling from the court that you're not going to do this anymore. You're not going to, from now on, you're not going to take as long as you have taken to provide this information, and the person wins. The court says, yep, the town really was dragging their heels, and so judgment is entered in favor of the requester, but the requester had already gotten the information without the lawsuit. What happens then?
Thank you, Mr. Chairman. To me, I think you're stretching it a little bit too far, right? I mean, to try to come up with an example. I mean, in the case you're saying, to me, it doesn't sound like that lawsuit was necessary, right? I mean, this person they're just doing a lawsuit just because they didn't like the process or something. You know what I mean? They wanted information. They got the information. That should be the end of it, I would think. I mean, I don't know.
Okay, no,
Yeah.
I mean, you may be right. I'm just asking a question.
Yeah.
Other questions for this witness? All right, thank you very much.
Thank you.
Representative McGuire.
And may I'd like to acknowledge my co-sponsor, Representative Smith. She has also helped us put this together.
Great,
Thank
yes,
you.
for sure. All right. Now, let's see. So next, Miss Coco? Miss Coco?
Yes, it's cocoa, like hot
Coco,
chocolate.
sorry. I'm sorry.
Thank you. No, it's fine. So I'll jump right into it. Right to Know New Hampshire enthusiastically supports HB 307, which sets a more realistic standard for awarding attorney's fees when right to know cases are won by the requester. Unfortunately, due to limitations of data that's available, we're not able to articulate the number of right to know cases that might have been fought, how many were won by the requester, or the number of instances where the winner of the case was awarded attorney's fees. I always prefer to have that kind of information on hand, and Right to Know New Hampshire has tried to gather what it can from available court records, but with few findings. What I can say is that based on the experience of our membership, the general public who seeks our help, and the attorneys with whom we interact, an award of attorney's fees is incredibly rare. Not only that, but in most cases, municipalities and state agencies typically outlawyer and outspend the average citizen where there's a contested outcome in a right to know case. The spending power and the knowledge base of the state and local governments typically edge out less powerful citizens, forcing them into a position of deciding whether to pursue an enforcement action that may lead to a financial loss, even when they win. And even if they're able to do that, a citizen who makes rational economic decisions, and I admit that not all of us do that, is unlikely to invest in an action that does not confer a personal benefit. The public good rarely outweighs a personal pocketbook. The playing field needs to be evened out so the average citizen has a shot at coming out, if not completely whole, at least partially compensated for the public good that they are fighting for. Otherwise, they're further disincentivized to raise the issue at all. If our current law didn't rely on private actions for enforcement, maybe this strategy wouldn't be necessary, but it does. I think this reliance on private action is one reason that New Hampshire ranked 34th in the nation and received a D- in public integrity as evaluated by the Center for Public Integrity in 2015, not 1915. In the category of public access to information, New Hampshire received an F and ranked 49th. The report stated that the bar for recovering attorney's fees and other costs is dauntingly high here. One related driver for that score was that in practice, the entities to monitor the application of access to information laws independently are not initiating investigations or imposing penalties on offenders. We got a score of 0. In helping to create the Right to Know Ombudsman's Office, the Judiciary Committee has tacitly acknowledged the financial deterrent that prevents citizens from bringing their right to know issues to court, and I think that's very important. But even the creation of this office will not change the scored factor that I just mentioned, because investigations still have to be instigated by private action, and existing penalties for violations of 91A are limited. But HB 307 would make it more feasible for those who do find themselves in court to consider pursuing the right to know enforcement action. Since those actions take the place of independent monitoring in New Hampshire, they're contributing to the public good and a healthy discourse around the implementation and enforcement of RSA 91A. I'm going to preempt what I think I might hear in the opposition, which is that public bodies do not want to have to pay costs associated with clarifying gray areas of the law. Unfortunately, this works to the advantage of the public body. As long as those gray areas exist, the uncertainty they create is and will be exploited to the benefit of the more powerful public body. And sometimes the only way to gain clarity on those gray areas is to bring a challenge to the system. That judicial clarification benefits the general public, and I would argue that sometimes, even when the right to know case is lost, and I've lost some, the clarification found in the case law is a benefit to the general public. I can provide an example of that if we wanted to talk about a gray area, but Given the extremely high upfront costs that are associated with attorney's fees, this legislation is not likely to precipitate frivolous actions. What it will do is improve the chances that New Hampshire citizens will be able to fulfill the role that's assigned to them as independent enforcers of New Hampshire's right to know law, and encourage them to pursue cases where their position is obviously or very likely to result in a winning case and changes to the behavior of public bodies. And I will end there. Thank you.
Questions for this witness? So, I guess I do have a question. You've removed from the current law language that says fees shall not be awarded if the parties agree to that. That's taken out. I shouldn't say you, but that's taken out of the language of the bill. And so my question would be, would it be your understanding that even though that under the proposed bill, with the amendments that it accomplishes to current law, there would be nothing that would prevent the parties to a right to know litigation from agreeing that in this particular case no fees will be paid?
Thank you, Mr. Chair. I will clarify, this is not legislation that Right to Know New Hampshire drafted. So I'm weighing in based on my opinion and my read of this, but I do not think that this prevents any kind of agreement from being able to take place.
That was my reading also. But I just
Okay.
want- okay. I'm sorry. Other questions for this witness? Thank you very much.
Thank you.
Lori Otalfo?
Ortolano.
Oh, to Ortolano, sorry. Thank you.
Good afternoon, Lori Ortolano. I didn't come with anything prepared in writing, just came to speak. I'm a member of Right to Know New Hampshire, and I speak in favor of this bill as a member and also as an individual that's been involved in right to know litigation in Nashua for almost 3 years. I think it's time to remove this standard that we have as part of the language and make it easier for attorneys' fees to be accessible to people filing suits. And I think it would have helped me in my cases tremendously to come to resolution and close them down without having them spiral out of control and become what I would call a dumpster fire. And as it stands right now, the cost of litigation is very high. I took a right to know lawsuit into court for assessing records. I spent $230,000. I won a portion of my fees. I removed my lawyer after I got through the order, but the city appealed to the Supreme Court. The cost of the appeal was going to be $100,000, so I went on my own. And it's hard to be a pro se litigant doing this, but, I filed a right to know lawsuit with an attorney under the assumption that they're handled, a priority case. They're simple, I was told, not a big deal. I told my husband I'm going to do this. I'm frustrated. I've been trying to get records for a year. And he was all on board, but we had no idea it was going to be $250,000. And if I had stuck with it, it would cost $400,000. We just had no idea. And it's frustrating to me that that's what I learned. I did 2 cases after the one with the attorney. Actually, while the attorney was representing, I filed 2 more on my own in Superior Court pro se, and I won those cases. And I did it I wasn't going to go through the legal fees I went through. I won the ruling for the records, and the city has appealed all 3 cases up to the Supreme Court. So they're challenging the fee, in the case represented by the attorney that was so expensive, the court did award fees, and he awarded information that the city would not provide. They're still withholding the information, and they're fighting the fees. I may not win. These high standards, I may not win, and they might be reversed, and it's going to have cost me $250,000. And it upsets me a great deal that the Constitution is written such that our records are supposed to be open, accessible, accountable, and our government is supposed to be responsible, and we're not supposed to have unreasonable restrictions. And you can't be a single-digit millionaire and take these cases into court as a citizen anymore. You can't. Your billing rates are $500 an hour, and you're just being raked over the coals. And municipalities have big pocketbooks with taxpayer dollars, and they were able to fight me like a beast. I stayed in the game, but it's been really eye-opening. And since those 3 cases are done, I went in with another one because the city just won't shape up. And I know that if I tried to get legal representation, that case in lower court would cost me $400,000 with a lawyer, and I'm not paying it. That shouldn't be the cost for information. You know, we've lost our media coverage. Now, Nashua no longer has a newspaper, really, doesn't cover any political things. Manchester is very minimal. The press played a big role in Right to Know and opening records and taking cases into court, and that was great. They had the corporation behind them and the money, but I think you're seeing it shift to citizens trying to do it, and we're getting smoked. And our ability to win in court is pretty poor, I think. I feel like the courts don't like these cases. They're burdensome to the court. They're busy. They have bigger fish to fry. They've got criminal cases. We've got drug problems. We've got serious problems that have to be looked at. And your little information request isn't very important, but it is, because it allows government to operate in the way government is supposed to operate. And when you make it so difficult for information to be obtained, you have no press that's checking. Municipalities can go really off the rails, and there's no way to pull them back on. I think that's happened in Nashua, and it is brutal, and it becomes so personal. It's not just a request for information, it's the associated gaslighting of citizens that goes on in trying to get it. And I think if fees were awarded, the cities and the towns would sit back and go, oh, you know, we don't want to play games here. We want to be clear. We want to try and get to the bottom of this, and we don't want to be paying fees. And I think it would have helped me. I'm not certain it would have fully helped me, but I think it would have definitely helped me. And, you know, sort of get control of the nonsense. Yeah, this was a really eye-opening experience for me, and very, very painful for my family. And it goes on, and when they can appeal and go to the Supreme Court, I won't see responses and information until 2024, 2025. And by the time I get them, it's all a waste of time. And I wasted, you know, hundreds of thousands of dollars to get really nothing. It's very disappointing. I wish the state and the government and the courts, I'm frustrated with the courts, had done more to get a hold of this before it became this. The Ombudsman Office is terrific. The work done by Representative DiLorenzo and Right to Know New Hampshire, I think it's a great move. It's a step in the right direction. But when you go into court and you need to access court, let's allow some of these fees to be obtained. You're only going to win probably 30% of the time. Citizens aren't going to do great. But, you know, give us an opportunity to recoup these. They're very expensive. Thank you.
Questions? Thank you. Questions for this witness? Yes, Representative Greason. I'm sorry.
Sorry. Thank you, Mr. Chair. Actually, this may be a question for you and your legal expertise, and you could clarify for all of us. Do we have the ability to restrict a public body from being able to appeal a decision unless some newly discovered evidence would show that the original ruling was unjust? So to play the stonewall and the expensive stonewall of, well, we'll just appeal it because we've got deeper pockets, they can't do that unless there's some way they can prove that the original ruling was unjust by some new evidence. Can we do that? Because the private citizen can appeal their decision against them. That's out of their pocket. But the public body is just playing a game.
I guess that we probably could do that. Although I guess what I would say is presumably anytime the municipality appeals, I assume that somebody has made a determination that the trial court decision was wrong. I mean, I would be, maybe I'm being too generous to attorneys, but I think that for example, if an attorney knew that a case was sort of frivolous, let's say, and was just taking an appeal for the purpose of costing the other side money, I think that attorney would be subject to discipline under the rules of professional conduct. So I assume in most cases that some an attorney who representing the municipality has made a determination that we have some issues here that we have a reasonable chance of prevailing on. Not necessarily we're going to win, but it's not a frivolous kind of issue. Oh, I hope that answers your question.
Could I respond to that as well? His question, just from my perspective, you hope they wouldn't do things frivolously, but I think, in fact, in my situation, there have been some frivolous things done. And Representative Lynn is correct. You can file a complaint through the Professional Conduct Committee. But let me tell you how difficult that is. You can't get a lawyer to assist you because lawyers don't like ratting out other lawyers. And guess what the city does? They lawyer up. And you go in there, it's brutal. Your chances of getting through that group is beyond discouraging. I am A1 disgusted with what it takes to take a complaint to a Professional Conduct Committee. That is, and you're sworn. They tell you you're sworn to confidentiality. You don't sign any agreement. There is no complaint I could file in any other group that I as a citizen am not allowed to share that complaint. If I file against assessors in the Department of Revenue, it's a public complaint. It's all public. They tell you it's all private. So you're just stuck in a hole with no representation, and citizens can't write them well enough. They give you a book of like 10-point print with 200 rules to figure out which one they violated. It's very difficult. You can't go up against it. It's not a good system.
Representative DiLorenzo, I believe you had a question. All right. Any other questions for this witness? Yes, Representative Perez.
Thank you for taking my question. See, this seems very black and white to me. Remember, I'm not a lawyer, but you asked for paperwork. You weren't given the paperwork. So you went to court. How can there be appeals to if the judge said you should have your paperwork? I'm naive in the legal system, although I've done
Well,
a
so
couple
was
of
I.
fights.
So was I, but they have a right. That's the process, the judicial process. They have a right to challenge the decision of the court, the lower court, and they have an appeal process that takes it to a higher court.
So this was black and white. I asked for something, I didn't get it. I'm going to court to get it.
Right. And then, and what's even more frustrating, in one set of records, I asked for a year, and they said they were giving them to me. We're sending them, we're redacting them, we're looking at them, we're sending them. Went on and on and on. And then this was asked for in December of 2019. In October 30th of 2020, the letter came that they elected to deny them. So you wait 10 months and you're told no after they looked at them. And then you can get a ruling to win, and they're up there appealing it. It's maddening. But
Other questions, Representative Smith?
Mr. Chair, Ms. Ortolano, it's so good to see you again.
Thank you.
The whole issue of attorney's fees is a very complicated issue. There are very few areas where attorney's fees are granted by the court when the client prevails. We've seen it in the area of special education, and it was in that area because there was a clear, there is a question here, I promise. Because there was a clear pattern of school districts having attorneys whose revenue came from saying, regardless of the merits of the case, saying, do not grant the parent's request. What has happened is we've been aware of that in the area of special education for a long time, but we have not been aware of it in the area of right to know. This bill, though, has two provisions, and I want to ask you about the second one. The first is, if the requester prevails, the court can then go and grant attorney's fees. But the next paragraph says, if the requester fails, the court can then require them to meet the attorney's fees of the agency. Do you see how that-
I think it's a little bit more restrictive. I think it has to show, like the language now for citizens. I think it has to show an intent to try to be malicious, or an intent, not just a favorable ruling against the citizen automatically grants the fees to the city. The other thing is it would change because the cities would have to start keeping fee records, and they don't. The cities, I'm required to hire an attorney who maintains contemporaneous records of their fees. The city, it does not maintain any fee records at all. And so I've been opposed to that because I think they ought to track them. It shouldn't just be us. They can throw out a lot of things and stand in a meeting and say, God, that lady's made us waste millions of dollars. Show me the records. But they don't track them at all.
If I could follow up, what it says is in bad faith, frivolous, unjust, vexatious, wanton, or oppressive. Those are all very unpleasant terms, but they're also as both specific and vague in terms of definition. And so do you have any problem with that section being included?
No, because I do think those words in front of it put a higher standard than just losing. And I also think those words are vague, but there are legal definitions to them, and they have to abide by a legal definition and a legal standard.
Thank you.
Other questions for this witness? Representative Tur.
Yes, I just dawned on me as you were asked, as that question was being asked, and I guess I'll direct it at you, but it may be maybe more easily answered by our chairman. If a lawsuit is one of those things, frivolous or unjust or vexatious, would it be dismissed? And would that dismissal be different than rendering a final judgment?
Well, to the extent you're asking it, of me, but
That's a hard question for me to answer. I mean, I think that one way or another, a judge has to make a ruling. It might be part of a case that you submit a pleading on that you're trying to look at versus the whole thing. I think it probably would be hard for a judge to dismiss it without hearing it, the case in its entirety. You're looking at all the evidence that's being, provided. So in that case, time gets wasted potentially, and that's what makes it, a problem and frivolous. But so I'm not certain that they would or do, or that I see often where a judge just dismisses something as frivolous. They, in my opinion, are investing a good bit of their own time and effort and the resources of the court to determine that.
other questions for this witness? Thank you very much.
Thank you.
Brendan McQuaid?
Good afternoon.
Hi.
My name is Brendan McQuaid. I'm the president and publisher of the New Hampshire Union Leader. I would like to start with disagreeing with Ms. Ortolano that the media is gone. We're very much here. I am here representing the New Hampshire Press Association, and we support HB 307. The New Hampshire Right to Know law, as you know, plays a crucial role in the transparency of state and local government. The law currently supports broad disclosure of documents, but we continue to see instances like in Lori Ortolano's case where documents are wrongfully withheld and they're withheld in violation of the letter and the spirit of the law. The current provision for awarding attorney's fees is that the public body, public agency, or person knew or should have known that the conduct engaged in was in violation. We would expect that public agencies and public officials should have known that they were in violation. In practice, it proves to be a rather high bar. And HB 307 as proposed gives much more leeway for the court to award attorney's fees, which have to be reasonable according to the language. And it would create a financial incentive for public bodies to be more responsive to valid requests for information that they ought to know that the public has a right to. The New Hampshire Press Association represents many media outlets throughout the Granite State, from small one-person online news publications, local weekly papers, large daily newspapers, and broadcasters. The right to know law is a critical tool for all of our members to inform the citizens of this state what their government is up to. A public agency that refuses to comply with the right to know law, backed up by publicly funded attorneys, is a daunting obstacle, especially for some of these smaller outlets. And it's a daunting obstacle to generate quality local news. We hope that by making recovery of attorneys' fees a bit more attainable, HB 307 will help level the playing field in the important work that our members do. We wholeheartedly support HB 307.
All right, thank you. Questions for this witness? Seeing none, thank you very much, sir. Margaret Burns?
Good afternoon. I'm Margaret Burns with the New Hampshire Municipal Association, and we are here this afternoon in opposition to House Bill 307. Under our legal system, the general rule is that parties to litigation pay their own fees and costs. There are some exceptions to this rule, and the current RSA 91A8 is one of those exceptions. The plaintiff or the requester is entitled to fees and costs if the lawsuit is necessary to enforce compliance with the right to know law, or to address an intentional violation of the right to know law. Fees are awarded only if the violator knew or should have known that the conduct was a violation of the law. There is logic to having these exceptions where there are intentional or egregious conduct that justifies awarding attorneys' fees and costs to requesters or plaintiffs in these cases. But under the bill, the law would say that if a plaintiff is successful in a right to know law case and the lawsuit was, quote, necessary to enforce compliance, the plaintiff will get fees and costs, making this a dramatic change to the right to know law. This would apply even in a situation where a public body or a public agency took reasonable steps to get legal advice, acted on that legal advice, was sued, and ultimately the plaintiff or the requester was successful, shifting the burden of defending that lawsuit based on reasonable legal advice to the taxpayers. The second section of the bill does allow the public body or the agency to receive attorney's fees and costs in certain situations where the lawsuit is vexatious, frivolous, and other terms that are listed in the bill. NHMA does not support this section either. We do not have a policy to seek out attorneys' fees or costs from residents or citizens who bring right to know law cases. Our legislative policies with respect to the right to know law are to oppose additional burdens and to support the intent and purpose of the law, as well as to support legislation that clarifies the law and makes compliance and public access requirements easier and less burdensome for public officials and employees and less costly for taxpayers. The legislature has recently taken significant action in this area to make right to know law actions more cost effective and more accessible to residents and citizens with the creation of the ombudsman position. For these reasons, we are opposed to this bill and we would ask the committee to vote as inexpedient to legislate. Thank you.
Thank you. Questions for this witness? Yes, Representative Greason.
Thank you, Mr. Chair, and thank you for your testimony. So if I understand your testimony in paragraph 2, the addition of the clause "and provided that the court renders a final judgment against the requester," you don't think that needs to be in there? Because current law ends with a period after oppressive.
No, our position is that current law should remain in RSA 91A8 as written.
Right, so put a period after the word oppressive, not have the what's bold.
That's correct. That's where the period is. Sorry for that, for not being clear. Thank you.
Other questions for this witness? Yes, Representative DiLorenzo.
Thank you, Mr. Chair. Good afternoon, Ms. Burns. You know, listening to the testimony in this hearing, I feel like, you know, there are two opposite poles kind of going back and forth. Is there a middle? For instance, you know, if the plaintiff files in court, can the judge order an injunction or estoppel or something like that, so it doesn't get to that point where...
I believe it's RSA 91A7, a different section from what we're dealing with now, that does allow for an injunction. So we're not always talking about we're not always talking about a specific scenario as was referenced earlier about the records or not the records. Sometimes there's an injunction not to repeat this conduct in the future. Sometimes there's a requirement even that the public body members undergo right to know law training. So those are different types of orders that you can see in these types of cases.
Thank you.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Giles Bissonnette.
Thank you, Mr. Chairman, Your Honor. It's good to see everyone again today. My name is Gilles Bissonnette. I represent the ACLU of New Hampshire. We're here strongly in support of this bill. I've been doing this job now for around 10 years, and a core component of my work has always been government accountability, public records work, to try to make sure that the public has access to what their government officials are up to. And it's frankly been, among the many things I do, probably the most rewarding work in my legal practice. And just by virtue of that experience, I am asked a lot by advocates who care as much about transparency as I do, you know, what would be like the single greatest thing you could do to make New Hampshire more transparent? And my response has been, you know, absent a wholesale rewrite of the statute, which is hard and cumbersome and requires so many stakeholders, it would be to have mandatory fee shifting. It would be to do what this bill does. And I want to explain why. Mandatory fee shifting, it allows requesters, again, who prevail in public records lawsuits to recover attorney's fees and costs. And it is critical to ensure the public's right of access, because what it really does is create a set of incentives where government actors are more likely to produce records. They are more likely to err on the side of disclosure. And that is the whole point of Chapter 91A. Chapter 91A creates a presumption in favor of disclosure. That is to say, the scales are already tipped. But we operate in a system now where, you know, I work with municipal lawyers. They're great, but they're very talented. You know, they know all the exemptions. They can raise exemptions, and there's no disincentive to just forcing a requester to go to court. For the ACLU, I mean, we, you know, have more resources, right? We're able to say, no, we think you're wrong, and we can file the $280 filing fee, spend, you know, the tens, maybe even hundreds of hours doing it, because that's our job. That's what we're paid to do. Other people don't have that benefit. Ms. Ortolano, who you heard from, doesn't have that benefit. And that, I think, is why we really do need to change this law. And I really hope this committee considers this change, because Chapter 91A isn't an exemption law, even though there are many exemptions in the statute. It is a transparency law, that every government body that gets a request should start from that default position. And I fear that we have kind of gone in another direction. And I think this will reverse that particular trend. Mandatory fee shifting is important because when a requester successfully goes to court, the requester has brought a lawsuit that confers a social good, not just for that particular person, but for the community at large. But without mandatory fee shifting, a member of the public, like Ms. Ortolano, like anyone else who doesn't have the ability to hire a lawyer, they're left to weigh the relative value of the requested records against the cost of litigation. The result of this calculus is that many successful lawsuits, frankly, to remedy a government's violation may not be brought, particularly when you're dealing with pro se litigants who know they're going to be faced with a municipality that has lawyers on retainer. And so the result is those lawsuits aren't brought. The public loses out on important information. So again, I think when we switch that balance, when we create mandatory fee shifting, now a government body needs to think, well, if I get sued and lose, I'm going to have to pay fees. So I think they are going to be more likely and more inclined to produce the particular information. And in fact, some evidence bears that out. And I've cited that in our testimony. In states that do not have similar fee shifting provisions in their public records laws, the financial risk of litigation is often deterrent to requesters. Footnote 2 has some data on that. And agencies in states with mandatory fee shifting provisions tend to demonstrate better compliance with public records laws. As one study has found, findings indicate that states with higher public records request compliance include mandatory attorney fee shifting provisions in their state laws. So that is really the goal here. I do want to note that we actually used to have this in New Hampshire law, believe it or not. We had mandatory fee shifting in New Hampshire by virtue of an amendment to our public records law back in 1973. It was then modified in 1977, and then in 1986, we landed in the regime that we have now, which is that you only get attorney's fees unless the government body knew or should have known. So I do want to reiterate that there is precedent here in New Hampshire for this. And frankly, I think we have now endured a 30+ year experiment with this attorney fee regime, and I just don't think it's been successful. But when we did have this language, this mandatory fee shifting back in the 70s, the Supreme Court said something that I think is pretty cool, and I just think it really embodies why we need this again in New Hampshire law. And this is a case from 1976 called Bradbury versus Shaw. And I hate to just quote things at length, but to me it is very powerful and demonstrates why I think this is a good bill. The provision for award of attorney's fees is critical to securing the rights guaranteed by the statute. Without this provision, the statute would often be a dead letter, for the cost of enforcing compliance would generally exceed the value of the benefit gained. In some cases, the plaintiff may gain a financial benefit by the invalidation of government action taken in violation of the statute, but it will frequently be impossible to place a monetary value on the interests protected by the right to know law. The attorney fee provision was enacted, in this case 1973, so that the public's right to know would not depend on the ability of individuals to finance litigation. And we lost that in the 80s. And again, I would submit that we need to get back to that. There have been some questions about just some of the language. I know you had an excellent question, Your Honor, about absent a final judgment, but if a lawsuit compelled information to be produced, would there still be a requirement for attorney's fees? And I don't think so. This language actually deliberately does not use the catalyst theory. So the catalyst theory is if you file a lawsuit and it compels the government to produce something, but you don't yet have a final judgment. In some jurisdictions, you may be able to get attorney's fees. Not here. You need to go that extra step and get a final judgment. So if you file a lawsuit, if you spent $20,000 filing a lawsuit and the government then decides to produce it, you are out of luck. I actually don't think that's ideal, but there's discussion about a middle ground. I actually think this is a middle ground, because one potential proposal here would be to omit the judgment requirement altogether, right? But here that exists, and I think that is a middle ground position in my view. I do also want to note, again, I said just a few moments ago, you know, we've lost our way over the past 30 years since this language, and I just do want to give some examples. I want to just give a shout out to Ms. Ortolano, who just testified. I'm pulling up my phone because
you, Mr. Net. I'm just noting the time. No, I'm not, I don't want, I hope it's going to be just a very few.
I have 30 seconds.
That's
And-
good.
And I want to say, number one, other states do this. It's in the last page of my testimony. But lastly, in response, Ms. Ortolano didn't say this, but in response to her work, in the months, this is from the union leader in 2021, in the months that followed her disclosures, the city ordered City of Nashua ordered a management audit of its assessing department, replaced its longtime chief assessor, retained a lawyer to investigate the assessor, and was subject to a review by the State Board of Land and Tax Appeals. That's why our Chapter 91A exists, for government accountability. We still have examples where the government is not producing documents, including police records, in a case that I'm about to litigate at the Supreme Court, even though the Supreme Court has said police records, for the most part, should be released. So I think for all of these reasons, I would request that the committee vote this bill out to pass. And I'm sorry for talking for a long time.
No problem.
Thank you, Your Honor.
Questions from members of the committee? Seeing none, thank you very much.
Thank you.
Ross Connolly.
Thank you, Mr. Chairman and members of the committee for holding this hearing today. Just for the record, my name is Ross Connolly. I'm the Deputy State Director for Americans for Prosperity in New Hampshire. Here to voice our support for HB 307. New Hampshire, we really pride ourselves on the transparent and open nature of our government. Every part of our government is accessible and open to the public. But as we've heard in recent years, there's when it comes to our 91A records requests, there's been a suffering of lack of response in really a timely manner, and not as transparent as it should be. But this bill provides really a simple solution, as we've heard, to bring more sunlight into government and have more of these records requests be honored and respected. So really what we view this bill, it is a powerful incentive that if a lawsuit is going to be brought, that it's respected and taken more seriously when it's there's skin in the game for both sides. So we want to make sure that our government records are open to the public. People can access them. They're not being hidden, because when that happens, people find distrust in government, breeds conspiracy theories, and results in a very negative view towards government employees and agencies. And we want to make sure that is not happening, and that these things are brought out into the open, because in our mind, sunlight is the best disinfectant. So for these reasons, we urge the committee to move this bill ought to pass, and be happy to take any questions if there are any.
Questions for this witness? Seeing none, thank you very much, sir.
Thanks so much.
Is there anyone else here who wishes to testify on HB 307 FN? Seeing none, I'm going to close the hearing on that. And I would like to, I had recessed the hearing earlier on HB 289. We were looking for Representative Corcoran. And I don't see him here. I'm concerned. I'm wondering if maybe I could ask you, Mr. Wallen, could you just introduce the bill? And the reason I say that is we have a witness here, Ms. Burns is here, I believe, who wanted to testify in opposition to the bill, and I think we need to have the hearing on this bill, but I wonder if you would mind, Vice Chair, just introducing the bill.
Thank you, Mr. Chairman, members of the committee. For the record, my name is Representative Scott Wallace, Rockingham County, District 8, the town of Danville. And I'm here to introduce House Bill 289 FN, an act relative to consultation with legal counsel under the right to know law. This bill prohibits a public official from retaining legal counsel for the purpose of evading compliance with the right to know law, and makes violation of the requirement a misdemeanor. And I'll take no questions.
Right. Thank you very much, Representative Wallace. So, so I'm going to call Margaret Burns. I'm going to ask you if you'd please come up.
Thank you. Again, I'm Margaret Burns with the New Hampshire Municipal Association here in opposition to House Bill 289. We think we understand what the bill means and that its purpose is to state that a government official can't hire an attorney to help them violate the law. I believe that is what the language in the bill is getting at. We agree that a government official should not hire an attorney to assist them in violating the law, or that any person should hire an attorney to assist them in violating the law. And we believe that Rule 1.2 of the Rules of Professional Conduct would already cover this situation. That rule states that a lawyer shall not consult a client to engage or to assist a client in conduct that a lawyer knows is criminal or fraudulent. For this reason, we don't believe this language being added to this provision of the right to know law is necessary, and would ask that the committee recommend the bill as inexpedient to legislate. Thank you.
Questions? Yes, Representative Greason.
Thank you, Mr. Chair, and thank you for taking our questions. Isn't the fact that although some language already exists, and yet the behavior still continues to occur, that clearly something needs to be done to address the fact that despite what's in the law, it's still occurring?
Thank you for the question. There are already serious penalties for individuals that take action to intentionally violate the right to know law or take other actions, especially in their governmental capacity, to violate the law, engage in fraudulent or other misconduct. Obviously, misconduct occurs in every industry and every faction of government. And I think we would see, if we tried to reiterate and address every possible piece of misconduct that could happen, we could see an endless addition of provisions to the law to put into place those particular situations that have occurred. So I would suggest that the law already covers this situation, and it's simply not necessary to put more language into this provision in the statute. Again, I believe I understand the bill to mean what I think it means.
Questions? Yes, Representative DiLorenzo.
Thank you, Mr. Chair. Attorney Burns, who gets to decide that misconduct has taken place?
It could be as the result of a criminal prosecution. It could, so in the situation of governmental misconduct, you could see a criminal prosecution or you could see a civil lawsuit being brought, and both could occur for the same conduct, criminal and civil action.
So follow up?
Yes,
So that would be after the fact, correct?
That's correct. Misconduct would have to occur for there to be a criminal proceeding taken against an individual.
So just more follow up.
Yeah.
So in this hypothetical case, then the defendant, I'll call, would be looking to defend their actions, and I'm not getting this at all. I don't know. I mean, would that be like a violation of the United States Constitution as far as representation of a plaintiff?
I'm sorry, I'm not sure I understand the question. I don't see a constitutional violation there.
This bill prohibits a public official from retaining legal counsel for the purpose of evading compliance with the right to know law, and makes violation of the requirement a misdemeanor. I don't know. I'm just having a hard time with this. I'm sorry. Just the fact that the bill says that it prohibits a public official from retaining legal counsel.
Oh, I apologize. I understand what you're saying. I don't think it certainly prohibits a public official in general from acquiring legal counsel. It is trying to target an already improper reason for retaining an attorney, which would be for illegal purposes.
Thank you. So, if I could just, that raises, am I understanding correctly that the subsection L that this amends, the purpose of that subsection is to say, these are the times when you don't have to have a public meeting, right? And so one of them is if you're going to talk about something that you've consulted with counsel, and what this is designed to say is if you've just sort of created when there's no real reason to be consulting with counsel, but you've just done it so you can have your meeting in private instead of in public, then you're in trouble.
Then thank you for that clarification. If you do exactly what you just described, you are already violating the right to know law. This is a provision that deals with consultation with an attorney to receive legal advice, and you can't use an attorney improperly or for some other cover to be able to evade the right to know law. So I think that would not only violate principles relative to rules of professional conduct, but it would violate another provision of the right to know law, which prohibits local officials from looking for ways to evade compliance with the right to know law.
Thank you. Other questions for this witness? Great. Thank
Thank
you
you.
very much. Is there anyone else here who wishes to testify on House Bill 289? Seeing none, I'm going to close the hearing on 289. And we've already done 307, so we will turn to House Bill 308.
Good afternoon. My two colleagues who were going to testify just went upstairs to testify in another meeting.
We
so-
understand.
I know.
The whole legislature's busy. We understand, so no problem.
Thank you. I am Frances Nutter Upham, Hillsborough 8. This is my third term on Health and Human Services. I've recently been appointed to the Rare Disease Council, and it's because of their meetings that I'm here today. I have an amendment that will replace the former bill 308. So originally, the 308 bill, which you looked at, was broader reaching than just the Rare Disease Council. And having sat here in the morning, I realized that House Bill 254 covered a lot of the same territory better. So that's why I'm offering this amendment, which would allow remote quorum access for the Rare Disease Council. So there's many reasons that they need to meet remotely. Most importantly is that some of them have chronic, forever rare diseases that they just cannot be in contact with other people. So we realize that COVID quarantine and contact kind of goes in and out, but some of the parents or parents of children with rare diseases that make up this council, it's just not really possible for them to come. The committee, the council does have a physical meeting place, Hazen Drive, and they run, so it meets that stipulation. If 354 was to pass, the minimum quorum requirement was 1/3, and I just don't know that it's reasonable for this committee to be able, council be able to meet that. The people on this committee are medical researchers, doctors up at Dartmouth Hitchcock and other places throughout the state, that I am grateful that they're able to give an hour of their time to come in remotely, but to expect them to take maybe 5 hours out of their remarkable schedules to come to Concord to give a monthly report is not reasonable. So I'm willing, if there's something about this amendment that bugs you or think we could be tweaked better, I'm willing to go forward with that. And I just think it's important medically for our state that this council continue to operate, and they haven't been able to vote on their minutes in over a year. I also have, I'll leave a pile there, but I brought the original bill about why the council was formed, and for your reading, it would be better than me reading it to you. So, but I'll leave a pile there. So that's, Dr. Knurk has, I think, sent you all a letter, and Representative Wendy Thomas also had testimony that she was going to give. So I can ask her to mail it to you.
Yes, are you ready for
Happy to
questions?
take
Oh,
questions,
great. All right,
sure.
Representative Kaczynski.
This seems like a little bit of a non-germane amendment here. Was the original intention for this bill to only encompass this one council?
Well, so Office of Legislative Services is new, and so when I mean, they're not the office, but many of the new lawyers on it are new. So when I said I'm looking for a way for this council to meet quorum, and they didn't write it narrowly, they wrote it broadly. They just wiped out some. So my intent was that this would cover this council, and if it was able to cover other councils with special needs like this, that would be okay.
Yes.
Thank you.
Yeah, because I think also the Special Needs Advisory Council had voiced earlier that they had similar issues. However, in looking at this council's makeup, I see that it's made up of about 11 members, and I see that 2 of them are House representatives, and 1 of them's a member of the Senate, and 1 of them is a commissioner of the Department of Health and Human Services. So that would be 4 of 11. That would be 1/3. That would seem like they would be able to be present. The rest of them, I could see perhaps if there's a reason why they couldn't be, but those people there, I'm unsure why on a regular basis that they wouldn't be able to be in person.
Well, for instance, last year, no appointments were made. So it went a whole year with a missing member. But the speaker seems to be proficient at that this year, and we're getting the letters about who's appointed on. So that was a problem last year that may not be a problem this year. Certainly I'll drive up from Nashua, whatever. So they haven't appointed the other state legislature to this committee yet. So, but I hear your point.
Other questions for this? Yes, Representative Alexander.
Thank you. My question's kind of pivoting off the clerks in the question of if it's only 11 members, like what's stopping the 11 members from meeting in a socially distant way in the New Hampshire House, for instance, in the chambers? I mean, I'm sure the speaker would be willing to accommodate.
There's only 2 members that are from the House and 1 from the Senate.
I'm sure that the 11 members could use the chamber for purpose of a meeting
Well,
or in a socially distant way, right?
Yeah, I don't think that's good enough for some of the ailments that these people suffer for, that wouldn't be safe enough. Even to come into a public building just wouldn't be safe enough. But good point. I hear you. Yes.
I do remember, I'm sorry.
No, go
I'm
ahead.
sorry, too.
Thank you,
That's
Mr.
all right,
Chair.
go ahead,
I do
please.
remember this bill from last term, and the issue was that a lot of the folks on the council were very disabled.
Yes.
And had trouble, getting out. And so this bill, or the issue, was to make an accommodation to them because of their
Right.
inability to get around.
Yeah, I'm sorry. Did somebody else have a question? Or no, Representative Kutab, go ahead, please.
So perhaps I'm a bit confused, so I'm hoping to get clarification. What I'm seeing is that the members are only 2 persons living with a rare disease and then 1 parent or guardian of a child with a rare disease. The rest are, again, legislators or a physician or a nurse practitioner. So I'm only seeing that less than 1/3 of those people would have a rare disease. Am I looking at the wrong thing? I just wanted to clarify.
No, I think you're correct, but the other point I made was that it's to ask one of those doctors to drive 2 hours here for an hour meeting and then 2 hours back is beyond reasonable.
What other, yes, Representative Perez.
How long has this group been in existence?
2019.
So that was during it came about with COVID. So you really haven't had an option to meet much together. How often do you meet?
Once a month.
Once a month. So
And not always in the summer. I've attended, so I just formally got my letter that I'm on it last week, but I have attended 4 or 5 meetings over the last 3 years.
And approximately how many members have shown up over these meetings in the past couple of years?
About 8.
Out of and there's 11 in it?
Yeah.
Okay, thank you.
Thank you. Yeah.
Other questions for, yes, Representative Alexander.
Just pivoting off that, if the 8 have attended the meeting, how can you not vote on minutes for the previous meetings?
We're not
That's my
allowed
question.
to vote online. Or their interpretation.
You've had meetings in person with 8
No,
people?
no, they
Okay,
were
that's
all
my
on
question.
Zoom. They've
Okay.
all been on Zoom.
Thank you.
So
for
if they were
clarifying.
allowed to vote the minutes on Zoom, they would gladly have done so.
Perfect, thank you.
Okay.
Any other questions? So, you know, yes, Representative Tripp.
So this was a public meeting.
It can be. It's noticed in the in
So
our
the-
calendar, and a public could come.
All right, so it being a public meeting, there were people present.
No, I think.
Well,
Well, I think we had a visitor by Zoom, but we haven't been in person. They've all been Zoom, so we've had visitors via Zoom attend these meetings,
all right. So
which is encouraged and welcomed.
I've
Although
lost,
the
I've lost
subject.
track of my question, so I'm gonna be quiet.
Well,
We have
thank
other-
you, Representative Tripp.
We have other questions. So I guess I do. Oh, yes, I'm sorry, certainly.
So is this a need of the state for these people that are disabled and can't get out? Is this a great need for the constituents out there?
That this committee, this council is able to meet is of great need for everyone dealing with all kinds of rare diseases. I'm grandmother of a young man with a rare disease, a survivor of an odd cancer myself. And it's so important that people doing research are able to talk to each other and follow up what's the latest, what's coming up, what other states are doing, it's crucial. That's why they passed this bill in the first place. I mean, not my bill, but the bill to form the council.
So can I
Yes,
follow up and
yep.
just say I don't know how this, so I'm new to this, but I just want to say, could we make an exception to, as we discuss things and to go forward, to allow them to have a remote access if they needed to? If they cannot come physically to the meeting, that they could, but again, it's
Well,
for us
that's
to
kind of
discuss
what
it.
I'm asking is for that the remote quorum be
Right.
allowed for them because of their special circumstances. And, if 254 goes through, we're almost covered here, except for maybe the quorum. But if 254 doesn't go through, I need this bill to go through so that this council can meet and approve their minutes and continue. So, yeah.
As
Sure,
a
if you have
nurse,
question,
I'm concerned as well, so I'm just hearing about this.
Oh,
So,
thank you very much.
Thank you.
Okay.
All right. Any other questions for this witness? So I guess I do have one question. I'm I'm a little troubled by the idea. I mean, the bill before the amendment seemed to be a more general bill that would allow remote participation. And I, I guess I'm a little troubled by your proposed amendment would limit it to just this, the Rare Disease Advisory Council. And so I'm wondering, I mean, what would be our justification? I mean, I understand you have two people that are on that council that have some kind of condition, but
Or more, yeah.
or maybe more. But I'm wondering what would be the basis for us singling out that advisory council? I mean, if we were going to pass a law like this, wouldn't we want to make it generally applicable? What if there's, what if the board of realtors has two people that are either ill or have some kind of condition or have some other reason that they couldn't be there?
Well, in a more perfect world, I'd be very happy for that. I mean, a broader one, but it seemed that the original 308 would be competing somehow with 254, which seemed more thought out and nuanced.
Right. So in other words, am I understanding what you're saying is you may have drafted the bill to be just for this one board, but you don't have you wouldn't have a problem if it was made more general to all boards.
No. And I after this morning hearing 254, I had to make a pivot in the hallway, like when I used to act and somebody gave you the wrong line from the wrong scene and you just had to kind of go on with the scene. I'm like, all right, we're finishing the play a little early today, All right.
Got it.
So.
No, got it.
Okay.
Any other questions for this witness? Thank you very much.
Thank you. And I'm available for, rewrites, questions. You have my number. Thank you.
Representative Wendy Thomas?
Mr. Chair and members of the committee, I'm Representative Wendy Thomas. I represent Merrimack Hills 12. I am going to testify in support of a general allowance of remote meetings. Times have changed. In 2020, we were introduced to Zooms, which are remote meetings. Very quickly after that, we all became burned out on Zoom meetings. But we realized that remote meetings allowed less travel time. It allowed parents to join meetings, and it allowed people who are sick, those that don't have much left in the tank, to attend. In 2023, we are finding out that 1 in 10 people will develop long COVID after exposure to the virus. Long COVID can be debilitating. However, people can participate with accommodations. We can still benefit from their expertise. Remote access is no longer a convenient way for people to participate in meetings. It is now simply a necessity for much more than 1/10 of our population to actively participate in leadership and decision-making opportunities. Thank you.
Any questions for this witness? Seeing none? Yes, Representative Stapleton.
Yeah, thank you, Mr. Chair, and thank you for taking my question. I'm sorry, but I didn't clearly hear those afflicted with COVID will develop. What kind of an affliction?
It's called long COVID, for lack of a better word. I mean, the medical community is calling it, and that's where persistent symptoms of the COVID infection continue. As an example, I'll give my example. In 2020, in November of 2020, I had COVID, and it didn't hit my lungs; it hit my gut. I couldn't taste, I couldn't smell, I had no appetite, I had no thirst. That persisted for 2 years. The gut portion at some points became so severe I literally couldn't leave my house. I mean, I had to be. It's like that commercial where the people are looking for the bathroom. It's gotten a lot better, but I had it for 2 years. Unfortunately, where I work, they allowed me to work remotely and to participate, remotely, and that saved my job. So, I mean, that's, work is a different issue from this. This is attending meetings, but we're going to have to be very aware that 1/10 of our population is going to be disabled because of COVID.
Thank you for that explanation.
You're welcome.
Any other questions for this witness? Thank you very much.
Thank you.
Um, Former Representative Jerry Knirk? Knirk.
He's upstairs at another hearing.
All right, well, let me go on then. Catherine Coco.
Good afternoon again. Right to Know New Hampshire is opposed to HB 308. I will admit I'm trying to catch up on the amendments that are here, so I'm going to speak to the original bill and to the extent that I'm able to with the amendments. Again, we recognize the advantages that remote access has provided to engage citizens and reiterate that there are challenges that have not been addressed in terms of how to conduct remote meetings, both for members of the public body and attendees in their presence as well. So much of my prior testimony on HB 254 applies regarding the kinds of safeguards that we feel need to be put into place. I did have the privilege of speaking with Representative Nutter Upham, and I understand that the motivation from this bill comes from a sincere desire to make participation in statewide meetings easier for committed volunteers and stakeholders who wish to contribute and to conduct business. The body she represents does face some unique challenges. And just as an added background on myself, I have a master's in public health and was doing pandemic planning as far back as 2004 and using the term social distancing long before anybody else probably in this room. I'm very much an advocate for the use of remote technology and have been self-employed in using that for a long time. But this proposal, as it currently stands in 308 in the original version, really does remove a lot of the guardrails that are currently in place with the deletion that it suggests, most notably the need for a physical meeting location, which is now added back into the amendment, which is why it's getting a little bit confusing. But some of the other issues that need to be addressed when we're talking about remote meetings include having a mechanism for managing problems with public access, having a trigger for stopping the public meeting if the public can't access it, and what that is, and the ability to define the record, the recording, as a public record. Currently, minutes of a meeting officially constitute the public record, and the video may or may not be made available to a citizen. There's no guarantee that in the case of a fully remote meeting, which could easily be recorded, that the official record will include the recording of the meeting or the chats associated with the remote meeting as part of that public record. There are a lot of questions about those kinds of technical issues that are still floating around out there. As far as the original bill goes, and I realize there's a change in the application, all proposed changes to 91A should consider whether or not they make meetings or information more or less accessible to the public overall, and not in specific cases. While statewide meetings may be a particular challenge, a change like this, if made to 91A, would make it possible for local boards of selectmen, for example, to meet entirely remotely, and that would dramatically change the participatory nature of local governance. So I would say that this amendment makes it a little bit clearer that there is a reason that it's being applied only to the Rare Diseases Council, but I will say that Right to Know New Hampshire is very aware of the difficulty that comes in enforcing something like 91A when you have discrete changes to the law that apply in very specific cases and aren't applied broadly across the board consistently and transparently. And I think that that would be an issue that our body would raise if I were to bring this amendment to them. We will be talking about that on Saturday. Because of those changes, I just want to take a look at this. For a couple of the other things that we think are important, that virtual access should be provided, and the information about that should be provided within the meeting notice, and that there should be and if during the meeting a member of the body informs the public body that there's a problem with that access, those problems should be stated in the minutes as well, so that it's documented that there was an issue with somebody gaining access to it. And those are a couple of pieces that Right to Know has identified as key to being able to put together truly accessible publicly remote meetings. So again, like with 254, we would urge you today to oppose this bill as inexpedient to legislate. What we really need is an overarching guidance on remote meetings that applies across the board. And if there needs to be a particular exception, maybe to the quorum requirement in the case of the Rare Diseases Council, maybe that one piece could be something that's put out there as an alternative. But tomorrow, we would like to be able to have that conversation and put something that's more comprehensive together.
Questions for this witness? Representative Tripp.
In being able to justify not attending the meeting, somebody wants an exception. One of the things that the sponsor said was that well, it's just too much bother for the doctor to drive 2 hours each way. Do you figure that that would be a justifiable exception?
I think that that puts much of the volunteers that are involved in supporting these kinds of bodies between a rock and a hard place. We want them to participate. We want to make that easier for them. And we want their input. I think we need to find a middle ground for them to be able to do it. I don't know what that is, but I do think that it is important, and Right to Know has stressed repeatedly when it comes to remote meetings that there needs to be a physical meeting location with a quorum in the room where the members of the public have the ability to interact with members of the public body as much as possible. That interaction is important. Being able to read body language, being able to see the screen, not simply have someone be audible. It's very different if I say to you, I agree, and roll my eyes, than it is if all you hear on the over the audio line is, I agree.
All right. Other questions? Yes, Representative Horgan.
Guess on the other hand, you're very concerned about things being said which aren't on the official record, but isn't that also a problem with an in-person meeting? People are having discussions that aren't, like in front of the microphone or in the main room. And of course, also, this isn't so much Right to Know New Hampshire, but other groups have also been against remote meetings because that doesn't give a chance to physically confront the officials in person. That certainly can lead to unofficial dialogue that's not part of the official program. So,
Is there a question? Is there a question?
Yeah,
Representative Horgan?
So you feel like there's more chance for like sort of unauthorized off back channel conversations in a Zoom meeting than there is in an in-person meeting.
So I feel that if I'm sitting in this room and you all are in front of me, I can see what the body language is between one representative and another representative. I can tell that you guys aren't under your table texting at each other. And even so there's a level of understanding the interaction that's happening. Do side conversations happen? Yes. If there's side conversations that are happening over, and Zoom chat is one of those kind of sticking points with remote meetings. They're happening on a publicly funded system for a public meeting where people are having side conversations, then yeah, those should be part of the public record. If you step outside and speak with someone in the hallway, that's a different thing.
Other questions for this witness? Thank you very much.
Thank you.
Now let me go back. Representative Jerry Knirk here. All right, so he's not here. We have other business, so I'm gonna close the hearing on this matter. I should say, is there anyone else here who wishes to testify on House Bill 308?
Mr. Chair, if former Representative Bernard has written testimony, he can submit it, right?
Oh, of course, yes, absolutely.
He did.
Oh, he did. Yeah, we do have a letter from him. Yes, or a memo. What I should say. All right. Any other witnesses on HB 308? All right. Not seeing any. I'm going to turn then to House Bill 321. HB 321. 321. Thank you.
And the committee calls Representative Yokella.
Thank you.
members of the Judiciary Committee. For the record, my name is Representative Josh O'Kella, representing Rockingham 32, Fremont, Danville, and Brentwood. I'm here introducing my bill HB 321, which seeks to clarify the law or 91A regarding non-public meeting minutes and the kind of review process and how those get considered to be subject to public disclosure. Right now, the law as it is states that these meeting minutes are subject to public disclosure when the body finds that the conditions for which they were kept from the public no longer apply. And so that assumes that they're making some decision at some time to that one, that the conditions are not forever, and two, that they need to be reviewed so that they can be subject to public disclosure. And right now, a lot of communities, because there is no set guidance for how that occurs, it has fallen by the wayside. And that, especially for someone like me who is on a board but was not there when the board was instituted, I do not know all of the times that it went into public meeting, non-public meetings, and then sealed those minutes, because prior to this year, there was no list of those meeting minutes that have been sealed. And so as a board member, trying to fulfill my duties to ensure that the meeting minutes that are kept from the public are being reviewed and unsealed when subject to public disclosure when appropriate is requires some negotiation on the board, because there is no clear empowerment by even an individual board member to go and find those non-public meeting minutes and review them. And so what this bill hopes to do is to create a kind of a guardrails and encourage boards to make a procedure for this. So what the proposed language does is say that you can adopt a procedure that goes into the this process for the regular review and to vote on the whether or not the circumstances no longer apply. But if you don't have such a procedure, then it is the determination would be that that you should review them every 10 years, at least every 10 years. And so that is kind of an outside, like obviously you should probably review them more often than that, but it's kind of just setting up guardrails and saying this is reasonable. You can pick whatever time frame that you want, 1 year, 2 years, 5 years, 7 years, even 10 years. And that the legislature views as a reasonable, regular review. But if you're doing it every 50 years, that doesn't necessarily constitute a regular review of these sealed meeting minutes. And so this bill was worked with in consultation with the Right to Know New Hampshire and with the Municipal Association, because the Municipal Association actually does encourage and recommend to the municipalities now that they have these regular reviews. And they do encourage people to, or they would like to encourage the legislature to be more clear about this issue and how this process should occur. And so that is where the impetus for this legislation came from. So I'm happy to answer any questions.
Representative Perez.
Thank you. So there's nothing in place now that says they have to review these at all and bring them public?
Thank you for the question. It is implied by the language of 91A that there would be a vote to determine whether the circumstances no longer apply, but there is no guidance for a time frame or that any requirement that they have a process at all right now. So it's kind of the wild, wild west. And so we're just falling by the wayside because it's not required.
The 10 years, why was the 10 years picked?
Thank you for the question. And as I was stating before, it was kind of, the idea is that we don't want to be burdensome on the local municipalities and say, you have to do it every single year. Otherwise it's going to be, because maybe they have a lot of minutes and they need time to review them or whatever. And so it's kind of a discussion between Right to Know in New Hampshire, which I'm sure would prefer it every year, and even the municipality, the NHMA would encourage people, these boards, to do it every year. But is that reasonable that every single board in the entire state have that same thing? I think that's maybe a little bit too strict. Is 5 years too long? Maybe, maybe not. I was trying to just say, what is a reasonable amount of time, and allow the municipalities to choose a time frame that makes sense for them, as long as it's within this reasonable amount of time of 10 years. But I'm obviously, I have sponsored a bill a few years ago that was very, very much more strict. And so it died. And so I wanted to be more inclusive to everyone's perspective on how regularly they could review this and not fall short of the law. So thank you.
Thank you, Mr. Chair, and thank you for taking my question. I noticed at the end of the bill, the Judiciary Department of Justice states there are a number of public bodies attached to the Department of Justice, and this might create a burden. Also, when it comes to municipalities and school districts, et cetera, is there any type of information available as to how often they seal records? Because like I know I go to my school district meetings, school meetings every month. And for about 9 years now, I've never known them to seal non-public. So I was just curious.
Thank you for the question. I believe that the Department of Justice needs to comply with 91A just like everyone else. And so if it's, so the only people that are able to seal or keep minutes from the public are boards that, so I'm not exactly sure which boards are in the Department of Justice and how often they're sealing stuff. There's no reason that they couldn't make a motion to reseal all, like a entire slate of meeting minutes in one motion. So I'm not sure it would actually be a burden if they now under 91A, the recent change, they have to create a list of the meeting minutes. And so they already have a list, so they know what meeting minutes need to be sealed and when they were last voted to be sealed. And so they could just go to that list and say, hey, I would like to make a motion to reseal all these meeting minutes. And it would not take any specific, length of time. And so I think that I kind of discount that that it would cost any particular board a large amount of time necessarily, but I do think that they need to have a procedure for that. And as far as your other question, as far as how often boards seal minutes, it is different between each board. And now that we have this requirement that they keep a list, you may find that some boards like budget committee or a zoning board don't do it ever. And selectmen do it at every meeting. And so it's, you may go to your local municipality and get that list and find out who is going into non-public and sealing minutes. And that will be the best probably way for you to know in your municipality who is utilizing that functionality.
Yes, Representative Kuta.
I know. I notice in the title of your bill that it states meeting minutes not reviewed after 10 years shall be made public, but then I don't actually see that in the bill. And I was wondering if the intention wasn't to have that in there, or if that was a mistake. And then I guess as a follow-up to that, if the intent was to have that in there, would you be amenable to adding something about unless otherwise unlawful? For example, I wouldn't want a school board meeting minutes relative to a specific child to be automatically released just because the school board hadn't had time to review.
Well, thank you for the question. I believe 10 years is plenty of time to review, but regarding your other statement about whether or not things would automatically be subject to public disclosure if they weren't following that, that is specifically stated in line 9, that they need to vote to determine whether or not the circumstances no longer apply if it's been more than 10 years. Otherwise, they would be subject to public disclosure. So they need to vote, or it's automatically going to be subject to public disclosure. And then also, in lines 9 through 12, I'm making sure that this becomes retroactive over the next 10 years, that they have 10 years to review and find those minutes that they currently may not be part of a list or whatever, so that they can go back, have that time to gather the previous meeting minutes, so that nothing is being like falling through the cracks.
Representative Tur.
Yeah, thanks, Representative Yokla. I guess I have two questions, but let me start with one. I think you clarified it in your previous answer. There's no specific requirement of what a review constitutes, and it would be acceptable for a board to just make a decision that we're just keeping this sealed without doing any specific type of examination of the contents. Is that your understanding or intent?
Thank you for the question. My intention is not to micromanage the boards, is to encourage them to have a process. If when they review it, it is in an inappropriate process, then that will be done at a public meeting that is transparent to the public, and therefore they can be voted out if appropriate. Okay. And so I think that, they can have any review process if it's appropriate, that you have a giant list and you say, I motion that we reseal all of this, every meeting minutes on this list for the next 10 years. And that is appropriate for their municipality. I'm fine with that. I just want there to be a process in place so that it's happening.
Can I ask one thing? I don't know if it's a follow-up specific. It may be a different question.
Sure.
When you're talking about voting on these minutes, my understanding, if you go into non-public, you can discuss multiple non-public things in one session. Would it be possible? Am I wrong? I'd be happy to be wrong on that. I thought that you could do that, and I was curious whether or not you could unseal part of a set of minutes if some of it needed to stay and some of it didn't.
Thank you for the question. I definitely think it's a different question. The you can go into non-public. So there's two kind of sections of law regarding non-public, and the sealing of non-public. So there's the statement kind of in public session for the reasons why you're going into non-public session, and then you could theoretically you could list whatever and however many of those that you want to be able to discuss in non-public, and as long as they are covered under the non-public heading, I don't think you have to come back out and go in for another discussion under a different topic. I don't believe that that is the intention of or the practice of current law. And then there's another part of the law that says that you make a determination after that, after you come out of non-public. You can make a determination about certain situations, which is a delimited list of the entire list of the reasons why you go into non-public, that allow you to keep the meeting minutes of that non-public from the public. And so it's not exactly the same list of reasons that you can keep things from the public as that you can go into non-public. Those are two separate lists. And so yes, I guess there is, you can go in for multiple reasons, I believe, is my understanding. And however, I don't know of a situation contemplated in the law where you would be able to unseal part of the minutes of the non-public meeting minutes. I think it just says there's something in there that you don't want to disclose and therefore it needs to be kept from the public. You have to just make it's more of a binary choice than a like line by line. We're going to, strike out this line kind of a thing. Thank you.
Representative Trick.
Thank you, Mr. Chair. Thank you, Representative, for taking my question.
Absolutely.
Is it true that the body has to be in public session before it can make a motion to go into non-public?
Yes.
For one of the reasons in 91A:3, 2A through J, and that they have to return to public sessions before they can seal the non-public minutes?
Yes.
Do you feel that most boards are aware of this and practice this?
Thank you for the question. Whether or not they follow the law, that is, I'm not aware of all of the municipalities and their boards' knowledge and practice of the law. Hopefully they are.
Other questions for this witness? Yes, Representative DiLorenzo.
Thank you, Mr. Chair, and thank you for taking my question, Representative Yokela. I'm reading this proposed bill, and it sounds like the bill requires public bodies to release by default all withheld records, correct?
Thank you for the question. I think that is a very broad statement. And I do believe that even the CIA is not allowed to seal minutes indefinitely. They can only seal minutes for like up to 75 years, and then they have to review them again and reseal them. And so I don't believe that that anything at the local level rises to the level of national secrets as far as that is concerned. And so I don't believe that we should go, as far as that. So I do think that, even, who killed JFK might eventually become, public record.
May I follow up?
Yes.
So, and my thought is, it's a every 10-year process, right? Who's going to remember 10 years from now that they have to deal with these records?
Thank you for the question. As I stated before, I definitely would encourage them to do it on a much more frequent basis. However, under the new law, there is, on non-public meeting minutes, on the list that is required to be kept, it is said when it was the date of the meeting and when the date of the sealing happened. So there's going to be a list of, so you would know.
Other questions for this? I'm sorry. Other questions for this witness? Seeing none, thank you very much, Representative.
Thank you.
Representative Rebecca McWilliams, or McWillis. Williams, McWillis, I'm not sure. Williams, sorry.
The story of my life. Mick Williams, MC Williams, son of. Yes. Thank you, Mr. Chair and members of the committee. For the record, my name is Rebecca McWilliams. I represent South Concord, wards 5, 6, 7, 8. You're sitting in one. It's a pleasure to have you in my ward. Thanks for coming. I'm here to also support this very good bill. This is a very small change, but I think it's a very needed change, just to clarify what otherwise the courts would have to clarify in terms of a reasonable period of time. And so we're putting a number on it. We're putting 10 years. That's a reasonable period of time. So if you go 11 years, that's an unreasonable period of time. I think it's really important that we do that as legislators, to put a pin in it. If we don't, it leaves things subjective and potentially subject to lawsuits where we all dicker about it and spend lots of money fighting over public meeting minutes in a court when we as legislators could simply put a number on it and make it very clear. So that's one of the reasons I support this bill. I think we do need this bill. Certainly there are all kinds of interesting Concord school meeting minutes that I would love to see at some point. And so setting a 10-year clock from now for me personally and for my constituents would be a good thing. And so I'm happy to answer questions, but I'm here to say, yes, please put a pin in it.
Questions for this witness? Seeing none, thank you very much.
Thank you.
Catherine Coco.
Thank you, Your Honor. And this will be the last time you have to hear from me today. Right to Know New Hampshire strongly supports HB 321. It requires a review process for minutes that are withheld from the public, and this occurs under a process that's commonly referred to as sealing the minutes, which can be done under any of 3 specific exemptions that apply to the contents of those minutes. When that happens under 91A3 Roman numeral 3, the law says information may be withheld until, in the opinion of a majority of members, the aforesaid circumstances no longer apply. Although 91A3 Roman numeral 3 implies the existence of a review process to decide whether or not those circumstances apply, most towns do not have one. The fact is that there's no historical record of non-public minutes that were sealed, and the reasons why further complicates and informs citizens' ability to review potentially relevant materials. A recent amendment to 91A that was mentioned by Representative Yokela now requires that listing of non-public minutes beginning in January of 2022 and has changed the process moving forward. This is very much for the good, but the historical record remains barred to public review, and for the most part, if the minutes were sealed in 2015, in 2005, or in 1995, they remain sealed and without review. There was some questions from a few members of this group about what the practices are, so I can speak to some of my experience. Until very recently, the practice in my hometown of Milford seems to have been to consider almost every non-public session to result in sealed meeting minutes. Those meeting minutes were often sealed incorrectly on the basis of the reason for going into non-public session and not one of the 3 legal reasons that you actually are allowed to seal the minutes. That has since been corrected, in part because I have raised the issue and raised it very loudly. I have personally had the experience of combing through several years' worth of past select board agendas to identify when those non-public sessions that had been scheduled may have occurred. I then requested those minutes of the scheduled non-public sessions, and when I was told that certain minutes were sealed, I asked that they be reviewed for possible unsealing. I was told by administrative staff, not the members of the public body, that there was at that point no reason for the remaining ones to be unsealed. At the time, my request was not escalated to the board level for a review process. After some back and forth, I understand that they now have a review process mapped out. But to my knowledge, it has yet to take effect and applies primarily only to the prior year's worth of minutes, and I have not confirmed all the details of that just yet. I do not know what will happen when I begin asking for some of the older materials as background to one of the 2 or 3 key issues that I like to follow in my community. This bill does not create an undue burden on a public body. It provides considerable leeway by letting them determine what their own process is. It sets a minimum threshold of time for reviewing and confirming the status of the sealed minutes moving forward. And it gives an exceptionally long period of time for retroactive review of the historical record before making it mandatory to release unreviewed materials. If the public body is concerned about information getting out that might be sensitive, it now has an entire decade to decide how it wants to manage that. And I know that Representative Yokela provided one sort of quicker way to try to deal with some of the issues. I think part of the challenge will be that, and the advantage to it will be that the communities will have to account for what minutes they currently have sealed that are not available to the public. And they now have 10 years to figure that out. The bill also does not create a new requirement. Under 91A3, public bodies should routinely be reviewing their minutes for information that may be opened up to the public. It simply hasn't been happening because 91A doesn't specify any requirements around that activity. This language essentially operationalizes an existing requirement. By doing so, it's meeting its responsibility to only withhold information for as long as necessary, and the public itself will gain access and informed insight into its own history.
Questions for this
Take
witness?
questions. Thank you.
Yes, Representative Tripp.
Thank you, Chair. Thank you for taking my question. I'm sure you heard me ask Representative Yukela if he thought that the boards follow or are even aware of the requirements of RSA 91A.
So I think that the boards do the best that they can to navigate those requirements. I think there is a tremendous need for education around what is really involved. My board was coming out of non-public and was not doing the additional step that you said about taking that vote in public. But once it was made clear that that needed to happen and that they need to provide the reason for sealing the minutes when they decide to do that, they've now started to do that. There's a huge need for education around this at the local level.
Follow-up question, please.
Yes.
Are you aware that the land use boards have to get annual training? You probably not. So
Not specifically the land use boards, but I do believe I've seen something related to other boards. Yes.
one more.
Yep.
Do you think that maybe it would be a good idea to amend the bill to put RSA 91A training annual in this bill?
Thank you for that question, Representative Tripp. I should have been thanking all of you for your questions all along too. I apologize. This is my first time testifying on behalf of the organization. Absolutely. I feel that not only should local elected officials be trained in 91A effectively, and that is a lack in my local community that I have tried to push them to remedy, but that also the administrative staff should be trained as well, because most of the time they are not. I was in court with my town, and our town executive administrator admitted that she had had no training prior to. She had been advised by legal counsel as to what to do, and actually stated that after being advised by legal counsel, and then we hired a different legal counsel, she's since learned that that was incorrect. So the accountability and being able to have people trained and understand what they need to do is tremendous.
Thank you.
Other questions for this witness? Seeing none, thank you very much. Oh, I'm sorry,
Yes, sir.
Representative Stapleton.
Thank you, Mr. Chair. Thank you for taking my question. That what you announced sounded like a rather circular administrative obfuscation. The minutes are sealed, and we see no reason to unseal them. Well, what follows from there? Can you make a request to the board or the council to put it on the agenda for review of those minutes in absence of the law? What could you do now?
Right. So So if I had chosen to pursue that particular issue, which at the time I did not, I could have brought it to the board and asked them to please put it on the agenda. You are correct. However, there were other issues involved in those minutes, and we did end up in court having some of those minutes reviewed in camera to determine whether or not they should be released. So the review process was secondary to what my initial objective was at the time.
Thank you.
Yep.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
You know, and I'm sorry, we've gone through. No, I was just going to make an announcement. We've gone through so many. Margaret Burns, have you already testified, or? And if you haven't, then we want to hear from you, please.
You feel like I've already testified, and I understand why. I'm Margaret Burns with the New Hampshire Municipal Association, and we are here in support of House Bill 321. We believe that House Bill 321 clarifies existing law. So RSA 91A3 implies that public bodies are supposed to do some sort of review of non-public session minutes to determine whether the reason they were sealed in the first place still applies. But it gives no real guidance on that or says anything further about what that means and what public bodies should do in order to be in compliance with that in RSA 91A3. So the first sentence of House Bill 321 would do something we think public bodies already should do and have the ability to do, but it would clarify that by stating that they can adopt a policy or a protocol to do this kind of review and determine if non-public session minutes should be made public or if the reason for their sealing should remain. And then the remaining sentences of this particular bill would put in place sort of a baseline or a fallback if a public body does not put in place a process so that there is some sort of standard for review and making non-public session minutes public. I do appreciate the question that was asked earlier about the last sentence of the bill, which says if the review is not done within 10 years, then those non-public session minutes will become automatically public. I suppose there could be a scenario where I think the example given was a student type situation or some other highly sensitive situation, and we would not want to penalize the subject of the minutes by making those non-public session minutes automatically available just because the public body did not do its responsibility of reviewing those non-public session minutes. That's a potentially narrow situation that could happen from passage of this bill. There was also a question earlier I just wanted to try to address about how public bodies and boards are supposed to decide whether minutes should continue to be withheld from the public. Our advice has always been that when they do a review of non-public session minutes, they need to determine whether the circumstances under which they were sealed still apply. So as referenced earlier, there are only a few specific reasons for which non-public session minutes can actually be so-called sealed. And when the public body is doing that review, if those circumstances still apply, then the non-public session minutes can remain non-public. But if the circumstances no longer apply, then there would not be a valid reason for those non-public session minutes to remain not public. And as Representative Yokella said, NHMA has been advising public bodies to adopt a process for reviewing and unsealing, or at least reviewing non-public sessions for years. And it's included in our book on the right to know law, as well as our trainings on the right to know law. So we hope that this will help clarify if passed. Thank you.
Questions? Yes, Representative Alexander.
Thank you, Mr. Chair, and thank you, Margaret, for answering Ms. Burns for answering my question. So is it my understanding that NHMA conducts annual training with their members to make sure that all local boards are up to date on what the current laws are, so that they would understand that if there was minutes in there for 10 years, they would know that they have to vote to seal them or not? And you currently keep them up to date on laws that are passed by the general court?
Yes, we conduct multiple annual trainings on the right to know law. It's our most popular subject and probably our most needed subject. And we also try to do a training shortly after the end of the legislative session, specifically on the right to know law, to make sure they know what's been passed, because sometimes there can be a very small change to the right to know law that can have a big impact on the way that they're operating. And it's very hard for local officials to keep up to date on their own with changes that happen at the legislature.
Other questions for this witness? Yes, Representative Tripp.
Thank you, Mr. Chair. Thank you for taking my question. Do you provide this training to school board members?
School boards cannot be members of NHMA. Our bylaws allow cities, towns, village districts, regional planning commissions, and counties to be members of NHMA. There is a separate association, just like us, but for schools, the New Hampshire School Boards Association, and they do provide right to know law training.
I'm surprised. Thank you.
Other questions for this witness? Seeing none, thank you very much. And may I ask, is there anyone else here who wishes to testify on HB 321? Seeing none, I will close the hearing on HB 321, and I will turn the chair over to Representative Wallace because I'm going to testify on the next bill.
Okay. And we'll now open the public hearing on House Bill 347 FN. And Representative Lynn, you've got the floor, but I will need a pink card afterwards.
Oh, yeah, of course. Yes, I will get you one for sure. Sorry about that. Thank you, Mr. Chair, members of the committee. I'm here to testify in support of HB 347, which proposes to establish a Superior Court land use review docket. This bill, there was a similar bill that was introduced last term by me. I believe it went to interim study. If I'm not mistaken, Representative Smith, I think it went to interim study, but I could be wrong on that.
It went to interim study, I believe, at your request.
Was it at my request?
Well,
I didn't think it was, but maybe something came up that I'm not remembering now. But I frankly don't remember. You may be
then
right.
I'm sure your memory is more correct. Maybe it was one of your other bills,
It
Mr. Chair.
might have been. Yeah. Yes. In fact, I think I'll talk to you about that. I think it was. But anyway, this bill would authorize the creation of a Superior Court land use docket. The jurisdiction of that docket would be all land use appeals from local land use boards. And you'll notice that in the bill, there's a specific provision that says it does not, the jurisdiction of the docket would not cover appeals from state agencies, even if they could be considered in some sense land use, even if they have some land use jurisdiction. So, for example, appeal from the Department of Environmental Services, as an example, would not be subject to the land use docket. It's limited to municipal land use agencies. It proposes that the governor and council would appoint the first justice of the Superior Court that would be assigned to that docket, who must be a person that is knowledgeable in land use and property law. And then it would give the Chief Justice of the Superior Court, if it turned out that more than one justice was needed to manage the docket, the Chief Justice of the Superior Court would have the authority to assign other Superior Court judges to the docket. The other thing I would note here, and I'm sure there may be questions about this, which I'm happy to address, is as you are I'm sure all aware, in 2019, the legislature created the Housing Appeals Board. It's important to note that that the docket of this proposed Superior Court land use docket would not be limited to housing appeals. In other words, the Housing Appeals Board is only concerned with housing development. So if there's a commercial, somebody wants to, put in a new commercial building somewhere, the Housing Appeal Board now, under current law, does not have jurisdiction over that. It just goes to the regular Superior Court appeals process. This Superior Court land use docket would cover all land use appeals, whether it was commercial development or housing development. The purpose of the docket is to consolidate all cases involving land use matters before a single judge who is somebody that's knowledgeable in that area, who would devote his or her time exclusively if necessary, but certainly substantially, to hearing these cases. And the idea would be to speed up the process to ensure sort of more consistency, which is really kind of important. As I think we all know, we have there is a housing shortage in New Hampshire, particularly a housing shortage for affordable housing. And this is designed to, one of the things that we hear a lot is that developers are discouraged because the process that currently exists, if you need to appeal through the Superior Court, the regular Superior Court docket can take a long time. And as somebody who spent 18 years as a Superior Court judge, I did a lot of these land use cases, and it's those, even though the current law says the cases are supposed to be given priority on the docket, there are a lot of statutes that say, the court shall give priority on the docket. And obviously, under the Constitution, the Superior Court handles criminal cases. Those have to get first priority. So the reality is that in the Superior Court, in the regular docket, land use cases can take a while. And I think that's the idea of this, is to try to speed things up, so to speak. And you'll note that the law specifically provides that the time limits. It sets time limits. It says that the structuring conference in these kinds of cases is to occur within 30 days. The hearing has to occur within 60 days of the time that the record is provided. And just so you understand what typically what happens is, let's say a planning board or a zoning board case before a municipality, they will develop a record of their proceedings. What kind of hearings were held, who said what are the plans that were submitted, that kind of thing. That constitutes the record. Sometimes that can involve getting a transcript of what happened, of testimony that was presented at hearings, not always, but sometimes. And if the transcript has to be prepared, that takes some time. So eventually there will be a record of what happened before the zoning or planning board, and that will be turned over to the Superior Court. This proposed statute says that the hearing has to be held within 60 days of the time the record is turned over to the Superior Court. And then a decision by the court has to be made within 60 days of the time it holds a hearing on the matter. Now there is a good cause exception, as there is in many statutes. If there's a specific reason why things can't be resolved in 60 days, the court can grant an extension for good cause shown. But if the court does it for that reason, it has to articulate. It can't just be like, good cause shown, extension. The court has to articulate what exactly is the good cause that justifies the extension. I would note that this proposal is modeled on another Superior Court sort of special docket, the Business Court docket, that this legislature passed. God, it's over 10 years ago. I mean, it's probably more like 15 years ago, where business cases were consolidated before a single Superior Court judge who was, again, in the same sort of fashion that this proposes, was initially appointed by the governor in the usual fashion. That appointment was made by Governor Lynch when the first business court judge. Some of you may know him. Rich McNamara was a very prominent lawyer in New Hampshire, was appointed as the first business court judge and served until he reached age 70 and retired. And he was, I believe, I think he was. I know Rich very well. He was an excellent judge. Shouldn't have had to retire, but he did. But he did an excellent job as the business court judge. And I think if you asked, the overwhelming majority of lawyers in the state, was the business court a success, they would say it was. He was, had a very great interest in that area, really sort of intellectual kind of guy, did just an excellent job. And so I have no reason to believe that we wouldn't have the same kind of thing happen with the land use docket. I should note that the governor is a strong supporter of this bill. Thinks it's a very worthwhile thing to do, and so I hope you'll support it. And I'm happy to answer any questions that anybody may have.
Representative Kutab.
So would this bill replace the HAB, or would the HAB still be in place?
No, that's a very good, excellent question. It would not replace the HAB, and at least not now. At least, and my inclination would be, I think this will be a really good addition to the Superior Court. And it may be that 5 years from now, or 10 years from now, if the land use docket in the Superior Court is up and running, and it's running just swimmingly like I expected it would be, it might be at that point that the legislature would say, well, wait a minute, for housing appeals, we have sort of two alternatives. You can go to the land use docket in the Superior Court, or you can go to the HAB. Why do we really need to have two alternative appeal vehicles? Let's get rid of the HAB because the Superior Court docket is working so well. And that may make perfect sense to do that. The only thing a caveat I would say on that, just so you understand, we do have, and we have had for, God, I think it's got to be close to 50 years. We have had alternative appeal mechanisms in a similar type of case. And what I'm talking about is the Board of Tax and Land Appeals. That board, which has been in existence for, as I say, about 50 years at least, maybe more, that handles appeals from property tax assessments at the local level, and also from eminent domain. If there's an eminent domain taking, you as a person who is the subject of that, you don't like your tax assessment, or you think that your property is being improperly taken by the state, you can either appeal to the Board of Tax and Land Appeals, or you can appeal to the Superior Court. They both have jurisdiction, and in either case, if you don't like the result you get from either the board or the Superior Court, you can appeal to the Supreme Court. So if this docket were passed, we would have the same kind of situation. You could go to if it was a residential development, the party aggrieved from a decision of the local land use board could go either to the HAB or to the Superior Court, and as an alternative. And I guess I would say you might, one of the things you might say is, well, isn't that really, isn't the Board of Tax and Land Appeals mechanism sort of duplicative? Does it cost more money than it should? Why do we have these two avenues of appeal? And those are all very valid questions. When I was on the Supreme Court, we asked those questions a lot. But the reality is we didn't really see that anybody was complaining about this being duplicative, or that the BTLA wasn't doing its job in these kind of cases, or that the Superior, it should be only the Superior Court or only the BTLA. They seem to work together. The parties There were not fights as far as the Supreme Court could see between litigants over, well, we should go here versus go there. It just seemed both bodies seemed to do their job. And so it might be that 5 years from now, if we pass this bill, that would be the same situation with the HAB and this, but maybe not.
Follow up.
So to make sure I'm understanding correctly, where this isn't replacing HAB, you could either use HAB or this new Superior Land Use Court. But how would it work with appeals? If you had used HAB, would you first appeal to this court, or could you go directly to the Supreme Court? How would this change that?
It
Or would
wouldn't change.
not?
No, you from either the HAB or this docket or the Superior Court Land Use Docket, you could go directly to the Supreme Court. You wouldn't have to go from the HAB to the Superior Court and then to the Supreme Court. It would be a direct appeal from either HAB or the Superior Court directly to the Supreme Court.
Representative Alexander.
Thank you. Adding off of the clerk's question, it is the applicant's option to pursue the HAB or the land use docket, depending on, it's their choice where that case goes.
Exactly. Yes.
Thank you.
Yes, it would be their choice.
Representative Tripp.
Thank you, Mr. Vice Chair. Thank you for taking my question. Just how many of these land use dockets would there be?
Oh, I think there'd be quite I can't give you a number. Maybe
More than one?
Oh, yeah, definitely more. Mr. Head is here. He may be able to, he may have those numbers. I don't. I can say that, when I was on the Superior Court in 18 years on the Superior Court, I did quite a number of land use appeals over that time in various counties where I sat. I can't put a number on it, but it was, it was a pretty substantial number of cases.
Follow up.
So there would be more than there are HABs, since there's only one HAB.
Right. Well, I don't know if the plan here would be that all of the land use appeals would be consolidated. All the land use appeals that go to the Superior Court would be consolidated in the land use docket. So one judge would be doing all of those. Now, whether there would be a need for more than one judge, I'm frankly not sure. And again, Mr. Head may have more information. I would just point this out. In the business, to the extent when I was using the business court analogy before, Judge McNamara spent a significant portion of his time doing business cases, but not all of them. He did try some criminal cases and do some other things. So, I think it probably would be sort of depend on the ebb and flow of work. There might be some times when the business court judge would have a slack and would be able to do some other Superior Court work, but I suspect that most of the time he or she would be doing the land use cases. And in fact, it could even be the case that there would, the Superior Court would have to appoint another judge to that docket, depending on how many cases there were.
Well, thank you very much.
Representative Manos.
Thank you, Mr. Vice Chair. I wanted to know, would this use existing judicial resources?
Actually, the bill provides that the governor will appoint the first the first land use docket judge under the bill. So there would be at least one new judge that would be appointed to be the land use docket judge. And then after that, from the existing Superior Court, the Chief Justice of the Superior Court could appoint additional judges if necessary. But there would be at least one new judge for the business docket.
Representative Manos.
Thank you. I also wanted to know how this would affect other cases in the Superior Court. So for example, if there's a civil case that's been pending for a long time, would this docket take precedence over other existing cases?
No, I think, in other words, I think that's the idea of having sort of a new judge appointed, would be to, so that, you know, that judge would then be doing the land use stuff. The other judges would continue to be doing their regular work. Now, I guess if the land use docket became so full that there needed to be more judges assigned, it would be up to the Chief Justice of the Superior Court to make that decision. But I assume that what would happen if something like that happened and there just weren't enough judges to do all the work, they would be back. The judicial branch would be back here asking for more judges. As for example, they are, as I understand their budget request. I'm not on finance any longer, but as I understand their budget request, they're asking for a significant number of judges for the circuit court, which I think they need. So I mean I think that would be the way that would be handled.
One more follow-up, Representative Manos.
Thank you. So this, in your view, this could potentially free up or speed up other civil cases?
Yeah, I think that's probably right, because to the extent that you have all of the land use cases consolidated before one judge, that means that, you know, they're gonna be taken off the docket of the other judges, which would give them more time to do other things.
Representative Smith.
Thank you. Representative Lynn, I'm going to save a number of questions for my good friend from the judicial branch. But I've read this bill a couple of times, and I don't see anywhere in this that you have specified that there would be an additional position added to the Superior Court. And all I see is that the governor would name a presiding judge of the Land Use Court, but I see no reason why, or no indication that he's not going to take that person from the existing roster of judges.
Well, he would have to, the governor may appoint the first presiding justice of the land use. So I'm sorry. So you're thinking that he might be, that the governor might say, I'm taking from among the.
Yes, that's what I'm thinking.
Okay.
And I say that based on past experience of what has happened when over the years additional definitions or responsibilities have come in, and that does not necessarily get reflected in an increase in the number of judges or justices. I always like to use judge for everybody except the Supremes, but I know I'm not supposed to do that.
Well, you know, I have to say, I guess I would say I would agree with you. I suppose if you read this language, that could happen. I had not anticipated that it would happen, and I don't think, but Mr. Head will correct me if I'm wrong. My impression was that the judicial branch was also thinking there would be a new judge appointed and I assume their budget request would contemplate that.
With all due respect, the government. Oh, I'm sorry. May I follow up? May I? Thank you. Only this one. With all due respect, my experience has been that the judicial branch frequently asks for additional judges, specific number. And sometimes they don't get any, and sometimes they get some. I'm not aware of any time they received anything more than they had requested. And
that's for sure.
and so I would think that, you know, if wishes were horses, we would all ride. I think that there has to be something saying very specifically that the expectation is that there would be an additional judge, and I hope you agree with that.
Well, as I say, I had not, I had just sort of assumed that that's what would be, that that's what was intended and that the judicial branch was going to be requesting an additional Superior Court judge for that purpose.
You didn't serve
but
on
I'm-
finance long enough. That's your problem.
But I, and that may be right. But at any rate, I mean, if that needed to be put in there specifically, I would certainly be willing to file an amendment to do that.
Yes, and if I might direct you to the fiscal note, it does say that there will be an additional justice appointed. And Representative Perez.
Thank you. That's what I was going to say. It specifically says that in the fiscal note.
Thank you. Any other questions for Representative Lynn?
Thank you very
Seeing
much.
none, your excuse. We now call Representative Ben Ming.
Okay. Chairman Lynn, Vice Chair Wallace, and Judiciary Committee members. For the record, my name is Ben Ming. I'm a state representative from Hollis. I thank you for your time in listening to my support for HB 347, which seeks to establish a Superior Court Land Use Docket. I'm a lawyer, and my practice over the last 10+ years has touched on nearly all matters relating to real estate, buying and selling, residential and commercial, landlord-tenant, and most relevant to this bill, litigation and land use and zoning. It is my opinion that courts need efficient systems, and HB 347 will push them in the right direction. In New Hampshire, the probate process gives a taste of this type of efficiency. Probate is the legal process of determining, among other things, if a deceased person's will is valid. Probate files are e-filed and centralized to the state. In contrast, the probate process in other states goes through individual county offices and operates with the use of paper documents. Which begs the question, why should this level of efficiency be extended to the Superior Court? The short answer is limited resources. One of the many things young lawyers are told in law school and in practice is, be cautious with what you tell clients you know, but don't let lack of experience be a deterrent for pursuing the knowledge required to help. I highlight this to say that judges are largely owed the deference they receive from lawyers and the public in general. However, they are not superhumans. The law is vast, and few, if any, can have a masterful grasp of every single nuance in practice with limited time. The Superior Court is a trial court, and having a strong grasp of law is important, but equally important is the establishment of the facts of the case. Again, time is limited to establish facts and review applicable law. We can't create more time, but what we can do is identify and establish the fact that land use and zoning is highly consequential in New Hampshire. Out of 234 municipalities in New Hampshire, only 17 have no zoning code. Zoning is opt-in. In other words, the RSA that gave life to zoning in New Hampshire requires formal steps to establish zoning in any municipality. Each community must agree to it. Zoning codes shape municipalities in the way each community sees fit, and the people of New Hampshire have historically and overwhelmingly said yes to zoning. It is local control. Because we have that type of local control, we also have over 200 unique zoning codes in the state, many of them over 100 pages long. It isn't fair to the judge, their staff, or either party in a litigated land use matter to bring a hyper-local issue to a courtroom that may require a significant amount of additional time just to understand all the specifics that make a certain zoning code in question unique. This is a step toward a more efficient court system, and I request that you support the passage of House Bill 347. Take any questions.
Are there any questions for Representative Ming? Seeing none, we thank you for your
I will
testimony.
actually add one comment. I point you to Roman numeral 2. It talks about the person's knowledge and experience in land use and real property law. And I think rightly land use is highlighted. And typically I would put land use under the umbrella of real property law. And when I hear real property law, I think a practitioner, which means if you take out land use, it's transactional, it's contracts. And I believe Representative Lynn, Chair Lynn, said that a knowledge of property law in general is what is the type of judge that would be appropriate for this position. So I just want to highlight if there's a way of saying that land use is truly the should be the deciding factor. And I would also suggest, with Chairman Lynn's blessing, that the Chief Justice also follow in the appointment of additional judges, that they should review knowledge and experience in land use.
So noted.
All right, thank you.
No further questions. We now call Attorney Head from the Judicial Branch.
Good afternoon, Mr. Chairman, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. I think I will make Representative Smith happy in that I will affirmatively say we not only support this bill, we ask that it be voted out of committee, ought to pass. We did include it within the budget for the Judicial Branch, and it is an important position. It's an important issue that the state faces, and would provide a significant benefit, I think, to the judicial branch and to the state. I will just note a couple things in terms of Representative Lynn's testimony. He kept talking about the business court in the past tense. It is still and continues to be incredibly successful under Judge Anderson, and continues with that same success. When asked, the judges in our Superior Court described these types of cases as complex. It is an area of the law that is detailed. It involves attorneys who are experts and have a great deal of knowledge. It involves experts. We have all of these cases involve a very technical area of law and fact. And we get engineers, we have wetland scientists, we have hydrogeologists, we have just a wide surveyors, a wide range of experts who tend to be involved in these types of cases. And they require a great deal of time to get up to speed. And one of the things the judges commented on was, if we only see these as part of our regular docket and mixed in and occasionally, it is just a greater lift to get up to speed again and to refamiliarize yourself not only with the case itself, but with the technical aspects of it and the law, which is also, as you heard, very complicated, long, and detailed. So to be able to consolidate these types of cases, the complexity of these cases, into a single docket would just have inherent benefits associated with doing so. You have the very aggressive timeframes that are laid out in the statute. We agree that those are appropriate, and those timeframes can be met under the circumstances of having a specific judge assigned to the docket. One of the things, and I do think in response to Representative Smith's question, there actually does need to be an amendment. RSA perhaps not only just to clarify that the initial appointment would be a new judge, as described in the bill, but RSA 491:1 currently has a limit on the number of Superior Court judges. It is currently 22, and that would need to be increased to 23. So RSA 491:1 would need amendment. I'm happy to provide the chair with a proposed language for that amendment. But I do think Representative Smith's point is well taken, and an additional amendment would be necessary in order for that additional judge to be able to come into the system. In closing, what I would say is that these files are very large, they're very dense, they're very complicated, they're very technical, and to be able to have a judge who is dedicated to this area and to be constantly involved in this area is a substantial benefit to the parties, to the state, and to the judicial branch, and to our ability to resolve these cases quickly. I mean, whether it be a housing issue or whether it be a commercial issue, time and delay is money, and it costs money, and it causes additional issues. The goal is to get these resolved quickly. In response to one of the questions, one of the things we've observed, their range in terms of the number of cases, it's not our highest docket. They tend to be in the 60s to 100. It depends on sort of what is happening in the market and what is happening in terms of development. We have not seen any changes in our numbers that we would associate with the creation of the housing appellate, the Housing Appeals Board. So that has actually, interestingly enough, not changed our numbers in a way that we've observed. So it may mean that folks who are looking for that process are filing an appeal where they weren't before, but the same number of folks appear to still be filing in the Superior Court. One other thing I would just, well, I guess with that, I would end my comments, but be happy to answer any questions.
Representative Smith.
Thank you very much, Mr. Chairman, and congratulations. I am thrilled at the strength with which you've endorsed this bill. I also want to congratulate you on the accuracy of the language in the fiscal note, because it says that your judicial branch assumes an additional judge. It does not say that there will be an additional judge.
And I wrote that fiscal note because of that exact reason.
And I thank you for that. And I also congratulate you on the fact that the chairman of Division 1 is a co-sponsor of this bill, and Division 1 in Finance, and therefore understands the importance of that bill. So all that is very good.
I'm afraid with all those positive things what this next question is. But
Well, but first I have to get permission to ask the next. I have permission. Could you tell me, do you have a full 23 judges?
we have 22.
I mean 22.
And
I
that
did.
includes the Chief Justice of the Superior Court. So she also has the administrative duties associated with that.
And how current, and this is part of the same current, how current is your caseload evaluation for the court, and where does it stand in terms of the length of time for all those other cases that don't necessarily deal with property but might deal with more human kinds of questions?
So thank you for the question. If I understand if I'm not answering the question, I apologize. We have very recently, in last year, completed what's called a weighted case study. And that weighted case study did a very detailed evaluation of all of the cases, both Superior Court and Circuit Court, and evaluated the time needed per case and the number of resources we currently have available. And as Representative Lynn suggested in our budget recognizes what that weighted case study found, which is in the Circuit Court, we are substantially down in terms of judges and staff. In the Superior Court, which is what we're talking about today, the number of judges that we are deficient is about 3.5. Our budget only asks for 1. It would be tied to this bill, which wouldn't have to be tied to this bill if this bill were not to pass, but the goal would be that the new judge would take on this land use docket that does have a ripple effect through the system of not having the other judges handling these types of cases, which tend to be time consuming and detailed. So at least the other judges would not be doing this docket. But overall, the weighted case study showed that we were deficient in terms of the number of judges, number of staff in both, and by about 3.5 in the Superior Court.
Just an elaboration on that one. So you're short 3.5 judges. You've decided that you would like to get one judge, leaving you still 2.5 short, and that one judge would focus on these cases. Could you give the committee, particularly the new members of the committee, some idea of the cases that therefore will not be handled in the timely way that you would like them to be handled?
I apologize. I may have misunderstood. That would not be handled in a timely way?
Yes, because you're short 2.5 judges.
I'm sorry. I get what you're saying. So we would have an overall improvement in the system. I think and the Chief Justice would speak to this in his comments when he's presenting the budget, so I don't want to speak for him. So how he balanced that out to be one judge instead of 3.5 versus, the same analysis that he had to do with the circuit court and come up with a number. I would leave that to the Chief Justice in his presentation on the budget as to how he made that balance. And I don't want to speak for him.
Perfectly legitimate response. Thank you.
Thank you.
Representative Horgan.
Thank you very much, Mr. Chair. Thank you much, Attorney Head. So the effective date for this bill is January 1st, 2024. It'll take a while to recruit the candidates and convince the governor to appoint one of them and to get them past the executive council and all the other steps. So, will that process be able to begin in the second half of calendar year 2023 after we pass this bill, or does that have to wait until January 1st, 2024 before we can get that whole process rolling, which could take months?
So thank you for the question. I think the docket would not be created until the judge came on board and was appointed and had begun the position, and that new judge would initiate the docket. Whether that occurs before or after January 1, whatever that date is, that's when we would initiate the creation of the land use docket.
If I understood, you can start trying to get the individual in place as soon as either this bill passes or, as I suspect might happen, it ends up as part of the budget. And
it would begin as soon as the budget was passed, and the nomination process then would take over. That's correct. There wouldn't be in the budget the same delay of January 1 before the judge could be nominated and appointed.
Representative Kutab.
Thank you for taking my question. I see in RSA 491.1 that it currently remarks 21 associate judges. You had just mentioned that we currently have 22 and would need 23. I just want to make sure that I'm hearing that correctly. Was there one that came from somewhere else?
I may have, and either my memory is off or it may say 21 associate and one chief.
It does say a chief and 21 associates.
That's where I'm getting the 22. So I'm adding Judge Netto in my 22. So I may have, the language would say a chief and then probably 22.
Okay,
Correct.
perfect. Thank you.
Any other questions for Attorney Head? Go right. Yes.
So how many cases in a day's time of the land of this would be usually heard in one day on the docket? How many cases?
You mean in terms of trial time?
Yeah.
I don't know the answer to that. I do know the vast majority of these have evidentiary hearings as opposed to just simply on paper and argument. Evidentiary hearings take longer, but so I don't know whether or not they tend to extend beyond one day or they're typically done within one day. I don't know the answer to that.
Can I follow up? Okay. So by having an extra Superior Court judge, it will help to free up the time that other cases would be heard, to have him just focus in on this.
So I think the new judge would hear all of the land use appeals. So all of them would get consolidated there. That naturally has the effect of taking that off somebody else's docket where it would normally be assigned. And every judge in the Superior Court system has just a very large caseload. So they would have whatever time would have been allocated to a land use docket case would now be allocated to a civil case, a criminal case, some other case that exists on their docket.
Can I ask one other question? How many judges do you have working in one day?
All of them.
All of
So
them.
yes,
So all
everybody
of
is
them.
working throughout the system at
Okay.
all times. One thing I would just point out, the judge's time is not simply trial time. There are hearings, pleadings, a great deal of, one of the aspects of what makes these very complex is a very, a significant record comes, as Representative Lynn said, you get the record from below. Those can be, especially in a very complicated commercial case, very thick. And it is the duty of the judge to become very familiar with the facts and details of those cases. So it is not just the time the judge spends in the court that is that consumes their time in these types of cases.
Right. Thank you.
Any other questions? Seeing none?
Thank you,
for your
Mr.
time.
Chairman.
Greg Moore.
Thank you, Mr. Chair. Thank you, Mr. Vice Chair. And thank you, members of the committee. For the record, my name's Greg Moore. I'm the State Director with Americans for Prosperity here in New Hampshire. And I realize that I'm probably the last witness in the last bill when all of you are trying to get home and beat the storm. So, oh, wait. Oh, it's good. So there are other people. Okay, so I can blame them. For the record, again, Greg Moore, State Director of Americans for Prosperity, here to testify in support of House Bill 347. We view this as a critical step for promoting economic growth in New Hampshire. Having the chance to go and talk to a number of business leaders, business owners, community leaders, one of the biggest problems that's facing the state of New Hampshire right now is just the issue of development writ large. Now, obviously, the housing component gets the lion's share of the headlines, but there is a real problem in terms of development in the commercial and industrial space as well. And I know this legislature has taken action on the issue of housing, starting with the passage of the Housing Appeals Board in 2019, as well as the House's creation of a special committee on housing, which indicates the level of seriousness and focus which the legislature has placed on this issue. But I would suggest to you that building more housing without supporting that with commercial and industrial property as well is going to be a problem long term. So having the ability to have quick access to judgment for these people in commercial and industrial, as well as those folks who are seeking the housing route and want to go down to actually sit in front of a judge, have the day in front of a judge as opposed to the Housing Appeals Board. I think this creates a great opportunity. Relative to the dynamic with the Housing Appeals Board, I want to point out that I had a chance to talk to the leadership of both the New Hampshire Home Builders Association as well as the Associated Builders and Contractors, and they are fully in support of this legislation. They suggested that they signed in. I haven't checked, so I apologize for not doing my homework, but the home builders and the Associated Builders and Contractors are in support of this legislation. The problem with the current system is in terms of land use, and I had an opportunity to talk with the Chief Justice, and he says the problem is that in land use cases, they go right to the bottom of the docket. Coupling that with the fact that they are very complicated, very dense cases, as we've heard before, leads to very long delays to getting results. I've heard that from several people that if you want to bring a case in Superior Court, you're lucky to get into trial in a year and a half. And you probably won't get a full result for about 3 years. Now, the problem if you're a developer is that if you have to wait 3 years between the time when there's been a potential violation of the statutes by a zoning and planning board and to get justice, your financing can't hold together for 3 years.
Correct.
So it is essentially a sort of a veto power over your ability to build. This speeds up the process, which could potentially be as fast as 5 months if there's not too much of a record sent into Superior Court. Moreover, by having one judge handling all the cases, you'll get a level of consistency of rulings across the board. So if there's one judge, right now there are potentially 22 judges who might have 22 particular versions of how they view the statute. By having it all run through one judge, you're going to get a level of consistency, and that level of consistency is going to actually be a great benefit to the zoning and planning boards across the state because everyone will know and understand what the rules are. As I know this committee has debated in years past, I know Representative Alexander, who's not here, filed legislation 2 years ago to have mandatory training for zoning and planning boards. That legislation did not pass, but there's a sense of unevenness. And that unevenness can lead to results that might fall outside of the statutory authority of the zoning and planning boards. And if that happens, and the recourse is to wait 3 years before you get a result on that potential violation, that's from our perspective, that's not really what we would describe as justice, because if your financing can't hold together for that period of time, you're not likely to be able to move forward. I would also just like to say that I'll give you an example of what I'm talking about, because I think it's great to talk about this in the theoretical, but just in terms of how this works in the practical sense. And I'll use my hometown, because if you're going to pick on somebody's town, you should pick on your own. I live in the town of Bedford. A local brewery was looking to do an expansion in the town of Bedford. They were looking to do it in the performance zone, which is the area designated by the town to be the area for development and in order to enhance the town's overall tax base. They went before the planning board. The planning board said that they were going to have to require them to put 2 feet of fill in the back part of the property. By the way, that's the part of the property that would not be where they would actually be putting a building, and it would add up to a cost of $2 million before they could even break the ground to build a foundation. So adding $2 million to the cost of the project. At this point, and I should add that the attorney for the brewery said that there's no statutory support for requiring that. Now, instead of building it, what happened is that the brewery just decided to scrap the plans, as opposed to trying to go to court and have that ruling overturned. That results obviously in a situation where somebody was out over $100,000 in design and legal fees to bring this to the board, and that whole plan was scrapped, and they lost all that money, despite the fact that, at least in the opinion of the attorney for the brewery, that the request of the planning board was not something that was supported under statute. They exceeded their statutory authority. So I just want to put a real world sort of example as to what that looks like. And that's a project that didn't get done simply because of the ruling by that board. So with that, and again, I know I want to be quick here because you all want to get out of here. Happy to take any questions.
Representative Smith.
Naturally. Mr. Moore, it's good to see you, and I think we all agree that justice delayed is justice denied. Assuming that this bill passes, and there's every reason to believe it will, and it comes into law, can you give us guidance as to what civil and criminal cases you think could now, in effect, go to the bottom of the list of pending cases, and making clear that we will benefit from the increased speed in the cases that go here to the land use review, understanding that the other cases with a long backlog and a shortage of 2.5 judges, what areas do you think it's justifiable to now have those cases take more time?
Thank you for the question, Representative.
You don't really mean that, do you?
I do. I do. I've had a lot of chance to answer questions for you through the years. As you know, I worked for a state agency once, and it's always fun when they tell you to paint the barn and only give you 1 gallon of paint. But to the question at hand, if this is adding a judge and you're taking work off the plate of the existing Superior Court judges, then I think it's going to benefit the speed with which those other cases are able to move through the courts. I think that that's helpful. There's a secondary question, I think, embedded in there of whether adding 1 more Supreme Court justice is the right answer. The folks down the hall are the ones who have to grapple with that. And but to your point, I don't think that the other dockets will be slowed down. I don't think the other cases will be. In fact, I think they'll be sped up, because all these land use cases will be taken off of the other 22 Superior Court justices. But I do agree with your point about, and to Attorney Head's point about making sure you change that other statute to make abundantly clear the intent of this committee to add another Superior Court justice.
Representative Kutab.
Thank you for taking my question, Mr. Moore. I apologize. I misunderstood a little bit. What was the $2 million thing that Bedford wanted the brewery to put in?
So this was on River Road, which is part of the performance zone in Bedford, and it's a piece of property that abuts against the Everett Turnpike, and there's a front developable part that abuts that sits on River Road, which is Route 3, and behind it there's sort of a gully that goes underneath to Everett Turnpike. Now the property extends all the way to the Turnpike, and so they demanded that if they wanted to go forward with the project, that they had to fill all that, and now fill it entirely, and none of that area was the area that the brewery was looking at using. They were looking at using the footprint closer towards the highway, if that's helpful.
Any other questions? Seeing none, we thank you.
Thank you.
And we now call Missa Margonkin. Did I get that right? Well, I tried. Mrs., right?
Hi, good afternoon, Mr. Vice Chairman, Mr. Chairman, members of the committee. My name is Alyssa Margolin. I serve as Director of Housing Action New Hampshire. We're a statewide affordable housing coalition. Thank you for hearing my testimony. Our broad coalition does not have a formal position on this proposal, House Bill 347, but we would respectfully ask this committee to consider amending the bill to make clear that this proposal would not in any way supplant the Housing Appeals Board. In this letter that is coming around to you, I've provided some draft language for your consideration. As you know, and as Chairman Lynn pointed out in his testimony, many parties seeking review of municipal decisions, whether that be at the Bureau of Tax and Land Appeals that's been in existence since the 1970s.
Sorry about that.
It's all right. Or the Housing Appeals Board since 2020 are benefiting now from timely, fair, inexpensive, and accessible access. The benefiting parties in the case of housing are not only abutters, but they're taxpayers, property owners, and developers. And we're starting to hear that municipalities are seeing the benefit of speedy review as well. So we feel like there's been a lot of progress, a lot of needed education in terms of what the Housing Appeals Board does and what it does not. It certainly has a busy docket. We don't doubt that the Superior Court has one as well. So would ask that you consider amending this to make that clear and to protect the work of the Housing Appeals Board. Thank you, and I'm happy to take any questions.
Any questions? Seeing none, thank you.
Thank you.
And we now call Chris Norwood, New Hampshire Realtors.
He had to leave. They're in full support. They'll send their comments to the committee in writing.
Thank you. And with that, anybody else wish to speak on House Bill 347 FN? Seeing none, we'll close that hearing.
You know, just this is really just for the committee. As you probably have seen, we've scheduled hearings for 2 days next week, Wednesday and Thursday. The speaker had suggested that possibly next Thursday we could have a full house session. If we do, obviously we're going to have to cancel the hearings for Thursday. But it seemed like it was unlikely that it was going to happen, so that's why I scheduled for 2 days. So we'll have hearings next Wednesday and Thursday, and then my plan, my inclination, and I'm going to talk further with Representative Smith about this, but my inclination is that the following week we will have an executive session at least on Wednesday of that week, which would be February 1st. Right now, it seemed pretty likely as of the day before yesterday that there would be a full house session on February 2nd, but based on your comment, it may be that there's not enough bills to make that ready for action that would make that worthwhile. So if we don't have a full house session on all right. So that takes care of that. So we'll have an executive session on February 1st. And I guess I want to think about this a little bit, but I'm thinking that maybe we will also have an executive session on February 3rd. But I need to think about that, and I also need to make sure we have a place to have it. So anyway, you can count on February 1st and you know, possibly February 3rd, but I need to get a little more information as to whether we have a place to have it, and I also want to speak with Representative Smith about that. All right. Sure. Oh,
You mean
sure.
that third?
About the 3rd, yeah. I'll try to have an answer to you about that certainly by Monday, by next Monday, this coming Monday. Yes, Representative Horgan.
This doesn't affect our committee directly, but I did get a text, which at least probably Representative Kenny also got, to the UNH Law School, which is located just a couple blocks away, is curtailing operations tomorrow. Do you have any indication if the State House is going to have its full schedule meetings tomorrow? Or?
You know, I have a meeting, the gel car is meeting tomorrow, and I got an email sometime, I saw it first thing this morning saying, you know, are you still planning to come to gel car? I said, yeah, as far as I know, but you know, it's only, this is New Hampshire and it snows. That's kind of the way I look at it.
It's, yeah.
If in fact officially things are going to be canceled, there will be a notice that comes out, and obviously no one's expected to put their lives in jeopardy by driving in unsafe conditions.
And the snow is long overdue too, so like, yeah.
All right. Well, thank you, everyone. I think this. Well, and we'll see you. Whoops, excuse me. We'll see you next week. Yeah. Yeah. Yeah, you know what? You'll see that many of the bills for next week are landlord-tenant related.